adjournments. Page wise, page 1, seal number 1 to 4. Page 2, seal number 5 to 9. Page 3, seal number 10 to 18.
12 and 1 week. 12.
Office subsection along with office seat. What are the office subsection? Criminal afflictions. Here for the appellant.
Appellant. Criminal appellant.
Net request 10 days time is granted to do it. Yes. Page 4, seal number 19 to 22. Page 20. For condonation of delay, why do you want time in this? This is filed in 2023. Office has not raised any such objection. It's only for recalling. Wait, just we'll see. You have informed, or you will inform. Madam, this is a matter of 2018. Just for recalling that to family court matter. Why it should be again adjourned? Just you can go through the file. See, if you are not received the copy, we'll ask the other side to furnish you the copy. Pass. Page 5, seal number 23 to 28.
7 minutes. Pay for 1 minute.
Suspension.
I am not fully prepared.
You have no urgency for suspension?
Not fully prepared, my lord.
Okay.
Next week,
Agenda
madam, I will
request
do
of
it.
the appellant's counsel. Yes.
Please.
Page 6, seal number 29 to 34. Page 7, seal number 35 to 39.
It's serial number 35. Your Lordship.
35.
Lords, I appear for response.
1 second. Just you wait, madam.
Please.
I appear for the appellate, serial number 35. I only pray for a week time, Lord.
Previous adjournment case. Yes, she is representing in the same serial number
Please, my
35.
lords. Please, my lords, I am for respondent number 1, my lords. I was also seeking for the short accommodation. my lords.
Adjourn at the request of as adjourn at the request of both sides. Yes.
39, my lord. 39. Serial number 39. I undertake to file a wakalat for respondent number 2. Respondent number 2 is last.
R3.
R3 madi.
NBW is now issued. Let us see what has happened to the NBW. We'll examine what has happened to the NBW.
Notice has been issued to this respondent number 2, my lord. Last citation.
Correct.
Please.
NBW issued against R2 and 4 through Commissioner of Police.
R-
We'll see
R2.
what has happened. Correct. We'll see what has happened in the to the NBW. Yes. Next question.
I have to file wakalat for R2, my lord.
All right. Now NBW is issued. We have to see what has happened to that.
Wait, my lord. Wait.
Page and when NBW is issued, party should be present before the court. Only for filing the wakalat, we cannot for grant adjournment. Yes.
Please.
Yes. Page 8, seal number 40 to 45.
Number 41, madam. I am
Yes.
for respondent in the case, madam.
Not
Who
ready?
is me?
Not ready.
Yes, ma'am.
Adjourn at the request of the response counsel. Yes, page 9, seal number 46 to 49, 48, 45.
45. Pray for a week time. I'm appearing for the respondent.
First case, Shankrappa,
Respond for us, respondent.
Maltish.
Yes,
This is the conviction or
acquittal.
why there are two appeals?
Two.
One is
So filed, my lord, the complainant.
Complainant
Victim has
has
also
filed.
filed.
adjourned at the request of counsel for respondent number 2 to 8. Yes.
Yes.
Page 9, seal number 46 to 48. Page 10, seal number 49. Page 11, seal number 50 to 54. Page 12.
54.2.
Hmm.
That we have filed the appeal, my lord, as the complainant has filed the appeal. State and accused also has filed the appeal. In our appeal 54.2, this, they had to execute the police had to execute the warrant.
Available warrant.
Yes, we have executed the bailable warrant, not reports.
Let them submit the report, we'll see. Available. Whether anybody has appeared after issuing available warrant, sole respondent.
No, the respondent, first respondent has been served, he has preferred an appeal.
No,
Another respondent is dead, but now one other accused has to be served,
no, this is appeal by the complainant or,
complainant.
so one accused is served as he is unrepresented, respond number one,
He is the one who's preferred 54.1.
54.1. Okay. Tejas N, he is
That is
represented
the
by
council
counsel.
says in, they preferred an appeal.
Now warrant is executed. We'll see whether he files wakalat or again if it is executed and he fails to appear, we have to order for execution of that, recovery of that amount.
Very well.
Page 12, cell number 55 to 60. Page 13, cell number 61. Frauders, cell number 1. SV Prakash. ಇವೆಲ್ಲ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಬರ್ಬೇಕಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ನಲ್ಲಿ ಯಾಕೆ ಬಂದಿದೆ ಅವೆಲ್ಲ NPW they should come in the orders matter. ಈಗ ಇಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಬೇಕು. Yes.
My lord, I appear for appellant. My lord, the whole appellant died. My lord, we have entered appearance through NOC wakalat, my lord. My lord, kindly grant 2 weeks time, my lord, I will comply all the office objection raised on A number,
LR applications.
LR application.
What is the office objection? Copy to be served. Non-compliance of office objection. Non-filing of necessary application as per the order dated 10/12/2018. Learned government advocate to accept notice. Appellant is permitted to make beneficiaries as party to the appeal. All this. It's 10/12/2018, such a long time back it was, order was passed. Beneficiaries in party. LIC. Beneficiary ಅಂದ್ರೆ ಘೋಷರಾಯಿ as claimant. Yes, you have not included them. Who is the beneficiary of the
And
acquisition?
now, my lord, I have entered appearance through NOC wakalat, my lord. My lord, I go through the order, my lord, and I will comply all office objections. my lord.
Delays days to be mentioned, other side copy to be served. HC if it copy serve ಮಾಡಿಲ್ವಾ?
ಹೌದು,
Yes,
ಹಾಗೆ.
show that copy to me.
Yeah,
ಹಾಗೆ.
received.
Yes.
Learned, ACA submits that, I'm sorry, copies of I number 1 to 3 of 2023 are served on this. Therefore, office objections in that regard should comply. Innೊಂದು delays days, number of days delay ಅದು
ಅದ-
mention.
I will comply, my lord. Kindly grant 2 weeks time, my lord.
2023 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
23.
LR application, setting aside abatement. No. 2013 will pass peremptory order. If you fail to do within 2 weeks, then these applications. At request finally, 2 weeks time is granted to do the needful, failing which IA 1 to 3 of 2023 shall stand dismissed. Yes,
Oblige.
we'll serve after 2 weeks. Cell number 2, KB Loknath. KB Loknath. Respondent his daughter. So he died as a last son. He was the first claimant. He died. He is LR's preferred the appeal. She has not committed since. Accepting it. In the level. Note regarding.
note of the appearance council regarding respond number 3 in the cost rate of the appeal memo is accepted. In 2016, LR application allow ಆಗಿದೆ. Yeah, it has been. Records ಇದೆ. Recall ಆಗಿದೆ dismiss. Appeal is restored to the file on dismiss ಆಗಿತ್ತು ಅಂತ ಕಾಣಿಸ್ತಾರೆ. ಇದು records ಇದೆ.
Copy ಕೊಟ್ಟಿಲ್ಲ. He has not served that copy to me.
ಬಂದಿಲ್ಲ ಇದನ್ನು. Copies are not served.
Not served.
Learned AG submits that the copies of IA number. The copies IA allow ಆಗಿದೆ ಎಲ್ಲಾರ applications ಇತ್ತು. The copies are not, but 2016 ಇಂದ pending ಇದೆಲ್ಲ ಇನ್ನೂವರೆಗೂ copies are ಮಾಡಿ.
ಕೊಟ್ಟೇ ಇಲ್ಲ.
But office has not raised such objection. ನೋಡಿ ಅವ್ರ ಹತ್ರ ಬೇಕಾದ್ರೆ ಕೇಳಿ ಇಸ್ಕೊಳ್ಳಿ. Who is the advocate? Lokanath.
ಲೋಕನಾಥ್.
Whether he appears here regularly? He'll appear ಆಗ್ತಾರ?
ಅಪೇರ್ ಆಗ್ತಾರೆ.
ಹಾಗಾದ್ರೆ because office has not raised any objection. It's long back. It was dismissed once for non-prosecution and recalled. Again, they do not appear. HCGP is directed to take notice for R1 and R2 on the memo of appearance not filed. Learned AGS admits that copies are not served only. No representation for the appearance. Finally, 2 weeks. Interested ಇರೋದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. Once already it was dismissed. Finally, they will dismiss for the Finally, any of you are aware ಯಾರು ಇವ್ರು ಲೋಕನಾಥ್ ಅಂದ್ರೆ appear ಆಗ್ತಾರಾ ಇಲ್ಲಿ? Finally, 10 days time is granted to serve the copies. I'm sorry, ಅದೆಲ್ಲ ಬರ್ಕೊಂಡು. It is noticed that this appeal was already once dismissed for non-prosecution and an application the same was restored. Under the circumstances, finally, 10 days time is granted to serve the copies, failing which appeal shall stand dismissed.
Seal number 3, SPP.
I appear for the accused, my lord. I was appointed as amicus curiae in this matter, but subsequently the court has issued an NBW to the accused, my lord.
My lord, a report has been received by the office, my lord. This is the report, my lord. They have filed it in the. My lord, accordingly, my lord,
He is not traced and
he was not able to trace, but ಇವಾಗ UP ನಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ they have got the information, my lord, and they have sent the police to verify, my lord, and to secure his presence, my lord.
Dubaratana, Baliatalu.
It is in the third pair of second page, my lord. ದಿನಾಂಕ 24/5/2024 ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಸ್ವೀಕರಿಸಿದ್ದು ಕೂಡಲೇ ಪರಿಶೀಲಿಸಲಾಗಿ ಆರೋಪಿಯು ಬೆಂಗಳೂರು ನಗರ ವಿಳಾಸದಲ್ಲಿ ಇರುವುದಿಲ್ಲವೆಂದು ಶ್ರೀ ಮೀಬಾ ಶಂಕರ ಗುಮ್ಮತೆ ಸೋನ್ಸೋರ್ ಅವರು ವರದಿ ನೀಡಿದ್ದು ಅದರಂತೆ ಆರೋಪಿಯ
2024 they have gone.
Yes, my lord. Yes, my lord.
Today is
28th, my lord.
So
We need
warrant
some.
is also not returned.
Yeah, not returned, my lord. We need some more time, my lord.
Kannada HCP ಇಲ್ಲೇ put up ಆಗಿರಲ್ಲ. Registry has put up the report of the concerned police, which indicates that the police have gone to UP to secure the accused, respondent, secure the respondent accused. Okay. CP seeks time to submit the final report. List on how many days? 10 days?
Yes, my lord, please.
Wait, after 10 days.
13th.
Macho.
13/6. Seal number 4. Seal number 4, SPP.
My lord, in this case, my lord, report is with me, my lord. I'm filing the report.
Whether it is executed or it's not.
It is not executed, my lord. They had gone to Orissa, my lord, which is his native place. And there also, my lord, only his wife and the parents of the accused were found. And they've also got the information that, my lord, 6 months back he had called them. So on the basis of CDR, my lord, they are trying to trace him, my lord. Another 15 days, 1 month time may be granted to trace him, my lord.
So you have returned the warrants. and
Yes, my lord.
Reissue. of-
Yes, my lord.
Submit
That is, huh?
on with the argument next week, if it is, date is fixed, the paper book is ready.
Huh. Correct, at least you have to file application. Why did you did not?
Warrant. So that date I was, not as last vacation.
Hmm.
Date
Correct.
date was given, was held up in other court, your worship. By then the warrant was issued. Namgu contact illa actually.
You file a formal application to recall that
Recall.
order, otherwise you have to reissue.
Presence of accused is necessary.
Order recall ಮಾಡೋದಕ್ಕೆ ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ವಿ. Non-available warrant return ಬಂದ್ಬಿಟ್ಟಿದೆ. So if you are ready to argue, then we'll, they also say that his whereabouts are not known.
Yes, ma'am.
ಸಿಕ್ಕಿಲ್ಲ ಅವ್ರು. ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಲಿಕ್ಕೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕೌನ್ಸಿಲ್ ಕಳಿಸಿದ ಮೇಲೆ ಬಂದೇ ಇಲ್ಲ.
This is the difficulty of the criminal law practitioners. Yes,
Is the paper book is ready, your worship?
correct. We understand. At least you have to file a formal application.
Next week.
So otherwise, we have to go on with this. Submits the report of the concerned police. Stating that the warrant issued is the respondent ಒಬ್ಬರೇ ಇರೋದು ಇದರಲ್ಲಿ. RV Deshpande for R1 and R2. 376 ಇದೆ ಅಲ್ಲ?
Yes, my lord. 376 and 302.
ಅಲ್ಲ, there is no minor is not.
ಏನಿರಲ್ಲ.
No.
ಯಾವ್ದು ಸ್ಪೆಷಲ್
workers.
ಯಾವ್ದು ಸ್ಪೆಷಲ್ ಎನಾಕ್ಟ್ಮೆಂಟ್?
No, my lord.
Circumstantial evidence, ಕೂಲಿ workers. Read with 511, 376 read with 511.
Which respondent? ಇಬ್ಬರಿಗೂ ಇಶ್ಯೂ ಆಗಿದೆ. Both respondents were not traceable.
ಎಲ್ಲ they were working in a ಕೂಲಿ on a house your worship. Construction ಕೆಲಸದಲ್ಲಿ. Orissa.
Response 1 and 2 could not be executed as they were not traced. Not possible for response 1 and 2. Submits that he is ready to go on with the matter and he files necessary application to recall. The order dated ಯಾವತ್ತು issue ಆಗಿತ್ತದು? Order dated 18/4/2024. List count ಮುಂದಿನ ವಾರ.
6. To go on with the matter, my lord.
No, I did him file an application.
Please, my lord.
To recall
Oh.
the order because he is ready. Now, if you go on tracing them, it will.
Please, my lord.
6.
Cell number 5, SPP, SG Rajendra Reddy.
For the response.
My lord, I pray for 2 days' time, my lord. I'll file the amended appeal.
Non-furnishing of amended appeal. That request 10 days time is granted to the.
Council.
Rajan,
Reddy.
yes, 10 days time for compliance.
Oblige, my lord.
Cell number 6, Narendra Gowda, this is Karamla.
ಇದು ನಮಗ್ ಬರೋದಿಲ್ಲ.
I'll take steps in respect of.
This is not our roster matter. Register has wrongly listed it. ಇದು ನಮಗ್ ಬರೋದೇ ಇಲ್ಲ ಕೇಸು. List before the roster bench.
Cell number 7, Munish Kumar KB.
This matter is we already deposited this much about 2 years ago. Because by inadvertence is not that we were not able to face it. By mistake, my lords, what my authority has done is the entire amount of deposit ಮಾಡ್ಬಿಟ್ಟು reference court order ಮಾಡೋದು enhanced. Madam.
One is connected appeal is by the claimant.
Yes, my lords. Sir.
Non-filing of acknowledgement for having served the copies.
Aye.
Copies ಅವರು ಮಾಡಿದಾರ ಅವ್ರ ಕೇಸಲ್ಲಿ?
Lord, the matter was listed from yesterday to today, madam. Matter was listed from yesterday to today.
Correct.
But in the
Renewal.
By one aspect, I appear not, both the appellants are the beneficiary and the acquiring authority.
ಕರೆಕ್ಟ್, ನಿನ್ನೆ ಅದೇ ಡಿಸ್ಕಷನ್ ಆಯ್ತಲ್ಲ ಆ ಕೇಸಲ್ಲಿ. ಏನು ಕಾನ್ಫ್ಲಿಕ್ಟಿಂಗ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅದನ್ನ ಹೇಳಿದ್ವಲ್ಲ ನಿನ್ನೆ. He can appear for both of them. Color. Now copies are served ನಿಮ್ಗೆ
ಇಲ್ಲ ನಮಗೆ ಸರ್ ಮಾಡಿ.
ಅಲ್ಲ
In the course,
ನಿಮ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ ಕಾಣಿಸುತ್ತೆ.
Yesterday there was a direction my friend has.
in the course of the day, my lord, I shall serve.
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಡೆಪಾಸಿಟ್ ಇದಕ್ಕೊಂದು ಮೆಮೊ ಹಾಕ್ಬೇಕಲ್ಲ ಇವ್ರು.
I'll file it.
ಎಷ್ಟಿತ್ತು ಅಮೌಂಟ್ ದೇ ಹ್ಯಾವ್ ಡೆಪಾಸಿಟೆಡ್ ಎಷ್ಟು?
It's 2 crore 80 lakh.
ನಿಮಗ್ ಮೆಮೊ ಕೊಟ್ಟಿದಾರಾ? ಒಂದು ಕಾಪಿ ಮೆಮೊ ಒಂದು ಕಾಪಿ ಇಲ್ವಾ?
ಎರಡು ಮಾಡಬಹುದು.
ಅದಕ್ಕೂ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ.
I'm sorry, please.
ಇಟ್ ಇಸ್ ಅ ಪ್ರಿವಿಲೇಜ್ ಆಫ್ ಬೆಂಗಳೂರು
By mistake.
ಹೆಸರು
ಇಲ್ಲ ಇಲ್ಲ other copy, madam. By mistake, my office copy.
ಕೊಡ್ಲಿ.
By mistake, madam.
ಅಲ್ಲ ಕಡೆ ಇಲ್ಲ ಆಯ್ತು ನೋಡೋದು. ಅದನ್ನು ಹಾಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೆಮೊ ಇಲ್ಲ. What was the amount? They say that they have deposited.
The 2 crore minutes 80 lakhs 20,985 rupees has been
Lord,
deposited.
I've been only
As per
permitted,
LAC case number 224.
I've been permitted only to my lord, withdraw a certain amount.
Plus we have a.
Balance amount, my lord, let it be in deposit, my lord, any day for final hearing, maybe.
2 crores 80 lakhs 20,985.
Yes, my lords.
Correct ಇದೆಯಾ ಅದು?
Please.
They
Earlier
have
order of this
considered-
honorable court, my lords,
Lord, consider
25 lakhs they
the
have
appellate.
permitted, please. to withdraw.
Counsel for the appellant submits memo along with city civil court ಕೊಟ್ಟಿರೋದಾ ಇದು? ಇಲ್ಲ
It is deposited in execution proceedings,
execution ಅಲ್ಲ.
579 of 2020.
LIC execute proof of deposit of the award amount in execution number 579 of 2020 before the reference court. Reference court. Office subsections in that regard stood complied. ಇಲ್ಲಿ ಇನ್ನೂ ಎರಡೇನೋ ಇದೆ ಅಲ್ಲ office subsections ಅದಲ್ಲದೆ extent of land to be corrected as per the judgment page number 2, survey number 55 part 2. And the, if necessary, deficit court fee to be paid. ನಿನ್ನೇನು ಇತ್ತು objection.
The deficit court fee, I will make that, I will pay that, please, my lords. I have already written in the letter.
ಅದೇನೋ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಇದ್ದಾರೆ ಸಮ್ ಎರರ್ ಇನ್ ದ ಅಪೀಲ್ ಮೆಮೋ.
Lords, my submissions are up to 25 lakhs, my lords, we have conceded. We have no objection, my lords, with regard to the award being passed.
You are restricting the
Oh,
appeal.
I am
Then
restricting.
you have to make an endorsement to that effect.
I filed, my lords, the necessary memo I already filed.
ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಅದನ್ನ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲಿ
I have already made a mention of this.
ಎಲ್ಲ ಸರ್ವೆ ನಂಬರ್ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಏನು ಹೇಳಿದ್ರು ಎಲ್ಲಿ ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಆಫ್ ದ ಅಪೀಲ್ ಮೆಮೋ?
Lords, paragraph number 13.
ಪ್ಯಾರಾಗ್ರಾಫ್
13.
13.
Up to 25 lakhs, my lords, we have no issue.
ಕರೆಕ್ಟ್ ನಿಮ್ಮ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹಾಗೆ ಹೇಳ್ಬೇಕಲ್ಲ ಹಾಗಿದ್ರೆ. ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಎಲ್ಲಿದೆ?
Lords, I will make a mention in the valuation paragraph. Lords, I will file a separate memo on that.
For compliance of the other office subsections, at this 10 days time is granted. ನಿಮ್ಮದ್ರಲ್ಲಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
In the course of the day, my lord, I shall.
Lords, I have filed a memo, please, my lords, an additional memo. I have calculated it and filed it actually. It is there in the report. Subsequently, I filed it. Lords, what
Nish
happened?
Kumar, you have to make proper amendment in your appeal memo. ಅದೆಲ್ಲ ಹೇಳ್ಬೇಕಲ್ಲ. This is the claim. This is the difference. We restrict our appeal only to this ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು. ಅದೆಲ್ಲ ಹಾಕಿದ್ರೆ ಅದು ಒಂದ್ ದಿವಸ ಆ ಮೆಮೊ ಎಲ್ಲ ಒಂದ್ ಸಿ ಫೈಲ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಉಳಿದಿದ್ದೆಲ್ಲ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
I will amend it.
My lord, I shall serve copies in the course of the day.
7.1 ಅಲ್ಲ, this 10 days time is.
Still number 8, Abhilashar.
Lords, interim order to be extended, my lords, in view of the
Interim
fact
order
that
granted. First matter, interim order granted earlier is extended.
And may I request for a date to be fixed, my lord? It is already admitted by this court as early as in the year 2021, my lord.
10 days ಅಂತ.
paper book.
It has been admitted, my lord.
The trial court records have
Correct,
come.
ನೀವು ಕೊಡಿ ಅವ್ರಿಗೆ ಕಾಪಿ after 10 days it will be listed.
Paper, trial court records.
2020 matters ನಿಮ್ದು. Now we were permitted to withdraw or not?
I was being permitted to withdraw a sum of rupees 25 lakhs, which they have not disputed.
Okay.
Balance amount is still in deposit.
I were asking you is 2012 14 matters pending ಇದೆ. This was solved.
Still number 8, Abhilashar.
Wait for appellant, madam.
Lords, the trial court records may be smart.
ಬಂದಿಲ್ವಾ?
ಇಲ್ಲ, ಬಂದಿಲ್ಲ.
Admitted ಅಂತ ಇದೆ. Admit ಮಾಡಿದ್ರೆ ಜನರಲಿ ರೆಕಾರ್ಡ್ಸ್ ಕಾನ್ಫರ್ಮ್ ಮಾಡುತ್ತಾರೆ.
Admitted on 11/8/21.
2021 order sheet ನೋಡಿ. 11/8/2021. ಎರಡನೇ ಮ್ಯಾಟರ್ 2681 ಕರೆಕ್ಟ್. ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿ ಉಳಿದ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್
TCR ರಿಸೀವ್ ಆಗಿದೆ ಮ್ಯಾಮ್.
ಅಂತ ನೋಡಿ ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ ಅಷ್ಟೇನೆ ಬಂದು PCR ಸರ್ ರಿಸೀವ್
ನಂಬರ್ 8 ಅಭಿಲಾಷ್
ಅವ್ರಿಗೆ ಜನರಲಿ ಬರೀತಾರಲ್ಲ ಯಾಕೆ TCR ಕೆಪ್ತಿಲ್ಲ
Sorry.
ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ಸ್ ಆರ್ ಪಾರ್ಟ್ಲಿ ಕಂಪ್ಲೈಂಟ್. Certified copy of SC number 37.
Mediation in the mentioning of judgment statement. Page number 12 and 49.
Facing sheet of the judgment shows.
Date of judgment is of 15/9/2020. But in page number 49. Mentioned as 16.
What is the date of judgment? 15 September 2020.
2021.
Hmm.
But in page number 49. It is mentioned as 16th September 2021.
What mistake?
Also.
16/9/2021.
Instead of 15.
ಅಲ್ಲ ಏನ್
Sentence.
that is force mistake. ಅದು ಒಂದೇನಾ?
Remaining of the subjections are.
Office subsection number 2. But, since there is typographical mistake in the judgment for which the appellant is not responsible. Appellant or appellants?
Appellant.
Sole appellant.
Please.
Appellant is not responsible. Counsel submission and office subsection is accepted. Office subsection only. What is the next stage here?
One more submission. Next date 17.
Next,
Sentence is passed on 17.
correct, ಅದಲ್ಲ ಈಗೇನು ಸಸ್ಪೆನ್ಷನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ?
Also.
1830. ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ sir.
Yes, copy served on its usual. What do you say for condonation of delay? ಅದರಲ್ಲೂ ಮಿಸ್ಟೇಕ್ ಇದೆ. ನಂಬರ್ ಆಫ್ ಡೇಸೇ ಬರ್ದಿಲ್ಲ ನೀವು, ಯಾಕೆ? ವೆದರ್ ಇಟ್ ಇಸ್ ಇನ್ ಟೈಮ್ ಆರ್ ಕರೆಕ್ಟ್ ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ. What is the offense involved?
302.
498 is 302.
498A he was acquitted.
Huh.
Only he was convicted for the 302.
302.
Life imprisonment is there.
Who is respondent number 2 here?
Respondent number 2.
Gandhi son of Chaudappa. Correct. Why they are made party? Idರಲ್ಲಿ special
No special
SC, ST and why respondent number 2 is made party?
Was not made as a party.
Appeal memo ದಲ್ಲಿ ಅವರ ಹೆಸರಿದೆ.
What happened, madam? As per the order of this honorable court on 8/4.
8/4.
8/1/2024.
8/1/2020.
The matter was referred to legal service authority. Therefore, I was instructed to file wakalat on
Just a minute.
thereafter I filed wakalat.
ಕರೆಕ್ಟ್. ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಡಿಫ್ಯಾಕ್ಟೋ ಕಂಪ್ಲೇಂಟ್ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ? ಯು ಹ್ಯಾಡ್ ನಾಟ್ ಡ್ರಾಫ್ಟೆಡ್ ದ ಅಪೀಲ್ ಮೆಮೋ. ಮತ್ತೆ ಈಗ ಅದು ಅವ್ರ ಪಾರ್ಟಿ ಇದ್ರೆ ನಾವು ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋದಕ್ಕೆ ಅವ್ರು ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಅಂಡ್ ಇವನ್ ಇನ್ ದ ಅಪ್ಲಿಕೇಶನ್ ನಂಬರ್ ಆಫ್ ಡೇಸ್ ಆಫ್ ಡಿಲೇ ಇಸ್ ನಾಟ್ ಮೆನ್ಷನ್ ಅಂಡ್ ದ ಪೆಂಡೆನ್ಸ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಆಲ್ಸೋ ನಾಟ್ ಶೋನ್ ವೆದರ್ ದ ಅಪೀಲ್ ವಾಸ್ ಇನ್ ಟೈಮ್.
Application is not suspension of sentence.
ಅಲ್ಲ ಅದನ್ನ ಸ್ವಲ್ಪ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ. If application is not necessary, you don't press that application. If application is necessary, you rectify that mistake. And even so far as respondent number 2, if they are not necessary party, you file application to delete their names. I mean, file memo at least.
Grant 1 week.
As requested, list in the next one.
Seal number 9.
Name is Agar.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ವ?
ಇಲ್ಲ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿ.
ಅಭಿಲಾಷ್. ನಿಮ್ಮ ಹೆಸರು?
ಹರೀಶ್.
ಹರೀಶ್ ಅನ್ನ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ. Shri Harish Anna, since Shri Harish Anna, Law Council, council has appeared for the appellant. Please shall show his name in the cause list for the appellant accordingly. Yes.
Seal number 9, Gopal Krishnamurthy.
Kindly grant 2 weeks time will come to the office.
In water office subject,
There are 5 office objections are there. That I will complain.
representative authority to be mentioned correctly. Order determination.
Application has to be filed. Delay application. Since he was in
Conviction is for
the license was in rigorous side.
302, 109, 201, read with 34.
request. ಎಷ್ಟು ಬೇಕು 2 weeks.
Please.
Because it's finally 2 weeks time is going to the money. Yes.
Seal number 10, Devraja M.
In this case, there are 5 office. 2 weeks time will be granted. 5 office.
Audio officer. ಇಲ್ಲಾದ ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಇದೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. There are FR criminal appeal number 708. ಇನ್ನೊಂದು criminal appeal number 482 of 2024. 45 of 2024. ಹೌದಾ? ಅದು 10 days time ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ ನಮ್ಗೆ notice ಕೊಡ್ತಾರೆ. Law council seeks time to comply with the subsections. Record show that the matter is connected to ಅದು ಇನ್ನೊಂದು ಯಾವುದೋ ಇನ್ನು FR ನಂಬರ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಇದೆ. Criminal appeal number 482 of 2024, 745 of 2024, 799 of 2024, and FR criminal appeal number 708 of 2024. List all the matters together after 10 days. Yes.
Seal number 11, Lakshmikant K.
3 days time may be given, my lord. After submission,
Correct version of what we mentioned, I pray.
more than a time. 3 days time.
At it was 1 week time is granted.
Seal number 12, adjourned. Seal number 13, Kumarswamy BN.
Lordship, praying for little time to comply with office objections, about a week's time, Your Lordship.
HCLC ದಾಗ HCLC matter ಇದು.
Yes, Your Lordship, yeah.
11 objections.
At request, ಎಷ್ಟು ಅವಷ್ಟು
1 week's time.
at request 1 week time is granted.
Thank you, Lordship.
Seal number 14, Rakshita.
In this case, I'm appearing for appellant, my lords. I pray for weeks time to comply with the office objection.
Just 10 days time is granted.
Pledge.
Seal number 15, RP Somshekharaia.
Again, second. No representation for conviction ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಆಗ್ತದೆ. 10 days time is granted to the
Hearing on IA, seal number 16, Sangesh G Patil, BR Prashant.
We have not received the copy of the, it was in office objection, my lord, till date. Now they have complained. Maybe
There are 1926 days means how many years?
3 years, almost 3 years.
Don't think it is, it must be more than.
Please, 4.
ಇನ್ನೂ ಒಂದ್ಸರಿ peremptory order ಆಗಿತ್ತು. No representation 66. Name of the applicant is so and so and violation slip is also furnished accordingly. Office objection is over. Finally, when it comes to failing which the appeal shall stand dismissed 6/6/2023.
Sorry.
You were directed to take notice.
Well, please, my lord, we were
It was not served.
my lord, we were directed to take notice, my lord.
No.
Later on, they have not served the copy of the. for
No
this.
representation for the appellant. Letter counsel for respondent Seshtivu
Respondent number 2.
and 2. 1 and 2 submits that the copies are not served on him. Finally, 10 days time is granted to Bandra. He says they are not served the copies on him.
16.
Cell number 16.
16.
16 only, easy.
And 10 days. Okay, kindly 10 days time is granted to serve the copies. 2016 matter, there is already 1926 days delay is there. Copy serve Madi.
Cell number 17, Bhargav Ji, Sunita Srinivas.
Respond to this case.
For second respondent in this case also, madam. We have
Sunita
received a.
Srinivas for R2 anta ಇದೆ. Same.
Please, madam. On behalf of Sunita Srinivas, I am appealing.
Who is R1? HCGP notice ಆಗಿಲ್ವಾ?
AGA for R1.
AG incident ತೋರಿಸಿದ್ದಾರೆ. AGA for R1, correct. This 1013 days delay,
Formal objection I will file, my lord, in this case also.
2017 ಮಾತ್ರ.
21 ತರುವಾಗಿತ್ತು ಕಳಿಸಿದ್ದೆ, ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿರಲಿಲ್ಲ. Weeks time, madam. I will.
At request of counsel for respondent number 2. 10 days time is granted to file counter to I1 of 2017. This done 10 days on one day.
10/6.
Date
Please.
10/6.
Cell number 18,
I am for the appellant, my lord.
Acharam Suryambe.
Acknowledgement for having served copies on AG and
IA1 of 2017, non-filing of objection. Sir, the copy of IA1 of 2017. Copy sir ಮಾಡಿದ್ದೀರಾ?
serve ಮಾಡಿದ್ದೇವೆ ಸ್ವಾಮಿ. Acknowledgement ಇವತ್ತು file ಮಾಡಿ.
Sir? ಯಾರ ಮೇಲೆ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದೀರಿ?
867
No, on whom we have served the copies?
to AGM.
Yes, AG.
Serve the copy.
ಅಲ್ಲ.
Filing a statement of objection in this case.
Well, AG submits that has received the copies. Therefore, office objections in that regard should comply. Yes, objections,
I will file an objection. First, may kindly have it after 15 days now.
any connected matter is there?
Connected.
ಮತ್ತೆ ಇವೆಲ್ಲ 2017 ಪೆಂಡಿಂಗ್ ಇರ್ತವೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ ಅಟ್ಲೀಸ್ಟ್ ಇಲ್ಲೇ ಕಂಡೋನ್ ಆಗುತ್ತೆ ಬರೀ ಎವ್ರಿ ಡೇ ವಿ ಹ್ಯಾವ್ ಟು ಅಡ್ಜನ್ ಸಿಟ್ ಓನ್ಲಿ ಟು ಅಡ್ಜನ್ ದ ಮ್ಯಾಟರ್ಸ್ At request, finally 10 days time is granted to file counter to I1 of 2017. ಇಲ್ಲಾಂದ್ರೆ ನಾಟ್ ಫೈಲ್ ಅಂತ ತಗೊಳ್ತೀವಿ ನೋಡಿ
10 days then.
ಲಿಸ್ಟ್ ಆನ್ ಫೈನಲಿ ಲಿಸ್ಟ್ ಆನ್
10/6. Cell number 19, Sangamesh G Patil.
Weeks time. Apply office objection and serve copy.
non-filing of any objections to IA1 of 2017.
Serve ಮಾಡಬೇಕು.
Non-filing of acknowledgement for having served. Yes, have you received the copy?
Have not received the copy.
ಇದೆಲ್ಲ 2017 ಕೇಸ್ ಅಲ್ರಿ ಇನ್ನು we sit only to adjourn the matters. ಅದು only on the small matters, not hearing also.
Wait, sir. Weeks time.
At request. 1 week time is granted to do to serve the copies, failing which appeal shall stand dismissed. List on after next one ವಾರ ಆದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ.
5/6.
Okay.
Cell number 20. Five, 6. Cell number 20, Chetan B.
Application for respondent number 2 and 3.
Them order.
Application.
Including R2 and R3.
R2 and R3.
IA1 for condonation of delay. Who are R2 and R3?
R2 is Government of Karnataka Secretary Chief Secretary in Dharsana. R3 is Kaveri Neelavari Nigama.
First question. ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರೀ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಫೀಸರ್ ಅಷ್ಟೇ ಮಾಡಿದ್ರು, ಬೆನಿಫಿಷಿಯರಿ ಪಾರ್ಟಿ ಮಾಡಿರ್ಲಿಲ್ಲ.
ಮಾಡಿದ್ದೀನಿ ಹೈಕೋರ್ಟ್ ಅದಕ್ಕೆ ಇಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಮಾಡ್ಬೇಕಲ್ಲ, ಯಾಕಂದ್ರೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ಯು ಎಕ್ಸಿಕ್ಯೂಟ್ ಅಗೇನ್ಸ್ಟ್ ದ ಬೆನಿಫಿಷಿಯರೀಸ್ ಆಲ್ಸೋ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ನಾವಿಲ್ಲಿ
Government of Karnataka represented by Chief Secretary. Kaveri Nivar, ಅವ್ರ ಇದ್ದಾರಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ ಅವ್ರ ಕಾಪಿ ಸರ್ ಮಾಡಿ.
ಅವ್ರು ಮಾಡಿದ್ದೀನಿ.
ಸರ್ ಮಾಡಿದೆ.
ಮಾಡಿದ್ದು.
ಪ್ರಶಾಂತ್ ಅವ್ರಿಗೆ
BR Prashant.
he is standing counsel for Kaveri ನೀರಾವರಿ.
ಅವ್ರು ಮಾಡಿದ್ದೀನಿ.
The AC accepts notice for respondent number, means proposed respondent number 2. Respondent number 2. Clerk counsel shall the appellant shall serve the copies on Shri or in Prashant BR. Prashant BR, allowed standing counsel for proposed respondent number 3. List on or ಮತ್ತೆ ಇದನ್ನ ತಗೋಬೇಕು instruction. 11-6. 11-6. You serve the copies already.
Amendment.
Amend application allow ಮಾಡೋದಿಲ್ಲ, ಅವ್ರ ಕಾಪಿ ಸರ್ ಮಾಡಿ ಮೊದಲು.
Number 21, S. Vishweshwaraya.
Claimants in motor accident cases and LIC cases have no procedural law.
I appear for appellant in this matter, madam. With a delay of 188 days in filing the application for recalling the order.
ಇದ್ರಲ್ಲಿ ಯಾರೋ ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ. Somebody was seeking time.
Next matter.
Next matter. Who are the respondents here?
Only under special land acquisition.
This
H.
order was passed on 4/3/2021.
It was dismissed for non-compliance of our objections. Since we did not produce certified copy.
Now we have complied.
Dismissed also not. Now it is compliant.
ಅಲ್ಲಲ್ಲ ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ. ಸಬ್ಜೆಕ್ಟ್ ಇಲ್ಲ ಮಾಡೋಣ. ಇಲ್ಲ ಮತ್ತೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮತ್ತೆ ಅದನ್ನೇ ಮಾಡ್ತಾ You pending this application, you comply the office objections, then we'll take up this application.
Much.
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ಅದರ್ ಸೈಡ್. ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್
Special land acquisition officer HB Bank.
8862. 8862. Who is the standing counsel for KHB? Are you aware? ಯಾರೋ ಇದ್ದಾರೆ.
I will ascertain.
ಯಾರೋ ಇದ್ದಾರೆ. ಯಾರು?
ಪ್ರದೀಪ್ ಅಂತಿದ್ದಾರೆ ಸಬ್ರದ
ಪ್ರದೀಪ್.
ಚೆಕ್ ಮಾಡಿ ಸಬ್ರದ
ನೋಡ್ಕೊಳ್ಳಿ ಯಾರಿದ್ದಾರೆ ಅಂತ ನೋಡಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
I will ascertain, sir, the copy.
Pending, I'm sorry, as a precondition for consideration of item 1 and 2 of 24, appellant's counsel shall comply the pending office objections within 10 days and also serve the copies on the standing counsel for respondent, for the respondent. Any of the standing. ಯಾರಿದ್ದಾರೆ ಇಲ್ಲ ನಾವ್ ಇದು ಬಿಟ್ಟಿರ್ತೀವಿ ಆಮೇಲೆ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. We ascertain and fill up his name dash ಅಂತ so and so standing counsel for the respondent. Failing which the application shall stand dismissed. 10 days time ಕೊಡ್ತೀವಿ ಎರಡು ಮಾಡಿ.
Yes.
You just come in the afternoon and ascertain the name of the advocate. Next after 10 days.
So number 22, Parinalalla, Narendra Babu BK.
Appeal for respondent. 285 days, recalling the order dated 7/2/2020.
Copies not sufficient.
New case agreement.
23/11/2021, all the one
What
record
is
on
the-
the council and through WhatsApp on based on the request by I saw through WhatsApp only.
No, I have not received some. Refer time to file the objection. They are leaving separated from 2012. And delay of 285. They are not the copies also.
2023.
It's for me, they are separate from 2012.
Correct, that is on merits. Now
It's,
for recalling, what is it?
285 days delay there.
ಏನ್ ರೀಸನ್ ಹೇಳಿದ್ದಾರೆ?
Copies received not.
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ ಇನ್ನೊಂದ್ ಸೆಟ್ ಕಾಪಿ. ನಮ್ಮ ಆಫೀಸರ್ಸ್ ನಾಟ್ ರೇಸ್ಡ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್.
Because on request of the council by the respondent council, I served through WhatsApp only.
You were the advocate.
2023 only I served.
ನಮ್ಮ ಆಫೀಸ್ ಅವ್ರು ಜನರಲಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡ್ತಾರೆ. ನೋಡೋಣ ಅದ್ರ ಮೇಲೆ ಏನಾದ್ರು ಎಂಡಾಸ್ಮೆಂಟ್ ಇದೆ ಅಂತ. ಯಾವ್ದಾದ್ರು advocate received ಅಂತ. Just
To WhatsApp I found, my lord, on request of the council by the.
ಆಯ್ತು ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ ಜಸ್ಟ್ ವಿ ಆರ್ ಸಿ
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇಲ್ಲಿದೆ ಅಲ್ಲ ಥ್ರೂ ಸೆಲ್ ಫೋನ್ ಅಪೆಲೆಂಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ನಿಮ್ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಯಾರೋ ಎಡೋಕೆಟ್ ಬಾಬು ಅಂತ ಹೇಳಿ ಯಾರೋ ಸೈನ್
ನರೇಂದ್ರ ಬಾಬು.
ಯಾರು ನೀವ
Respondent.
ಇದೇನೋ ನಿಮ್ದು ಸಿಗ್ನೇಚರ್ ಇದೆ ಅಲ್ಲ ಇಲ್ಲಿ ಬಾಬು ಅಂತ.
ಬಾಬು ಹಾಕಲ್ಲ ನರೇಂದ್ರ ಅಂತ ಹಾಕೋದು ಸೀನಿಯರ್.
ನರೇಂದ್ರ ಬಾಬು ಅಂತಾನೆ ಇದೆ. ನರೇಂದ್ರ ಇಲ್ಲಿದೆ, ಬಾಬು ಇಲ್ಲಿದೆ.
ಇಲ್ಲ ಬಾಬು ಹಾಕಲ್ಲ.
ಅಲ್ಲ ರೀ, ನರೇಂದ್ರ ಬಾಬು ಅಂತಾನೆ ಇದೆ ಇಲ್ಲಿ. Because office has not raised objection, ಅದಕ್ಕೆ ನಮ್ಗೆ ಡೌಟ್ ಬಂತು. ಆಫೀಸ್ ಯಾರು ಮಾಡಿಲ್ಲ ಅಂತ. What is that reason you have assigned? Appeal was listed on 23/2019. Hearing my counsel so and so was pleased to issue notice to the respondent.
They are not appeared.
Entered appearance. Above case was thereafter listed on 7/2/2023. Regarding memo of retirement filed by my counsel. Memo of retirement, whether that was accompanied by notice.
She is admitting, my lord, received the memo of retirement.
Yeah.
After that, in paragraph number 5, my lord, in my affidavit, I explained that I am suffering from indigenous my lord. I didn't contact the any advocate.
Psoriasis.
Yes, ma'am.
To file the objection free of times.
This is a family court matter. One.
No, they have not the surrogate appeal also. This because of
Office has not.
they are living separately from 12 years.
That is on merits. Merits ಮೇಲೆ ಬಂದಾಗ you can argue.
They are not interested in.
Women's appeal, whether they have issues out of the marriage.
Yes.
ಮಕ್ಕಳಿದಾರ?
ಒಂದ್ ಮಗು ಇದೆ.
ಯಾರ ಜೊತೆಗಿದೆ ಮಗು?
ಅವ್ರ ತಾಯಿ ಜೊತೆಗೆ ಇದಾರೆ. She is.
ನಿಮ್ಮ ಮಗುನ ಅವ್ರು ನೋಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. 2012 ಬೇರೆ ಇರ್ಲಿ.
I am throw out of the my ನಮ್ ಮನೇಲೆ ಅವರೇ ಇದ್ದಾರೆ. ನಮ್ ಪೇರೆಂಟ್ಸ್ ಮನೇಲಿ ಅವರೇ ಇದ್ದಾರೆ. ನಾನು ಆಚೆ ಇದ್ದೀನಿ ಇವಾಗ. From 2012.
ನಿಮ್ಮ ಮಗುನ ಅವ್ರು ನೋಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ ತಾನೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ.
Order is passed.
Yes, my lord.
ಎಲ್ಲ ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ.
10 lakhs permanent alimony
Has been granted.
but there is no single phase till that they are not.
ಇಲ್ಲ ಸ್ವಾಮಿ ಸುಳ್ಳು ಅದೆಲ್ಲ ಸುಳ್ಳು.
Order is there, my lord.
What about the child?
Because of that reason only the 10 lakhs alimony has been granted, my lord.
Where is this?
In page number.
10 lakhs to the wife ಅದು.
Yes, ma'am.
ಮಗುಗೆ ಏನಾದ್ರು ಸಪರೇಟ್ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ಟಿದಾರ?
ಇಲ್ಲ. Because at the time he is minor.
Correct. ಈಗ ನಾವು the child is major now. So your grievance is only against regarding the quantum of alimony.
I will provide the ಅದು ನಾನು ಎಲ್ಲ ನಾನು ಪೇ ಮಾಡಿರೋದೆಲ್ಲ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ. Will recall this.
ಸ್ವಾಮಿ.
Present ಅಲ್ಲ ಇದ್ರಲ್ಲಿ their grievance is also setting aside the judgment and decreed that it's so and so possible. ಇಲ್ಲ setting aside ಅಂತ ಕೇಳಿದಿರಲ್ಲ ನೀವು.
My lord,
Your prayer is only to.
Yes, my lord. The petition is filed by the husband.
Correct.
That, before the family court, my lord. That regarding the dissolution of marriage, that petition is allowed, my lord. And one more, the prayer has been, that 10 lakhs has been awarded to the permanent alimony, my lord.
I paid that.
No, my lord. Till that I have not received any single.
We are asking whether this appeal is against a decree of divorce or only against alimony.
Decree against this divorce.
ಬೇರೆಲ್ಲ
Decree against divorce.
ಅವಾಗ ಕೇಳಿದ್ರೆ ನಾವು ಎಸ್ ಅಂದ್ರಲ್ಲ.
ಇಲ್ಲ, decree against divorce. Sorry, ma'am.
Lara counsel for the respondent seeks adjournment on the copy ground that copy was not served. The applications are filed in the year 2023. As per the endorsement on the applications, the copies were served and even office has not raised such objection. Therefore, the council submission in that regard is rejected. Order summary number 1/2/2023, heard. This is an appeal of the wife against, appeal of the wife challenging the decree of divorce granted against her. The records show that her counsel retired and before she could make some arrangement, the appeal was dismissed for non-prosecution. Since the substantial rights of the parties are involved, substantial rights of the parties in the conjugal relationship are involved, and considering the reasons assigned, delay of 285 days in filing I number 2/2023 is condoned.
That cannot be condoned, Swami. Ashtu 285 days ಇದೆ. ಅಷ್ಟೊಂದು days ನ condone ಮಾಡಿ. They are separate from 2012 in the
You made
separate.
that submission, we said that comes only in, this appeal was filed before. When did you file your petition for divorce? That was in 2012.
2012.
Decree was passed in 2018 and this appeal was admitted. Then later it is dismissed. No, sorry. Filing so is condoned. And the order dated. Order dated 7/2/2023 dismissing the. appeal for
Copies serve
non-prosecution
ಮಾಡಿಲ್ಲ Swami.
is hereby recalled. The appeal is restored to the file. I number 1/2023 are disposed of accordingly. ಆಯ್ತು records merit ಮೇಲೆ ಮಾಡಿ. Please.
They are not interested, both of them are.
Correct, we'll hear you on merits. How many times we have to
ಹೌದು.
tell you?
ಒಂದ್ಸತಿ ಹೇಳ್ತಾರೆ ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಕಳ್ಸಿದೀನಿ ಅಂತ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ನರೇಂದ್ರ ಬಾಬು ಸೈನ್ ಇದೆ. ಇಟ್ಸ್ ನಾಟ್ ದ ಸೈನ್ ಆಫ್ ದ ಸೀನಿಯರ್.
Even assuming, ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. It's a matter of, you have to succeed in a
Just to
case.
harass the respondent.
You have to succeed in a case on merits. If you have a good case, you will succeed. Their appeal will fail. And that too, it's a conjugal relationship. They have a son and
Daughter.
and their
daughter.
grievance is not against the quantum of alimony. They have sought reversal of this divorce decree. Judgment is reasons ಎಷ್ಟರಲ್ಲಿದೆ judgment ಬರೀ ಇದ್ರಲ್ಲಿ ಮಾಡ್ತಾರೆ, witnesses ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. Hardly 3-4 pages judgment ಇದೆ, reasoning. We'll consider, and it's a statutory appeal. List for final hearing on next month. 10 days.
11/6. 11/6. Cell number 23, Girish P. Baldare, AGA for
I prefer the respond in this case.
Pardon?
430 days.
430 days.
I file my statement of objection in this case.
ಆ ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿಗೆ ನಾವೀಗೆಲ್ಲ ಹೇಳ್ತೀವಿ, ನಿಮ್ದು 490 days ಡಿಲೇ ಇದೆ, 430 days.
Additional document ಒಂದು ಹಾಕಿದ್ದಾರೆ, ಡಿಲೇ ಎರಡಕ್ಕೂ
ಹಾಕೊಳ್ಳಿ, additional document that has to be heard along with the main matter.
ಅಲ್ಲ, I will file both not statement.
ನೀವು
ಎರಡಕ್ಕೂ
2017 ಕೇಸಲ್ಲೂ ಈಗ ಹೇಳ್ತೀರಾ.
Final not speak and only 10 days time in this case, not call my officer and I'll file.
ಅಲ್ಲ, ಈಗ ನಿಮ್ ಪ್ರಿಡಿಸೀಸರ್ ಇರ್ತಾರೆ, ಸ್ಟೇಟ್ ಅಪೀಲ್ ಅಲ್ಲೆಲ್ಲ ಹೀಗೆ ಕೇಳೋದು. When were you served? MA not filed. You are not even filed memo of appearance.
11/6.
We'll deny the interest and allow the application. Orders and number. ಏನೋ ಸಾವಿರ ಡೇಸ್ ಡಿಲೇ ಇದ್ದಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿದೀವಿ ಟೈಮ್. Orders and number 1/2019. ಏನು ignorance, illiteracy na? What is the reason said for delay? ನಿಮ್ಮ ಡಿಪೋನೆಂಟ್ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ. Except my children.
He
What is
stated
his
that
age?
is the medical reason ಹೇಳಿದ್ದಾರೆ.
47?
Page number 32.
ಈಗೇನು ಇದ್ರಲ್ಲಿ ಸಿಮಿಲರ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗಿದೆಯಾ? ಅದಕ್ಕೆ
Actually, that it belongs to Hassan district, Hassan city.
on merits, we have to see that. If it is not similarly situated land, then that may not be applicable. Considering the reasons assigned to explain the delay of 430 days in filing the appeal is condemned in the interest of justice with a condition that if the appellant succeeds in the appeal, he shall not be entitled to interest on the enhanced compensation for the delayed period. IA number 1 of 2019 is disposed of accordingly. IA 2 of 2019 being the application for production of additional evidence needs to be heard along with the main matter. Also, similarly situated land will be done. And when the judgments were passed, before the award was passed or after the award was passed? Same ಅದೇ ಹಾಸನ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ 2015. When this order was passed, this impugned award, this is passed in 2017.
16th October.
ನೀವು ಕೊಟ್ಟಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ 2015 ಇದ್ದು. How this becomes a subsequent event? 2014 ಇದ್ದು.
Same purpose, madam, widening of the BM.
ಅದಕ್ಕೆ ಬೇಕಂದ್ರೆ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೊಳ್ಳಿ ಅದಕ್ಕೆ.
Please.
Admit call for TCRs. Please look for the risk of TCRs.
Say number 4, Nagaya, Nanesh Chennai.
Appeal for respondent 1 to 4, your lordship. This what is the IA for modification of interim order? There is an copies to second or 5. It is filed by you. Production IA 1 of 2021 for state. What is that modification you are seeking?
There's an unconditional order of say subsisting in this case, your lordship. We are seeking for the petitioners to appellants to deposit 50%.
Deposited any amount?
They haven't, sir. There's an unconditional order, your
Instead
lordship.
was granted by the form of granting liberty for the respondent to move in case.
With liberty is given. Yes.
That is, in other cases, your lordship has ordered.
Pardon?
In other cases, in similar MFA,
Hmm.
your lordship has ordered to deposit 50% of.
50%.
Enhanced awarded amount. Awarded amount has already been paid to the respondent.
Award amount, LIC award
LIC
reference quota. LIC award ಏನು
paid.
meager amount ಇರುತ್ತೆ. You have to pay the reference award. Reference quotes award deposit ಮಾಡಬೇಕು.
Really, we have taken the contention in the appeal memo.
14,83,440. In addition to what has been. But
Taken that, the reference court has not considered, even no document has been produced before the reference court about the growing of badami mango.
we'll see.
That is some merits.
Orders and number 1 of 2024. Okay. The above heard, the above appeal is preferred, challenging the award, it's a land acquisition award passed by the reference court, enhancing the compensation. Now date of order 216.
That is 16 to 2021.
This court 16 green.
16 to.
This court on 16. 2/3/2022. This court on 2/3/2022 has granted that. It is in the nature of a money decree. Otherwise also you have to deposit. We do not know how it is passed on that.
We will consider, we will tell.
This court on 2/3/2022 has granted unconditional interim stay. The decree is in the nature of a money decree. And the respondent applicant, sole respondent.
Respondent
Respondent number
1 to 4.
The LS of, this is the claimant.
Under the circumstances, the appellant, the circumstances are available. Even in that interim order, liberty was reserved to the response to seek modification of the order. Under the circumstances, the order dated 2/3/2022 is modified as follows. Interim stay of the impugned award, subject to the appellant depositing 50% of the award amount granted by the
Respondent number.
reference
One.
court. With 50% of the award amount with all statutory benefits.
Pass the respondent number 6 months.
Benefits within ಎಷ್ಟು ದಿವಸದಲ್ಲಿ 4 weeks.
To 8 weeks, madam, because we have to move the authority and
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಯಾವ್ದಿದು?
Vijay Vishweshwara Jalalingam Limited.
I press for shorter time, Your Lordship. 8 weeks is allowed.
Appeal is filed in 2021. Upper Bhadra project.
Upper Bhadra project.
In between 6 weeks kodal. Yes, subject to 50% of the award amount with all accrued statutory benefits. Accrued benefits ಅಂತ ತಗೊಳ್ಳಿ. Accrued benefits with before ಅಲ್ಲೇ ಕೊಡ್ಲಿ ಅಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಾ?
Have to deposit there.
Before the reference court within 6 weeks from the date of this order. I number 1 of 2024 is disposed of accordingly. ಮತ್ತೆ ಏನೋ ಒಂದು ಇದೆ.
My lord, with the condition,
Release happens ಆಮೇಲೆ ಬೇಕಂದ್ರೆ ಮಾಡ್ಬೋದು.
with the condition to the respondent number 2 to 4 to withdraw the amount with by giving some security.
Withdrawal permission ಕೊಟ್ಬಿಡಲ್ವಾ?
In the event if they unable to succeed in, we have succeeded in this, then you have to recover back the amount from the.
He is conceived. On such deposit, the reference court shall release the amounts to the claimants. Claimant is no more now. ಇಲ್ಲ ಇದಾರಲ್ಲ 4 ಜನ ಇದ್ರಲ್ಲ. There are more than 4 claimants.
ಇಲ್ಲ ಇವರು ಒಬ್ಬರೇ ಇದ್ದಾರೆ.
ಅಲ್ಲ,
Father is dead.
The claimants were 5.
5.
For the
1 to
reference.
5.
ಇಲ್ಲಿ 1 to 5. Release such amount in the claimants and the ratio of their shares digitally. Please,
Then
Dr.
undertaking my lord. Then undertaking with any condition may be imposed for recovery of money in the event we are succeeding in this.
ಹಾಗಂದ್ರೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಬಿಡಿ, ನೀವೇ ಕೊಡಿ ಅಂದ್ರೆ ನಾವು ಕೊಡ್ತೀವಿ ಅಂದ್ವಿ. ಈಗ ಮತ್ತೆ ಯು ಆರ್ ಇಂಪೋಸಿಂಗ್ ಕಂಡೀಷನ್ ಟು ಅಸ್. ಆಯ್ತು, ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ಮೇಲೆ ದೇ ವಿಲ್ ಕಮ್ ಅಪ್ ವಿತ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ದೆನ್.
ಅಲ್ಲ, even I have no objection for deposit the money before your lordship.
ಮಾಡೋದು ಕೊಟ್ಬಿಡೋಣ, ಅವ್ರೇನು ಲ್ಯಾಂಡ್ ಲೂಸರ್ಸ್, ಅವ್ರದೇನು ಟೈಟಲ್ ಬಗ್ಗೆ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
ನಮ್ ಕಂಟೆನ್ಷನ್
ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಆಫ್ ದಿಸ್ ಅಪೀಲ್ ಅಂತ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ.
Public.
Is there a likelihood that it can be reduced to less than 50%? Chance ಇದೆಯಾ?
ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು I will demonstrate before lordship that they are not entitled for.
ಇನ್ನೊಬ್ಬರಿಗೆ ಯಾರಿಗೂ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದೆಲ್ಲ ಇದೆ ಅಲ್ಲ. Finally, 10 days time is granted to do. R5 is statutory.
R5 is the data. R5 1 to 4 are the family members of
authority.
Rudrappa.
R5, you have not filed wakalat for her.
No, Your Lordship. We represent R1 to.
She directed to pay to all the claimants in accordance with their shares anta ಮಾಡಿದ್ವಿ. So she is not before the court. You don't want to file the wakalat, otherwise again there are no instructions.
I
There
don't
are
have.
siblings.
Yes, I don't have instructions, Your Lordship.
ಅಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ರ ಅವರು? No, they were represented through the same advocate before that trial.
If maybe passed over, Your Lordship, I can.
Order notice. Take instruction and file wakalat.
Yes, please.
Finally, 10 days time is granted to do the needful in respect of respondent number 5. Failing which appeal against respondent number 5 shall stand dismissed.
Otherwise, in the meantime, out of 50%, let the 1/4 pay be released in favor of respondent number 1 to 4.
ಎಷ್ಟು ಸರಿ ಆರ್ಡರ್ಸ್ ಚೇಂಜ್ ಮಾಡ್ತೀವಿ ತಗೊಳ್ಳಿ ಬಿಡಿ. We do not think that it will be released by.
Public.
Still number 25, Javid, yes, SPP.
ಕಡಿಮೆ ಆಗೋ chance ಇರುತ್ತೆ. Yes.
Appearing for the appellant, my lord.
IA1
Still number 25.
Yes.
Appellant has been convicted for the offence punishable under section 302 and 323 for life imprisonment, my lord. There are 18 witnesses, my lord.
There were 2 accused.
One mother of the accused number 1, my lord. She has been acquitted, my lord.
323, 302, 109.
There are 2 eyewitnesses, my lord. The brother of the accused, my lord.
Yes. Right, he was on bail during the trial?
No, my lord.
Then how are you?
That is on 24.
And there are eyewitnesses also.
2 eyewitnesses.
And how can we grant them suspension?
Heard with along with me.
Heard along with the main matter. What would son, we can renew your application if there is delay. It is not admitted.
Admitted, my lord.
Admitted ಆಗಲ್ಲ. TCR
March 15.
TCR ಬರ್ಲಿ ಅಂತ ಮಾಡಿದ್ರು. Yes. what is-
My lord, there are
Who were the eyewitnesses here?
My lord,
PW 8.
PW 7, 8 and 9 are the eyewitnesses, my lord.
7 to 9.
The accused has killed his wife, my lord. And the 3 children have also deposed against the
At
accused.
30 years prior to the incident.
His age is 55, my lord.
4 sons.
And the eyewitnesses separated the accused while he was slitting the neck of the deceased, my lord.
They were neighbors, eyewitnesses.
Yes, one of the witness is neighbor.
PW 8 is the brother of the accused number 1, my lord. He is the eyewitness.
PW8 is the brother of
Accused, my lord.
accused only. He has supported.
Witness.
Yes, my lord, they have supported the case.
And PW7 and 9?
Wife and son of the PW 8.
PW8. We'll dispose
heard
of the application. Paper book ready.
Please, ma'am.
Why the application should be pending?
Yes, ma'am.
Orders the number. One of 2023. Third, where the impugn judgment and order, the appellant is convicted and sentenced for the offenses punishable under section 302 and 323 APC. 323 ಯಾಕೆ? He has caused injury to
The eyewitnesses were also
Eyewitnesses.
assaulted, my lord. They also
Wait,
suffered injury.
They were injured eyewitnesses.
Yes, ma'am.
The charge against the appellant accused number 1 was that 30 years, married 30 years.
55 years age, my lord.
Uh,
Accused number 1.
That he was addicted to alcohol
Yes, my lord.
and was torturing his wife for money for addiction of for his addiction and seeking sexual power from her, though they were married for 30 years and having 4 children. It is further alleged that in that background on 19/2/2021 at 11, during daytime only, at
11
11:30 AM in his house, he assaulted the victim and committed her murder. Cutting the neck,
This one, slitting.
Okay. Cut her neck ಅಂತ started to cut her neck ಅಂತ ಇದೆ. ಏನದು ವೆಪನ್ ಏಮೋ?
Knife malo.
ರಿಕವರಿ ಆಗಿಲ್ವಾ ಅದು?
ಆಗಿದೆ malo, from this spot on.
ಎಮೋ 7. Assaulted ಅಲ್ಲ? He slit her neck with MO7, the knife, and committed her murder. And when PW 7 to 9 came to her rescue, he assaulted them also and caused them injuries. During the trial, the appellant was not extended the benefit of bail. The eyewitnesses, who are none else but the brother and nephew and sister-in-law of the accused, have supported the prosecution case. Under the circumstances and having regard to the and having regard to the gravity of the offense and material on record, I exhort a fit case to grant suspension of sentence. This I-1 of 20 phase rejected. Paper book ready ಆಗಿಲ್ವಾ ಇನ್ನು? 16/30/2023. The registry shall prepare the paper books within 4 weeks. List after 4 weeks.
Number 26, Keshu M. Datar, SPP.
Combination of delay application. 63 days delay.
What is judgment? Conviction for 302, 201, no? 302. Conviction for 302, 202.
302 conviction.
He was in custody during trial.
He was in custody during trial.
So that is the ground for delay.
My lords,
That is the ground for delay.
that is the ground for delay. He
In
was in custody during trial and as well as by the time he got information.
We'll condone the delay.
Please.
ಅದನ್ನೇ ಹೇಳಿದ್ದೀರಾ? The record shows it.
65.
The appellant was in judicial custody during trial and thereafter also he is in custody to serve the sentence. Considering the same, they have 163 days in pending the appeal is conflict of interest of justice. I-1 of 24 is disposed of accordingly. What about suspension?
Suspensions, this is circumstantial evidence. My lords. This is a crime that was committed on 6/5/2021.
Yeah. Yes, ready, there are suspension of sentence. No, yes.
My lords,
What are the circumstances?
my lords, the circumstances are that Chandran, who is the deceased, my lords, and the accused are related. Subsequently on they were working on the same fields. Subsequently on 6/5/2020, they were walking together and allegedly a crime has been committed. There are no eyewitnesses who have seen the crime. There is no circumstances that are contributing to the factor that the accused was present at the time of the offense. If your lordships can turn to,
They're living together,
they were not living together.
never colony. This is common feature in Kurg, living together. area murder
Two,
cases.
yes, my lords, but they weren't living together.
No, no, in the common that line houses,
Line house ali, they were in different houses.
quarters are different, but the
Quarters
same
are
line, same line house.
Similar lines.
This,
My lords, if your lordships could turn to page number 41, my lords, of the impugned order. Running page 41.
this,
At para 27, my lords, last three lines. In the cross-examination by the accused, by the counsel for the accused, PW 14 stated that the complainant came along with the written complaint and he is able to read Kannada language. Now, my lords, I take your lordship
we
to,
asked you, what were the circumstances set up by the prosecution?
please,
You said
precisely.
It is based on circumstantial evidence. Who filed the complaint?
The complaint was filed by a third person called Mohammed.
No, it's resident of same, the singer.
No, my lords, that I'm not aware.
Hangandre
Then he was-
ಓದ್ಕೊಂಡ್ ಬನ್ನಿ. Have you gone through the entire judgment?
Entire judgment I've gone through.
Then it should have been reflected in the judgment. Who filed the complaint? And what are the circumstances relied? Are you aware? Madam?
CW1.
What are the circumstances relied on the prosecution? Last scene, no?
Your Lordships,
Recovery.
Lordships, there is no last scene witness, your lordships. PW1 is the witness who was aware of the fight between, there was some dispute going on between the deceased and the accused. PW1 is the witness who speaks about that there was dispute between accused and deceased. Your lordships, the last scene theory ಅಂತಂದ್ರೆ there is no
Correct, ಏನೇನ್ circumstances rely ಆಗಿರೋದು trial?
lordships, it's on the voluntary, your lordships, the sickle is recovered at the instance of the accused weapon. And your lordships, the bloodstained clothes of the accused and deceased and the weapon all have matched, your lordships. To
FSL report.
FSL report, DNA, FSL report ali, the blood.
That circumstance was proved.
That was
Recovery
proved.
was proved.
And the Mahazar witnesses have also supported the case of the prosecution.
My lords, insofar as the statements mean that why the respondent is concerned, the FSL
We'll
report.
do one thing.
Please.
We'll consider this application after the receipt of the TCRs. We'll admit and call for the TCRs.
Because the FSL report has no mention
Yes,
about
we
the
have-
blood stains as well.
We have to see that.
Precisely.
Now,
Page
during
number
trial also he
52.
was not granted bail.
My lords,
During trial also
he was not granted bail.
So now it seems because she is referring to this
FSL report.
reports, we have to examine that.
Please.
We'll admit and call for the records. We'll
Please.
consider this application
Please.
after receipt of the records.
Please.
Your lordships, that finding is there in page number 51, 52, your lordships, regarding the FSL report. Page number 52 at the bottom and page number 51 also, your
Now,
lordships.
when we see the records, we'll come to know.
Please, your lordships.
We call for TCRs for consideration of I number 2 of 2024. The TCRs are required, therefore, I 2 of 2024, I'm sorry. Consideration of I 2 of 2024 is deferred till the receipt of TCRs.
Grateful, my lords.
Please down on 4 weeks with accounts.
Grateful.
28.
Cell number 27 adjourned. For admission, cell number 28, MP Geeta Devi, BC Prabhakar.
I appeal for the respondent, my lord.
For the appellants, my lord. Lord, this matter, my lord, the respondent is Infosys establishment is covered by the ESA Act. Lord, for the wage period, October 2007 to 2009, they had paid certain sum of money to the corporation. Then they submitted a representation saying that they have paid the contribution for all the employees all over India, but some of the employees are non-covered region and therefore they sought for refund. The two question that arises for consultation, my lord, is that once the main headquarters is covered, the entire establishment will be liable to be covered as per Supreme Court judgment in the Transport Corporation case, my lord. That is one aspect, my lord. Now, the second question that arises for consideration, my lord, is that when a person can seek for refund, the regulation stipulates, my lord, before the contribution, before the benefit period, they should seek for contribution period. Not 6 months thereafter the benefit period. My lord, the entire amount, there's a quid pro quo in the ESI, unlike in the insurance, that I pay the insurance, I get the benefit. In the ESI Act, my lord, the entire amount that has been paid goes to a fund. And from the fund, all eligible employees will get the benefit. I may incur an expenditure in terms of sickness or an accident. I may not for entire 10 years I'm working there. But I'll be entitled to in case of any emergencies. So that is the benefit under the ESI Act. There is no quid pro quo. So now the question of refund, these aspects have not been considered by the ESI court, my lord, and therefore I'm before you.
They were urged before the trial court.
Please, my lord.
They were urged.
These are all issues that arises, my lord. They're all questions of law, my lord. Only question they ask is a non-implemented area. Non-implemented area, for that purpose, my lord, this judgment of the Supreme Court, which says that once the headquarters is covered, then if a notice is issued in Karnataka, all the places all over, even outside Karnataka, if there is a control and conductivity, then they are liable to be covered, ma'am.
53,65,981.
Please, madam.
But what was the total contribution paid?
They had sought for this amount for refund.
They have sought refund of 53
This
lakhs.
much amount, madam, which they
Total
say was
contribution-
erroneously paid.
Are you aware what was the total contribution they had given during that period?
I should ascertain, madam.
Which is that judgment, Supreme Court judgment you refer?
2000 volume 1 SCC 332. I have only one copy, my lord.
One copy, sure.
SCC.
Very substantial question whether this refund is contrary to the judgment of the court.
Yeah. 332. 2001, volume 1. 2001, volume 1 ತಗೊಂಬ.
Is it their case that for that state they have paid a separate
No payment.
contribution?
They say that it's centralizedly processed in Bangalore wherever it is stated. That is their contention, my lord. It's centralizedly processed from Bangalore, and which they fail to note that is a non-implemented area. My lord, previously the implementation issue became important because in
So
a non.
only substantial question is whether this refund order is contrary to the judgment of the Supreme Court.
And
that is
also
the
with
only
a non-implemented area, they're liable to be covered. Now, my lord, you have triple A.
that point is discussed in this judgment.
Please, madam.
So the only substantial question of law is whether this judgment is contrary, whether this judgment was urged before the trial court. Referred in the, cited before the trial court.
It has not been cited.
Transport Corporation of India versus
Not been
Employees
cited,
State
madam.
Insurance Corporation.
A shortcoming on our side, my lord. We have urged the regulations, my lord, which says
Yes,
that.
learned counsel for the respondent, what do you say?
My lord, the judgment relied upon by my learned friend is on a different basis, my lord. It is not covering this particular aspect. With your lordship, I do agree that the only question in this narrow question to be answered, my lord, is that in a non-implemented area, if some payment is made towards ESI contribution erroneously, whether refund can be denied under Regulation 40. That is the whole question. Now, what is the meaning of non-implemented area is covered by two
Employees compensation.
section, subsection 3 of section 1, my lord, subsection 3 of section 1 and
Just a minute, we'll
subsection
take the
5 of section 1. My lord,
Is it your case that you have paid that contribution in another state?
we have paid that contribution erroneously and the ESI
Your
itself has.
contention is that these employees situate in other states, but for them also you have paid it. Is it
My
your
lord, we
case
have-
that you have paid that contribution in some other state?
My
For
lord,
your
this
employees you
particular,
have to pay. If the,
this,
even if this,
this, please, my lord.
for your employees, you have to pay the contribution. You dispute that or concede for that?
No, my lord. My submission is that when there are any employees working in an area which is non-implemented, where the provisions of ESI Act are not implemented, the employees working there need not pay because they cannot avail the benefits there. In fact, the ESI court has gone to the details of finding out whether that area was implemented area or not. In fact, the
if you have
ESI
1,000
itself has
employees,
admitted.
suppose
my
we
lord.
have 1,000 employees in Karnataka, Andhra, Tamil Nadu, and
Please.
only in Karnataka it is implemented.
Please.
So your employees in Andhra and Tamil Nadu are not entitled to ESI benefit?
Exactly, that is my contention. And in fact, the citation
Why that
relied upon.
discrimination in your
It is
amongst
not
your
a discrimination,
employees?
my lord. In order to answer that, kindly come to subsection 3 of section 1, my lord.
1 second. wait a
The
second.
entire
Subsection 3 of
the act will come into force only in areas where it is declared.
One
That is the way this act works, my
Subsection
lord.
3 of section 1. No? Yes.
Subsection 3 of section 1, my lord.
Yes.
Two conditions must be satisfied. Two conditions must be satisfied for the act to come into force. The first condition is subsection 3 of section 1, my lord. If I may be permitted to read the subsection 3, it shall come into force on such date or dates as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different provisions of the act. And this is important, for different states or different parts thereof. So the first step is the central government must identify an area and say that in this area, this act is going to be implemented. That is the first step. That is the central government has to make this order under subsection 3, my lord. That is not enough. Then further, subsection 5 of section 1, the appropriate government. Now the appropriate government comes into picture. The appropriate government may, in consultation with the corporation, where the appropriate government is the state government, etc., after giving 1 month's notice of its intention of so doing by notification in the official gazette, extend the provisions of this act or any of them to any other establishment or class of establishment, industrial, commercial, agriculture, or otherwise. So what it means, my lord, is that subsection 3, first of all, identifies the area where the act must come into force by the central government. Secondly, the appropriate government must specify which are the establishments in that area which come under the act. Now, in this case, the department itself has admitted that the area in question is a non-implemented area. They themselves have admitted. Kindly come to page 16 of the impugned order, my lord. Page 16 of the impugned order.
Internal page 16. Yes.
Page 16 of the impugned order in ESI application 43 of 2013.
Yes.
Para 18, my lord. They have reproduced the letter from Sub-Regional Office, Pune, Employee State Insurance Corporation, Panchadeep Bhavan, Pune. It is addressed to Infosys, and the subject is implementation of ESI Act. And then in page 17, they say, with reference to your letter dated 4/11/2009, I have to inform you that plot number 24 Rajiv Gandhi Infotech Park, Village, Man Taluka, Munshi, Pune, falls in non-implemented area. They themselves accept, they themselves admit that it is a non-implemented area. Now,
This
kindly
is
come to the
issued by
definition.
ESI office only.
Please, my lord, it is the ESI office itself has admitted.
Yes.
And only after that, we took steps to say that we have by mistake, we have erroneously, we have submitted the contributions, kindly return it back. And then they took the stand that under regulation 40, you cannot
So
ask
they
for.
say that they have withdrawn this notification.
No. This notification continues. This notification has not been
You
withdrawn.
submitted later, they said that they have wrongly issued this and they are withdrawing it.
No. They have not wrongly issued it. This stands. Even today it stands.
Even today, it is in force.
Please, my lord.
So,
The whole question is this, my lord.
then what
The
this
definition
judgment
of contribution.
whether this judgment says that This shall
Huh.
apply, this covers the non-implemented area also?
No, no, my lord. That is why I made the distinction between subsection 3 and subsection 5. The judgment which is quoted by my learned friend pertains to subsection 5. It never mentions subsection 3. It never mentions subsection 3 because the issue before the Supreme Court in Transport Corporation of India case was with respect to subsection 5.
What section, subsection 5 says?
Subsection 5 says the appropriate government may, in consultation with the corporation, after giving 1 month's notice of its
No, it
intention
appears
of,
the subsection 5 is deleted by Amendment Act 2010. Oh, get citation on that.
no, my lord. No, no, my lord.
See, in our book, we are seeing 1(4) is contribution. 4 is definition of contribution.
No, my lord. I'm reading in section 1. Section 1.
Sorry, we are reading.
Section 1, my lord.
5. Correct. 5 you
Subsection 5
already
of
read,
section.
no? So this was dealing with the same provision, section 1, subsection 5, which you already read.
Although, that is what I'm saying. The Transport Corporation of India judgment, which is relied upon by my learned friend, pertains to subsection 5, whereas I am on subsection 3. The question of subsection 5 comes. The question of subsection 5 comes only if it passes the test of subsection 3.
Now, the two issues that arises, my lord, is that whether the establishment, when we have to, what is considered by the ESA Act court, my lord, is also why we have rejected this. Regulation 40 specify the period within which you have to seek for refund, which is erroneously paid. And that is time barred. We have rejected on
So
that.
you have taken up that ground also. It was barred by.
That is the ground that has been
So
rejected.
when that payment was made and when its refund was sought?
Refund was sought, my lord.
Payment was made in between 2007 and 2009.
Please, my lord. 2009, they made the payment.
Refund was sought on 31/12/2009. What is the limitation? Where is the limitation?
Lord, regulation 40 of the ESA regulation.
Regulation 40.
And regulation 4. Regulation 40 specifies
What it says?
Find it, ma'am?
Yes.
Refund of contribution erroneously paid. Any contribution paid by a person and erroneous belief the contribution was payable by that person under the act may be refunded without interest by the corporation to that person if application to that effect is made in writing before the commencement of benefit period corresponding to the contribution period in which the contribution was paid. When any contribution be paid by a person higher rate, then the excess amount can seek for the.
Now, what is this benefit, corresponding benefit
May
period?
I take your lordships to regulation 4, my lord?
Regulation 4.
4.
Sub-regulation 4.
No, my lord, same. This is 40 we are saying for 4. 4.
Yes.
Regulation 4. Contribution and benefit period.
Yes, what?
May I read, my lord? Contribution period and corresponding benefits period shall be as under.
One
The
second.
contribution period.
We are
was-
referring to.
Within the period.
40 again 4. What is the regulation?
Alla, 40 by 4, 4, regulation 4, my lord.
I'm looking 40 by 4 or?
There is a
Yes,
chart.
4. Yes.
Your lordships could get the chart, my lord?
Yes, 4.
Now, the contribution for the 1st April to 30th September, the corresponding benefit period is 1st January to 30th June. So, my lord, they had to make before, for this period of 1st April to 30th September, they should make before the 1st January. That's when the entitlement starts to roll on. Whether they claim, they don't claim, it's immaterial, my lord. So, they had to make the benefit, they had to seek the benefit so that the amount will not be dispersed for that purpose. Now, for the 1st October to 31st March, the benefit period is 1st July to 31st December. So now we have rejected on the ground that your claim was after the the benefit period had commenced, and therefore you are not eligible for refund.
So there are 2 points according to you. One is that covered the non-implemented area also, And the second one is the claim was beyond this corresponding period. Benefit period.
Please,
So
ma'am.
that will be the, those two will be the
Will be a
substantial
substantial
questions. ಮತ್ತೆ ನೀವು ಹಾಗೆ ಮಾಡಿಲ್ವಲ್ಲ?
I will,
ನೀವು ಹಾಗೆ ಬರ್ದಿಲ್ವಲ್ಲ ನಿಮ್ಮ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ?
in fact, the appeal memo discusses in great detail what is the definition of contribution and when does contribution become payable.
The first question of law is the refund contrary to the provisions of ESI Act and regulation. That is,
Very omnibus.
it's under regulation 40, whether it has to be, that is the one should be the
My lord,
question of law.
The second one was it covers the non-implementation.
Once the headquarters is covered, every
ನೀವು ಅದು
unit,
ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ. These aspects are discussed in this judgment.
that's there, my lord. The court says, the Supreme Court says, takes the view that I have taken that contention in these, one of the grounds I have taken,
Yeah.
my lord, but
You said this judgment is contrary to the impugned award is contrary to this judgment. Whether this judgment has discussed these 2 points.
the second point
No,
is
my
there.
lord. No.
That is the
No,
Which
my lord.
paragraph?
non-implemented area. The point the court makes, my lord, that if a non-implemented area, the headquarters is covered, if there is a connectivity, if there is a control and management of
Which
the
paragraph? Show us. Judgment and source ಯಾವ paragraph?
last paragraph of the note.
ಅವ್ರು you are a mighty corporation.
Sorry,
ಒಂದು
my lord.
judgment ಹಿಡ್ಕೊಂಡು ಬಂದು.
Sorry, my lord, that's the reason I
My
made
lord,
a mention.
my lord, may I make
Both of you are mighty corporations. Yes.
may I make a submission, my
I
lord? May I
apologize,
make a
please.
submission? I have another judgment of the Honorable Supreme Court which covers the question of subsection 3 of subsection 1, section 1. If your lordship may take up this on another day, I will come physically and argue this matter. My lord.
No, we'll admit on these 2 points and then we can hear you, both of you.
Please, my lord, please, my date may be fixed. Any
That-
date, I am ready to come
Trial
and
court
argue
has
the matter.
considered that aspect of this, the second.
Please, please, it
this,
is considered, it is a very
corresponding
elaborate
period
judgment.
That has been considered.
Considered.
That has not been
And that
considered.
is overruled.
That no, my lord, the court says that refund is not correct. That's all. The non-implementable area, so they are therefore they're liable to.
One point was whether it covers the non-implemented area also. That is answered against you. This claim being beyond corresponding benefit period.
That is answered against us.
I will
considered.
answer that, my
That was
lord.
considered,
That is also in
considered.
favor of me. That is
That
also
was
in
It
favor
was
of me.
within a period ಅಂತ ಹೇಳಿದಾರೆ.
ಇಲ್ಲ, ಅದು ಹೇಳಿಲ್ಲ. But
ಇಲ್ಲ,
erroneous
question of
payment,
period.
non-implemented area, so therefore is eligible for refund.
So this period,
Question of-
limitation period.
That was not looked at in the perspective which is there in the act.
I will answer that, my lord. The question of limitation does
We'll
not arise
admit
at all.
on these 2 points. We'll admit on these 2 points, then you can argue.
Please, my lord, please, my lord.
Whether. Implies in the ASI code. Under the ASI code. Committed error in molding that. The contribution, no?
Please, my lord, contribution.
Does not cover. Contribution paid does not cover the non-implemented area.
Whether the payment of contribution.
The very definition of contribution rules out payment of contribution in a non-implemented area, my lord. Kindly come to subsection 4 of section 2, definition of contribution.
The regulation
40.
40.
Read with full. The finding of the ASI code that the contribution made by the respondent was refundable is contrary to regulation 40 and 4 regulation 4 of ESI into bracket general regulations 1950. Number 2, the appeal is admitted to consider the following substantial questions of law and technical. Number 2, ಇನ್ನೊಂದು ಯಾವ್ದು ಲಿಮಿಟೇಷನ್ ಹೇಳ್ತಾನ ಅಲ್ಲ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಬೆನಿಫಿಟ್ that covers is regulation 40 and rule 40.
Regulation 40 only prescribes the limitation period for which it is.
ಸರಿ ನಾನ್ ಇಂಪ್ಲಿಮೆಂಟೇಶನ್ ಏರಿಯಾ ಯಾವ್ದದು
Pune, my lord.
ಅಲ್ಲಲ್ಲ ದಟ್
Subsection 3 of section 1, my lord.
ಅವರ ಪ್ರಾವಿಷನ್ ಇನ್ನೇನು ಓದಿದ್ರು Regulation 40 ಅಲ್ಲ. Section 3 ಅಲ್ವಾ ಅದು? ಅಲ್ಲ, section
Ah,
1(5).
1(5) and 1(3). 1(5) and 1(3).
Section 1 into bucket 3 and section 1 into 5 of the ASI Act.
Please, madam.
Number 2, whether the impugned order of refund of contribution is contrary to regulation number 40 and 4 of Employee State Insurance General Regulations 1950. These points. Records ಬಂದಿದೆ ಅಲ್ಲ?
ಬಂದಿದೆ.
Final hearing. After, when do you want it for final hearing? After 2 weeks.
Next week, my lord.
2 weeks. Want a date?
Any date, my lord, any date.
11/6.
Please for final hearing on 11/6.
Seal number
Please, madam.
29.
Please.
Gita Devi MP.
Interesting.
Lord, this establishment is covered under the ESI Act. My lord, there was belated payment of
They are
contribution.
not appeared, though served.
Regulation, my lord?
Respondent served unrepresented.
Unrepresented, my lord.
In the non-filing of memo to clarify
The
the
court
position.
had asked us to clarify because we had sought for the respondent, how they had described themselves in the ESI code. We have put them as management of Scott's garments. So ಯಾರ್ represent ಮಾಡಿದ್ರು, ಆ ರೀತಿ ಯಾರ್ ತಗೊಂಡ್ರು, ಆ ತರ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರು. So my lord, the clarification, I mean, now in the code below, how they have described themselves, we have put it in that same manner in the appeal memo.
Accordance with the aforesaid provision of law. Where, when, on which date that clarification was sought?
In the last date of hearing, my lord, the previous date of hearing.
In 7th hearing. However, the ranking of the respondent in this appeal and before the ASI court has not been clarified. The respond management has not been represented. Even before the ASI court, they were not represented.
Lord, they themselves have filed the appeal. There's an error in description. Normally we write represented by so and so person. ಅವ್ರು ಅದನ್ನ ಹಾಕಿಲ್ಲ. Management ಅಂದ್ರೆ ಯಾರು, person ಅಂತ ಹಾಕಿಲ್ಲ. The description is erroneous.
ಅಲ್ಲಿ ಯಾರ ಮೇಲೆ ಸರ್ವ್ ಮಾಡಬೇಕು ಅಂತ.
Management ಅಂದ್ರೆ
Now they have management and there should some person to receive that. Who has received the notice? At least who tendered the evidence, you could have showed him. Now whether the service is complete. Girish HJ, who is that?
I shall take care of that, my lord, in the next time, my lord, because now I see that the
Right,
one who
they
led
made a
evidence,
mistake.
Girish ಅಂತ ಮಾಡಿದ್ದಾರೆ evidence.
Now who is he? What is his post?
He may be the manager, my lord.
And at least
There are connected matters in this matter. I'll bring up all those together, my lord.
you do one thing so that if he has appeared in that case, we can ask the advocate to.
I'll ensure about this.
In the other cases, they are represented or unrepresented.
I will have to ensure, my lord. In those cases also, there were some problems in that. I'll ensure.
Because there should be, any institution should be represented by a living person.
Management ಅಂತ ಅವ್ರು ಹೇಗೆ describe ಮಾಡೋದು, council, Mr. K.R. Anand represented them in the trial court.
KR Anand ಇಲ್ಲಿ ಬರ್ತಿರ್ತಾರಲ್ಲ,
ಬರ್ತಿರ್ತಾರೆ.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿಬಿಡಿ ಹಾಗಾದ್ರೆ. We'll direct you to
Permit me to serve copy on them, my lord.
We'll direct you to serve.
Very well, ma'am. Very well.
The records should not. Before the ASI court also. The name of the person or designation, name/designation of the person who represents. Respondent was not mentioned. However, Shri K.R. Anand, learned advocate, was representing the present respondent in the trial court. Therefore, the clerk also for the appellant is permitted, is directed to serve the notice on Shri K.R. Anand, learned advocate. The registry shall show his name in the clauses for the respondent. Please come, you serve on him so that.
I'll do that, ma'am.
Next week. 5/6. You serve him in advance. In a
I'll do
longer
that.
date.
11/6, the other matter is 11/6, and that
11/6.
day, 11/6. Plus.
Seal number 30, M. Narayan Swami, DGA.
I appear for the respondent in this case.
Yes, sir. In memo for having served the copy to response advocate.
They have not served that copy to me.
They are not served.
They have not served.
2018 matter ಬರೋದೇ ಇಲ್ಲ. Admission. ಇದು ಏನು ಒಂದ್ಸರಿ ಡಿಸ್ಮಿಸ್ ಆಗಿ ರಿಸ್ಟೋರ್ ಆಗಿರೋದ ಹೇಗೆ? Medical ground of the appellant's counsel last time. See, 10/11/2021 order was passed to serve you. Correct, ಆಗಿದೆ ನೋಡಿ. We rightly anticipated. 2/9/2021. 6/2/2020 it was dismissed once it seems. ಹೌದು, correct. ನನ್ನ ಕೇಸ್ ಆಗಲ್ಲ. ಡೆಫಿಸಿಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. Referendary order. No representation for the appellant. Learned AGA submits that the copies are not served on him. The records show that this appeal was already once dismissed on 6/2/2020. For non-compliance. Finally, 10 days time is granted to do the input, failing which the appeal shall stand dismissed. Please stand 10 days on the meeting.
11/6.
Cost of
11/6. Number 31, Venu KV, Arjun Rao, Dimitri Ebert.
My lords appear for respondent.
You have submitted the records now?
Yes, my lord.
No, in this trial court records, single judges records.
The single judge's compilation, I've kept it ready, my lord. If my lords may permit me, I'll file it in the court. I have it ready.
Yesterday you said you will submit it, otherwise how do we proceed with the matter? You don't
Because I
have.
have it ready, my lords.
My lords, one humble submission. Today, the senior counsel from Kerala is appearing in this matter, hoping that he would appear, but unfortunately, he is not keeping well. And we have also noted that 2 additional interim applications has also been filed by the other side. So there is already IA-3, which is a stay application. In addition to that, a new IA has been served to us yesterday, which is also for stay of the proceedings in CP. There are some additional grounds raised, and we would require time to file objections in both the new interim applications as well. So if lordships may post the matter to next week, senior counsel will also appear physically, and our objections will also be on record, and the matter can be heard for admission on the appeal as well as hearing on the interim applications.
My lords, my only request is if the matter can be kept any day on Thursday or Friday, my lords, there's an
No,
urgency.
you file it in the register. See, unless we have the records of the
My lords,
case.
I'll file it today. I'll file it today, my lords.
Yesterday you said it's submitted.
My lords, maybe on the first week of June.
Learned counsel for the.
My lords, my only submission is that, my lords, my client is incurring heavy costs, my lords.
All
for
right,
the-
madam, you first, you file the records. All
That's another thing I wanted to point
proceedings,
out.
this petition and other documents which were produced, statement of objection, all you produce copies.
I will, my lords, file it in the course of the day. My lords, another submission, my lords, I wanted to point out. My lords, if my lords may see there's a dispute between the parties under the Admiralty Act, my lords. If my lords may refer to the Commercial Courts Act, my lords, it says under section 3 of the Commercial Courts Act, it says any dispute which relate to maritime law or admiralty law will be a commercial dispute, my lords.
Have you raised this point before the single judge?
Oh, my lords, that is not raised. My lords, I just wanted to point this out because, my lords, it will be a commercial dispute between the parties.
They could have raised before the single judge even now. Even now, before the single judge, you could have urged that point instead of urging here. If you say that there is bar of jurisdiction or bar of jurisdiction by law, now that probably.
My lords, the single judge matter is due to be listed tomorrow, my lords.
Right, now you are saying that this should go before the commercial courts,
Correct, my
right? You have not urged it before the single judge till now. You can bring it to the notice of the single judge, the single judge may consider that.
Lords, if my lords may
Where
even
is
see.
this? If this matter is stayed, then you can't consider that.
My lords, I am just asking for a stay of the sale application, my lords.
My lords may not be stayed, my lords, because
Now you produce the documents, we'll consider it later.
My lords may keep it
Not
on
also for
Thursday,
the
my lords.
appellant.
There's an urgency, my
Next
lords,
time
in the matter.
to produce.
my lords maybe in the first week of June, as senior counsel is not well to travel this week.
In
My lords, he can appear through
What is that?
VC.
CP number 56 of all the records submitted in CP number 56 of 2024. Okay. Now counsel for the respondent also 6 time. List on. No, we'll fix some date. We can't.
My lords, sorry.
Yesterday you sought 1 day adjournment.
My lords, we are traveling from Kerala, so if there's a specific date, we need to book
Madam,
everything in
They can
advance.
appear virtually. Or they can
My lords, last
instruct
night
you to
also we
appear.
received
We
a
can't.
call asking only for accommodation. for
Now there
one
is an order for sale of the properties.
My lords, there is no order. There is no order. Only the application is filed.
Correct. RS, you said there is sale being held.
My lords. the
No, my
same
lords.
Application, my lords, they have filed before the learned single judgment.
That is not yet considered, no.
It is only in the filing of objection stage.
Date
Maybe next week, my lords.
on the date. When do you want?
My
Last-
request is it may be kept on Thursday or Friday, my lords.
Tuesday.
My lords, every day, my lords, I'm incurring US dollars of 20,000
When
rupees.
you only did not submit the records. We had asked you.
I have it ready, my lords. I will
If you
submit.
hold it in your hand and you say now I'll produce, you hear us now only, we can't do that.
My lords,
We
I'm
too need some
requesting for
time.
either Thursday or Friday, my lords.
Friday is half day sitting.
My lords, Thursday, my lords may consider. my
ಅಲ್ಲ
lords.
Monday. Thursday ಬೇರೆ ಸ್ಪೆಷಲ್ ಬೆಂಚಸ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆಲ್ ರೈಟ್ ಮಂಡೇ ಫಿಕ್ಸ್ ಮಾಡಿ ಮಂಡೇ 3-6 Cell number 32 B Latif. Suspension of why 2 days? ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ
And for the appellant,
ಬಂದ್ರಲ್ಲ ನಿಮ್ ಜೂನಿಯರ್ ಅವೈಲಬಲ್ ಇಲ್ಲ ಅಂತ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
I was held up in court.
ಆಲ್ ರೈಟ್ ರಿಲ್ಯಾಕ್ಸ್.
Not this circumstantial evidence. The appellant was on bail during the trial. And the trial court is convicted solely on the ground that last seen theory, not the last seen theory what they relied, saying that all the accused number 1 to 4 were found together, not with the deceased. They are suspecting that they might have committed murder. And so far as recovery is concerned, they recovered my pant and shirt.
In all 4 accused were tried.
Please,
In all 4 accused were tried.
right.
How many of them are convicted? This is
All
is accused
four.
number 4. There are other connected appeals.
Not,
They are not preferred appeal.
not filed appeal. And recovery is concerned,
What is the old act against this accused?
individual overtax, no eyewitnesses. They are relying that they are seen together in near a Baraka factory in the midnight together by accused number 1 to 4. And thereafter the dead body was found at that place. Last in witnesses PW 10 to 13, what they are relying, they say that all the accused are standing together. They are identified accused number 1. Except that the recovery, bloodstained clothes was sent, that the FSL was not supporting. Nothing was found in my clothes.
What is the other evidence against you? What are the total circumstances against you?
2 circumstances.
The last scene.
Last scene. That is not the last scene. They are saying that we are not together with the deceased. They say that, well, I am going to the boat four accused are standing near a Baraka factory. Having accused number one, they identified the accused number one as Asif. He is having a deadly wooden piece in his hand, and one of his colleague didn't reach the boat, and thereafter they came to know that he was found dead at the place. After they
So
returned.
when they cited this accused, they did not cite the deceased also.
Not cited.
They were not seen together.
No. They say that they might have committed murder ಅಂತ ಹೇಳ್ತಾರೆ. That is the last thing they were relying.
Circumstance?
Another circumstance, the recovery of clothes at the
Clothes of?
instance of
Whose clothes?
my clothes.
Oh,
In that note, FSL report is not
from
supported.
which place they were?
That is
seen?
in my house.
In your house, bloodstained clothes.
Bloodstained clothes, they are sent to FSL. Bloodstains were not found.
Blood group did not match.
Bloodstain itself is not found.
Stain itself was not found.
Not found.
Only these two circumstances.
Two circumstances what they relying against me.
What according to you?
Please, your lordships, the accused number 4 has also been identified in the test identification parade, your lordships.
No, no. Case is based on circumstantial evidence.
Please, your lordships.
What were the circumstances against this accused?
Your lordships, wooden clubs have been recovered, your lordships. There are 6 wooden clubs and
At his
clothes.
instance?
At his instance itself.
That is joint.
Giant recovery, no?
Accused number 3, 4. In his presence, from accused number 3 and 4. They have
Correct.
produced 6
What was
wooden
the,
clubs.
in whether they were stained with blood, from where they were recovered?
Your lordships, from the tiles factory.
Tiles factory, of whose tiles factory?
Near from the side.
Nearby from the bushes from
Open
the
place.
dilapidated tiles factory and by that.
Oh, whether those witnesses have supported?
They have
Because-
supported, your lordships.
Right, was there any blood stains on this?
No. No bloodstain.
And even in test
No,
identity.
we are asking you a question, whether these wooden clubs seized at the instance of these accused, whether they were stained with any blood? And whether there was any,
Lordships, blood-stained clothes were recovered, your lordships.
that he submitted, but according to him, even FSL report did not show any blood stains on those clothes.
Please, your lordships.
And
There is-
throughout the trial, I was on bail.
Where is the discussion about that?
So far as last seen theory is concerned,
Not
paragraph
last seen.
42. Paragraph 42.
Para 42.
42, my lord. One by one I will come. 42 is concerned the last. Yes. PW 10 to 13 are deposed at the court that they were left to their place, attend their work at 2:30. On the early morning at 12:40, PW 10 Sasidhar Puttan deposed at court that he along with PW 10 so and so together went to the fishing for their work to Kotapura Jatti. And they were followed by PW 12 Mukesh and 13 Avinash Kotian. PW 11 to 13 reiterated the same in their evidence. PW 13 to depose before the court that they witnessed the number 1 to 4 and other two near the petty shop in front of Baraka factory yielding wooden clubs. In the cross examination, PW 10 has admitted he cannot specifically depose as who were all holding the clubs when he saw the accused near the petition. This is the discussion about
Right,
last
this is
scene.
about last scene. That
Nowhere they say that deceased are together.
correct.
And the bloodstain close is concerned, paragraph 58.
No, FSL report where it is discussed.
58. Paragraph 58.
Hmm.
PW 17 and 21 are deposed before the court about recovery of bloodstained clothes at the instance of Exhibit 3 and 4 and child in conflicting of law as per Exhibit P 21. Investigation officer produced the photographs of recovery of clothes before the court at Exhibit P 25, 26, 27, 28 to 30. Investigating officer also produced the video clippings of recovery of clothes in instance of Exhibit 3 and 4 as per Exhibit P 29. Punch witness are deposed the recovery of bloodstained clothes in instance of Exhibit 1 in his presence to Panchanama marked as Exhibit 22. Investigation officer produced the photographs at marked as exhibit P
Right,
30th.
even assuming that the recovery is proved, that there was any FSL report, whether that is discussed before the. in the
ಅದ್ರ
trial.
ಬಗ್ಗೆ ಡಿಸ್ಕಸ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನನ್ನ ಮೇಲೆ ರಿಕವರಿ ಆಗ ಬಗ್ಗೆ ಡಿಸ್ಕಷನ್ ಮಾಡಿಲ್ಲ.
Even assuming that it was recovered and the recovery was proved, you submitted that FSL report, there was nothing incriminating in the FSL report.
ಹೌದು.
Whether that point is discussed.
That was not discussed.
Scientific evidence ಅಂತ ಇಲ್ಲೇನೋ ಮಾಡಿದಾರಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅದು DNA ಇವ್ರದ್ದು ಬ್ಲಡ್ ಟೆಸ್ಟ್ ಮಾಡಿರೋದು ಬ್ಲಡ್ ಸಿಕ್ತವ್ರು.
Identity of the dead body fixed.
ಪ್ಲೀಸ್
FSL report ಬಗ್ಗೆ
ಡಿಸ್ಕಷನ್ ಮಾಡಿಲ್ಲ. ಐ ಹ್ಯಾವ್ FSL ಕಾಪಿ. ಮಾರ್ಕ್ ಐ ವಿಲ್ ಪಾಸ್ ಆನ್.
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆಯಾ ಕೊಡಿ ನೋಡೋಣ.
FSL ಇದೆ. ನಂದು 11 and 12.
Exhibit P11 and 2. You said blood stains were not clearly found on that.
Not
Cross
found.
ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದು. 11 ಮತ್ತೆ
Not traced. 11 ಹನ್ನೆರಡ.
11 12. Thank you sir.
ಕರೆಕ್ಟ್ ಇದು ಎಲ್ಲಿದೆ ಅದು ಫೈಂಡಿಂಗ್
ಅಲ್ಲಿ ಕೊನೆಗಿದೆ. ಅದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೆಥಡ್ ಆಯ್ತು. Observation.
Blood stains were not detected in item number 6, 9, 11, 12. Paragraph 43 ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
Paragraph 43 ಅಷ್ಟು
262 ಅಲ್ಲ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ FSL ಅಲ್ಲಿ.
ಇಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ. Paragraph
62. Page number 43 of internal pattern. In page number 53. Blood stains were not detected in item number 2, 6, 9, 11, 12, 13, 14.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅದರಲ್ಲಿ ಕೆಳಗಿನಿಂದ ಪೇಜ್ ಪ್ಯಾರಾ 43 ಇಲ್ಲಿ ಮೇಲೆ ನೋಡಿ 2, 6, 9, 11, 12. Reverse is 11, 12. Blood stains were not detected. Yes, madam. Blood stains were not detected. He was granted bail during the trial.
He was on bail duty.
He is aged 25, na? Admit ಆಗಿಲ್ವಾ ಇವನು? ಇಲ್ಲ. 32 for admission. Matter requires detailed consideration. Admit, call for TCRs. Paper book shall be prepared within 8 weeks ಮಾಡ್ತೀವಿ ಯಾಕಂದ್ರೆ ಸಸ್ಪೆನ್ಷನ್ ಕೊಡೋದು ಆರ್ಡರ್ಸ್ ಅನ್ನ 1 of 2020 within 8 weeks on receipt of a TCRs. Orders and 1 of 2024. The appellant was accused number 4 before the trial court. The appellant and accused number 1, 2, 3. He is 4 alone.
Out.
By the infringement in order, the appellant and accused number 1 to 3 are convicted for the offences punishable under section 143, 148, 153, 302, 201, related section 149 IPC. The charge against the accused. Charges against the accused. For that, the accused, along with 2 juvenile offenders, along with 2 children in conflict with law, we do not call them as in conflict with law, due to communal hatred during the forming themselves into an unlawful assembly during the intervening night of 11/12/4/2016, committed the murder of Rajesh Kotian alias Raja by assaulting him with wooden clubs and to Screen his identity, disfigured his face. Disfigured his face. Next one. The case is based on circumstantial evidence. There are no eyewitnesses to the incident. The circumstances relied on the trial court are that the accused, the appellant and that the appellant, the other accused were seen near the scene of offense.
Please.
The appellant and the other accused were seen together near the scene of offense, along with the clubs, the weapons of offense. And the weapons of offense and the clothes of the appellant worn at the time of the offense were discovered at his instance. Next one. The impugned judgment indicates that even according to the prosecution, it was not the accused and deceased were seen together. Only the accused were seen together near the scene of offense. Secondly, the alleged discovery of clubs was a clubs and clothes also joint recovery.
No. Clothes are separate recovery.
Alleged
Clubs
recovery
joint
of the
recovery.
clubs was a joint recovery. Though the clothes of the appellant were allegedly seized at his instance, the trial court judgment, the impugned judgment indicates that as per the FSL report, no blood stains were detected on the clothes of the appellant. During the trial, the appellant had the benefit of the bail, and there are no allegations of he jumping the bail conditions, and for violating the bail conditions. He is aged 25 years. Hearing of this matter may take some time under the circumstances. It is a bit case to grant suspension of sentence. Yes, the following. The application is a no. The impugned or judgment is impugned order of sentence. ಎಷ್ಟೆಷ್ಟು ಫೈನ್ ಹಾಕಿದ್ದಾರೆ ಪೆನಾಲ್ಟಿ
25,000.
ಇದರ ಡಿಫ್ರೆಂಟ್ ಇದಲ್ಲ
ಇನ್ನೊಂದು 5.
impugned order of sentence is hereby suspended and the appellant is granted bail in the above case subject to the following conditions. 25,000 is for 302.
And 201 is 5.
143 ಅದಕ್ಕೆಲ್ಲ ಬರೀ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. 143, 148, 153A ಫೈನ್ ಹಾಕಿಲ್ವಾ? ಆ್ಯಂಡ್ ಅಂತ ಇಲ್ವಾ ಅದರಲ್ಲಿ? ಆರ್ ಅಂತ ಇದೆ ಅಂಡ್ 153A ಫೈನ್ ಇರಬೇಕು. ಒನ್ಗೆ ಸೊ ಸೆಂಟೆನ್ಸ್ ಆಫ್ ಫೈನ್ is imposed only for 302 and 201. Subject to the following conditions. Number 1, the appellant shall execute and sign of the personal bond in the sum of rupees 1 lakh and furnish 2 surety 1 lakh to the member. He furnished 2 sureties in the like sum to the satisfaction of the trial court. He shall deposit the fine amount before the trial court. He shall appear before the court as and when required. Final communicate the copy of this order to the trial court and the consent person. 33. Mar Nanjundagowda.
And for the appellant.
Yes.
This appellant is actually number 2. 2 or 3 persons have faced the trial. Out of trial, both of them are committed for the offences constituted. 114 and 120B, so this 34 IPC is sentenced to undergo RA for life. Distinct sentence is not passed. joint sentence is passed. This case is purely based upon the circumstantial evidence. The appellant was on bail throughout the trial. The circumstances which the prosecution relied upon are that this accused number 1 said to have been paid 10,000 rupees to this accused number 2 to accompany him to take over the life of the deceased. Who deceased thereafter in illicit intimacy with the wife of accused number 1. Then, according to the case of prosecution, as a token advance, he has paid some of his 10,000. And recovery at the instance of this appellant is that one mobile and it is 2,000. This is only the circumstance which the prosecution is supposed to establish. That except this recovery, the CDRs are not good.
Mobile belong to whom?
That is not, that the identification, I'm sorry, that card is not produced.
No, mobile belong to whom?
That is not belongs to me. It does not stand in my name.
No, is it the mobile phone of the deceased?
No, my lord.
No.
So,
Identification.
recovery of mobile phone and
Some of rupees 2,000 at the instance of this.
Hmm.
For that also, no substantial evidence is produced by the state.
only these two circumstances?
Please, ma'am.
Motive and recovery, ashtena?
Motive is that this accused number 1 has taken.
Correct. You submitted about motive. Circumstances relied is motive and recovery.
Yes.
Eradena?
Yes. And said to have been thrown the chili powder on the deceased. That circumstance is not proved by the prosecution. And also said so that I was assaulted in the club on the body of the deceased. That is also not proved. According to the autopsy, the cause of death is due to head injury. That cause of injury is said to have been caused by accused number 1. Purely rests upon the circumstances. I take your lordship's kind leave. He was on bail throughout the trial. Bail was granted by the son of the court at page number 119 with the lordship's kind leave.
Right now, according to these are the only two circumstances.
Yes, ma'am.
The mobile phone did not belong to the deceased.
No.
Assuming that it belonged to the accused himself, that has no incriminating circumstance. SIM card was not seized in that. It didn't bear any SIM card. And this 2,000, it can be not specific identification.
Yes, ma'am.
So far as 2,000. Any other circumstance?
Oh, my lord. That is the only.
Only these two
That is the CDR, my lord, which shows that, my lord, the accused number 2, who was a resident of Bangalore, was in Mysore district on that particular day, my lord, on 29th and 30th of October 2021, my lord. And the CDR also shows that, my lord, the accused number 2 and accused number 1 had conversed with each other over the phone, my lord.
Merely because they converse,
Yes,
they cannot be roped.
That is the
into
only thing I want to.
And merely because he was found in Mysore.
There is no other materials against accused number 2, my lord.
Then on what basis the trial court convicted him?
Please, ma'am.
Are you sure there were no other circumstances?
Yes, my lord, I have read the entire judgment.
Then if that
The
is the case,
para number
he is
100
entitled to suspension if that is the case.
Lord, the relevant portion of the judgment is at page number 108, my lord.
Even if chili powder was found.
Nothing was recovered.
ಇವರೇ use ಮಾಡಿದ್ರು. Chili powder ಇವ್ರ ಹತ್ರ recover ಆಗಿತ್ತು ಅಂದ್ರೆ. Yes, sorry.
Yes, ma'am.
Only these two are the.
Only these two, my lord. There are these.
Why how the trial court convicted?
My lord, the relevant portion is at page number 108.
Page number?
108 of the
108.
petition, my lord. The 73 of the judgment, my lord. Para number 110. Where the trial court has summarized the evidence, my lord. May I read, my lord?
Yes.
Here, as already observed above, the relatives of deceased Nagaraja, for also the relatives of accused number 1, deposed about the illicit relationship of the wife of accused number 1 with deceased Nagaraja. There is no delay in lodging the complaint in this case. In the complaint itself, the name of accused number 1 has been cited, and in the FIR, his name has been entered. The wife of accused number 1 herself admitted the illicit relationship between herself and deceased Nagaraja and also deposed that her husband killed Nagaraja. The CDRs reveal about the conversation took place between the accused
Wife
number
of
one
accused
and-
number one admitted,
Yes, ma'am.
not the deceased.
Not the,
Yes. But
Uh,
she was not the eyewitness.
no, there is no eyewitness, my lord.
Yes.
Only
yes.
accused number one had called the CW16, that is the wife, and told that I have killed him.
But during his lifetime, he had never raised any objection or suspecting
He was suspecting, my lord, there were objections for the illness.
No, was there any proceeding or anything like that?
Yes, my lord.
Any panchayat or anything?
There were certain police complaints between the CW16, who is the wife of accused number one, and the accused number one.
Oh, it was the wife of accused number one. What we are asking is, who is the first person to object for illicit relationship? The deceased. If there was any, during his lifetime, he had not raised any such complaint.
No, my lord, deceased is the person who had the illicit relationship with the wife of accused number one.
So, no, sorry. Accused number one had raised any such.
Yes, my lord.
He had filed any
He had
complaint.
raised, there are evidences to that regard also.
But even otherwise, that was with accused number one, not.
Yes, ma'am, not with accused number two. Right? With respect of accused number two, my lord, only these are the circumstances.
What was the evidence to show that this accused number one had raised objection?
There are police complaints, ma'am.
Police
complaints.
He had filed complaint against deceased.
Yes, my lord. There are matrimonial disputes were there
Bits
between
were
accused
also
number
there. But that
one
is
and the wife.
double-edged weapon motive. Both sides.
Yes, ma'am.
Heard. Matter is constituted consideration, admit, call for TCRs. Paper will be prepared within 4 weeks after the receipt of the, and receiving the TCRs. Orders and I number 1 of 2024. Heard by the impugned judgment and order. The appellant slash accused number 2 by the impugned judgment, the trial court has convicted the appellant slash accused number 2 and accused number 1 for the offences punishable under section 302, 114, 120B, read at section 34 IPC. For the conviction sentence ಎರಡು ಒಂದೇ ದಿವಸ ಮಾಡಿದಾರ?
ಹೌದು.
ಇಲ್ಲ. Conviction was on 16th April. Sentence was ಅವತ್ತೇ ಮಾಡಿದ್ದಾರೆ.
The date is
For the
not mentioned in the
There are
judgment.
ಇಲ್ಲ ಸೆಂಟೆನ್ಸ್ ಕೂಡ ಏನದು? 302, 114, 120B, 34 ಎಲ್ಲದಕ್ಕೂ ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್.
ಹೌದು ಸರ್. Distinct sentence is
ಆಗಿ
supposed to be
ಮಾಡಿಲ್ಲ.
passed by the court. That is not done so also. Very unfortunate. Because the offences are distinct and separate.
That
Separate. distinct
correct,
sentence.
but 114, 120B is same as the major offense ಅಂತ ಇದೆಯಾ?
True. ಇದೆ.
114
actions
ಗೆ
ಅಂತ ಇದೆ.
32 ಬರುತ್ತೆ.
But the level section
For
is
341, they should have been a difference.
supposed to
The
write.
341 trial court has sentenced separately, but 302, 114, 120B IPC ಕೊಡಿ ನೋಡಿ. ಅಥವಾ CRPC.
ಅಂತ ಇದೆ. ಕೊಡ್ಸಿ.
For the offenses under section, for the offense under section 302 IPC. CRPC, schedule ಅಲ್ಲಿ ಇರುತ್ತೆ. One twenty B, same as the abatement of the offense, which is the object of the conspiracy. 114 ಹಾಗೆ ಬರುತ್ತೆ. Same as the offense committed.
ಹೌದು.
Only 341 is the distinct offense, my lord.
Separate sentence.
For the offenses under section 302, 114, 120B, the trial court has sentenced the accused for the rigorous life imprisonment and fine of rupees 50,000. For the offense under section 341, section 34 IPC, the trial court has sentenced the accused for simple imprisonment for 1 month and fine of rupees 500. The charges against the accused, at that accused number, I'm sorry, deceased Nagraj. Deceased Nagraj had illicit relationship with the wife of accused number 1. Therefore, accused number 1 conspired with accused number 2 to commit murder of Nagraj. And he hired accused number 2 / appellant for committing such murder. 114 abatement is for this accused number 2.
Yes, ma'am.
Yes.
And both of them. What is the mode of commission of murder? Accused number 1 assaulted with a club and iron rod.
Iron rod and knife by accused number 1.
What about accused number 2? Overtact of accused number 2?
Overtact is that he assaulted in the club on our body and also on the legs. But no evidence as such.
Assaulted the victim with iron rod. Judgment very iron. Assaulted splashed chili powder on the deceased and assaulted him with iron rod and club and committed his murder.
Strangely.
The case was based on circumstantial evidence. The appellant was ಇವರೊಬ್ಬರೇ ಬೇಲ್ ಅಲ್ಲಿದ್ರ ಇಬ್ರು ಬೇಲ್ ಅಲ್ಲಿದ್ರ
ಇವರೊಬ್ಬರಿಗೆ ಬೇಲ್ ಆಗಿ
appellant was on bail during the trial. Motive recovery ಎರಡೇನಾ?
Yes,
The only circumstance relied against the appellant is that there was recovery of one mobile phone and cash of rupees 2,000. Even according to the prosecution, the said mobile phone did not belong to the deceased. Under the circumstances. The hearing of this matter may take some time. Under circumstances, it repeat case to grant suspension of sentence and bail. This is the following order. I number 1 of 2024 is allowed. Appellant / accused number 2 is granted. Impugned order of sentence. Impugned order of sentence against appellant / accused number 2 is hereby suspended and is granted bail and above is subject to the following conditions. Fine amount ಜಾಸ್ತಿ ಇದೆ ಕಟ್ಟಬೇಕಾಗುತ್ತೆ.
ಫೈರ್ ಸೀರಿಯಸ್ 50,000 ಲೇಬರ್
Previous ಏನು ಹಾಕಿದ್ವು ಅದೇ ಸೇಮ್ ಕಂಡೀಷನ್ಸ್ ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಅಲ್ಲಿ. Communicate the copy of this order to the trial court and consent.
Please.
For further hearings, seal number 34, Kumar Narayan, Rudraj Joshi.
Yes, ಜಶಿ ಅವರೇ 11:11 ಮುಗಿಬಹುದು ಅನ್ಕೊಂಡಿದ್ವಿ ನಾವು. ಆರ್ಡರ್ಸ್
ಇಲ್ಲ ಇವತ್ತು ತಾವ್ ಹೇಳಿದ್ರಿ ಆರ್ಡರ್ಸ್ ಮುಗಿದ್ಮೇಲೆ ತಗೋತೀನಿ ಅಂತ. ಐ ವಾಸ್ ವೇಟಿಂಗ್. ಅದೇನೋ
we wanted to conclude this.
Conclude. My lord, yesterday I was referring to the judgment of this division bench judgment of this court. ILR 2007 Karnataka page 44. There's a Gulati and another case. Wherein particularly we are reading page number 75. My lord has got it. Para number 18A.
Yes. Yes. Yes,
Yes, my lord has got it.
got it.
Para number 18A. What emanates? We stopped at that point.
Yes.
What emanates from the above decision is that in terms of section 120 of the Contract Act, the liability of the appellant surety is coextensive with the liability of the principal debtor, and hence it is not necessary for the first respondent corporation before proceeding against the surety to demand payment from the principal borrower or sue the principal borrower. This is the answer to my friend's question. Principal borrower ಕೇಳಿಲ್ಲ.
Yesterday only we told you.
Why-
You clarify us about limitation ಅಂತ
Clar-
ಹೇಳಿ. Limitation ನಲ್ಲಿ what was the last payment made?
Yes,
The statement of account is marked.
yes.
What was the last installment paid?
No, last installment has nothing to do with this.
Uh-huh.
This is in 2007. 2007.
He was arguing, saying that if the petition is barred against the principal borrower, then it will be barred against the surety also. That is what he was arguing.
ಅದು ಅವ್ರು ಹೇಳಿದ್ರು.
So
ಅದು ಇದು ಅಪ್ಲೈ ಆಗಲ್ಲ. ಬಿಕಾಸ್ ಪ್ರಿನ್ಸಿಪಲ್ ಬರೋರ್ ವಿರುದ್ಧ ನಾವು ಹೋಗೋದೇ ಇಲ್ಲ. We don't go against the principal. That is a division by judgment as well as the apex court judgment. We don't need to go for principal borrower. We need not go to the principal borrower.
correct. For you also there will be some reasonable time iruttalla to go against them also.
That is because of this.
Section Article 137, 3 years from the date cause of action accrues.
ಬರ್ತೀನಿ, ಅದಕ್ಕೆ ಬರ್ತೀನಿ.
Statement of account marked execution.
Para 20 ಬಂದ್ಬಿಡಿ.
Para 20 of this statement,
This judgment. Particularly they have explained
notwithstanding ಅಂತ ಇದೆ ಅನ್ನೋದು.
as regards to the period of remediation.
Yes,
My lord has got it.
yes.
Para 20. At internal page 83. As regards the period of limitation, though it is broadly stated in the counter that the petition is barred by limitation and the date of first notice is to be taken as the starting point of limitation, there is no clear details given as to how such a contention would stand. Full stop. I pause here. Yesterday I submitted on this point because there are many number of notices we give to main borrower and copy we for a warning to the sureties. ನೋಡಪ್ಪ ಅವ್ರಿಗೆ ನಾನು ನೋಟಿಸ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ನಿನಗೆ ಏನಾದರೂ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರೆ ಅವ್ರನ್ನ ಹೋಗಿ ಕರ್ಕೊಂಬ ಅವ್ರನ್ನ. So that is not the demand of surety. Further, it needs to be mentioned that under the first notice, the first respondent corporation had only recorded the entire loan payable by the principal borrower and at the same time had alerted the guarantees to see that something is done to save the company. Under the first notice, admittedly, the first respondent corporation did not invoke the liability of the surety under the guaranteed bond. ಇಲ್ಲಿ ಒಂದೇ ನೋಟಿಸ್ ಇದೆ. There is no separate notices which are produced by them. If at all they have any other contention. ಇದಕ್ಕಿಂತ ಮೊದಲು ನೋಟಿಸ್ಗಳು ಕೊಟ್ಟಿದ್ರು. From that day, the limitation starts ಅಂತ yesterday they have submitted. ಅದನ್ನ ಕೌಂಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಫಸ್ಟ್ ನೋಟಿಸ್, ಸೆಕೆಂಡ್ ನೋಟಿಸ್, how they have framed. ಇಲ್ಲಿ ಅದನ್ನು ಹೇಳ್ತಾರೆ. Even the first notice, second notice only to warn them. Further, under the first notice admittedly did not invoke the liability of surety under the guarantee bond. It is only in the second notice the first respondent corporation invoked the liability of the surety, and if the period of limitation is to be computed from the date of the second notice, the petition filed by the first respondent corporation under 31(1)(a) for enforcing liability of surety, it is well within the time, even if it is to be assumed that the residuary article of 137 is applicable to such petitions. Further, all other contentions, this particular judgment has been referred by the learned trial court judge in this case. My lord, page number 94. Page number 94. From top 94, from top after 11 lines, admittedly, my lord has got it. Page number 94.
This,
Admittedly, when the principal borrower, namely the company, did not repay the loan in spite of the issue of such notice and did not comply with the terms of notice, the first respondent corporation invoked the liability of sureties under the guarantee deed executed by them. This way, by issue of second notice dated so and so under exhibit P2, in this case, exhibit P10, notice issued by the guarantors, including the appellant, the first respondent corporation made it very clear that it notes the deed of guarantee executed by them dated so and so in undertaking to pay. ನೋಡಿ ಇಲ್ಲಿ ಗ್ಯಾಪ್ ನೋಡಿ ಡಿವಿಷನ್ ಬೇಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ 93ಗೆ 84ಗೆ ಗ್ಯಾರಂಟಿ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ, 93 ನೋಟಿಸು. ಇಟ್ ಹಸ್ ಬಿನ್ ಅಪೀಲ್ಡ್ ಬೈ ದಿಸ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ವಿಚ್ ಹಸ್ ಬಿನ್ ಅಪೀಲ್ಡ್. ಅಂದ್ರೆ ನೀವು ಇಷ್ಟು ದಿವಸ ಯಾಕೆ ಸುಮ್ಮನೆ ಕೂತ್ರಿ ಅಂತ ತಾವೇನು ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರಲ್ಲ, ಇದು ಅಪ್ಲೈ ಆಗಲ್ಲ. ಇದು
ನಾವು ಕೇಳಿಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳಿದ್ವಿ.
ಅಲ್ಲಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ದನ್ನ
ಕಂಟೆನ್ಷನ್
ತಾವು ಅವ್ರು ಹೇಳಿದ ಕಂಡೀಷನ್ ತಾವು ಕೇಳಿದ್ರಲ್ಲ ಪ್ರಶ್ನೆ. ಇಟ್ ಇಸ್ ಮೈ ಡ್ಯೂಟಿ ಟು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ಟು ಕನ್ವಿನ್ಸ್ ದಿ ಕೋರ್ಟ್. Undertaking to pay the amount in case the borrower company has failed to pay the amount of the corporation to the corporation. Instead of this, if they fail to pay the amount within 15 days from the date of the notice, corporation will be considered to take constraint to take a legal notice, a legal proceeding to recover the amount from them. It is by this notice, exhibit P2, in some case, exhibit P10, the first respondent corporation revoked the deed of guarantee executed by the appellant. Obviously, when the appellant and the other guarantors did not pay the amount and did not comply with the terms of the notice, so and so, the right to sue accrued in favor of the first respondent corporation to initiate the proceeding against the appellant and other guarantors under the 31(1)(a) of the SFT Act. I pause here once again. My lord, is being a managing director and a guarantor or a surety, he only has challenged this as by a way of appeal, whereas the other judgment debtors.
What have you done to them? Now order against them has attained finality.
Yes.
Have you proceeded against them to recover?
ಅದನ್ನು ಪ್ರೊಸೀಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಇನ್ನೂ ರಿಲೈಸ್ ಆಗಿಲ್ಲ.
Any amount is recovered?
Is not yet.
Why
Not-
they don't have any assets?
Not yet.
This
Not
one-
yet. We are not received.
You have filed a execution case?
ಎಕ್ಸಿಕ್ಯೂಟ್ ಪ್ರೊಸೀಡ್ ಮಾಡ್ತಾ ಇದೆ. ಮತ್ತಿದು ಪೆಂಡಿಂಗ್ ಇದೆ, ಇದು ಸ್ಟೇ ಆಗಿದೆ.
ಇದರಲ್ಲಿ ನೋ ಸ್ಟೇ.
ಇದರಲ್ಲಿ ಇದು ಪೆಂಡಿಂಗ್ ಇದೆ.
Correct, this is of the year 2012.
2012.
Whether you have filed any execution case against them or not
ನಾನು
against them?
ಚೆಕಪ್ ಮಾಡ್ಬೇಕಾ? ಇನ್ನು ನಿನ್ನೆ ನಾನು ಚೆಕಪ್ ಮಾಡಿದೆ. ಇದು ಹ್ಯಾವ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಎನಿ ಪೇಮೆಂಟ್.
Correct, ಇವ್ರು ಎನ್ಫೋರ್ಸ್ ಮಾಡಿದಾರ ಅಂತ.
ಅದನ್ನ ಚೆಕಪ್ ಮಾಡಿ ಫರ್ದರ್
KSFC ಅವರು ಒಂದು ಆರ್ಡರ್ ತಗೊಂಡ್ಮೇಲೆ ನಾವು
ಮಾಡೋದು.
ಸ್ಟೇನು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. He said there is no interim stay in this case also.
ಸ್ಟೇ ಇಲ್ಲ.
Then you could have
ಇವ್ರು
proceeded.
ಅಮೆರಿಕದಲ್ಲಿದ್ದಾರೆ. ನಾವು ಯಾರ್ಯಾರನೋ ಕರ್ಕೊಂಬರಕ್ಕೆ ರೆಡ್ ಕಾರ್ನರ್ ನೋಟಿಸು ಬ್ಲೂ ಕಾರ್ ನೋಟಿಸ್ ಎಲ್ಲ ಕಳಿಸ್ತಾ ಇದೀವಿ, ಅದೇ ರೀತಿ ಇವ್ರನ್ನ ಕರೆಸ್ಬೇಕು ಅಲ್ಲಿಂದ, ಇದೆಲ್ಲ ಮಾಡಬೇಕು. ನಾನು ಫರ್ದರ್ ಬರ್ತೀನಿ.
And even your people want only a paper decree. Your KSFC people want only a paper decree because against the others, more than 12 years now,
Yes,
they are not proceeded.
the period of limitation under 137 is 3 years, which commences from the date when the right to apply accrues.
Yes.
ಇದನ್ನೆಲ್ಲ ಗ್ಯಾರಂಟಿ ಬಗ್ಗೆ ಎಲ್ಲ ಲಿಮಿಟೇಷನ್ ಬಗ್ಗೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದಾರೆ. ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೇಜ್ 95. I need not read.
Trial court has discussed that.
Uh,
Refers to some, and it refers
Yes.
to the clause of the agreement.
Yes.
It refers
Now,
to section 31AA it seems.
yes, now,
Refer ಮಾಡಿ,
now
unless
I am,
there is clause.
I am coming to another point. 128
SFC Act.
SFC Act ಜೊತೆಗೆ Contract Act 128. Time and again, even the previous round of argument also. Previous round of arguments as well as yesterday. (31)(1)(a) enforcement of the liability of surety.
Yes.
My lord, may please to look into the.
The trial court has discussed, it says 31 refer ಮಾಡುವಾಗ without prejudice to the provisions of section 29 of the act.
29 is for the primary assets.
That's what.
ಆ ಪ್ಲಾಂಟ್ ಮೆಷಿನರಿ ಸೀಸ್ ಮಾಡಿದ್ರು. ಅದನ್ನೇ ಅವ್ರು ಹೇಳಿದ್ರು, ಪ್ಲಾಂಟ್ ಮೆಷಿನರಿ ಸೇಲ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ದುಡ್ಡು ಬರ್ತಿತ್ತು, ಆವಾಗ ಬರ್ತಿತ್ತು, ಅದನ್ನ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅಲ್ಲ ಹೇಳಿದ್ರು. Now we come to the Contract Act. My friend has forgotten to submit. My friend has skipped for submit regarding 128 of the Contract Act. ನೋಡಿ ಎಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿದೆ ನೋಡಿ. ಮಾವಿನಹಣ್ಣು ಸೀಸನ್, ಯಾವ ಟೊಂಗೆಯಲ್ಲಿ ನನಗೆ ಹಣ್ಣು ಉದುರುತ್ತೋ ಅದನ್ನೇ ಅಳಗಾಡಿಸ್ತೀನಿ, ಹಣ್ಣು ಬರುತ್ತೆ, ಬೇರೆ ಎಲ್ಲ ಕಾಯಿಗಳಿರುತ್ತೆ. 128, a guarantee which extend to a liability of surety is coextensive with that of the principal debtor unless it is otherwise provided by the contract. It is for them to show it is otherwise provided. ನೀವು ಮೊದಲು ಪ್ರಿನ್ಸಿಪಲ್ ಬಾರೋ ಹತ್ರ ಹೋಗ್ಬೇಕು, ಅದು ಮುಗಿದ್ಮೇಲೆ ನಂತರ ಬರ್ಬೇಕು ಅಂತ ಇಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ now another important point, 137 may please be looked. 137 of the contract. 137, yes. ನಾ ತಾಳಿಕೊಂಡೆ forbearance. Mere forbearance on the part of the creditor to sue the principal debtor or to enforce any other remedy against him does not, in the absence of any provision in the guarantee to the contract, discharge the surety. ನಿನ್ನೆ ಡಿಸ್ಚಾರ್ಜ್ ಆಗ್ಬಿಟ್ಟಿದೀವಿ, ಅವ್ರನ್ನ ಮಾಡಿಲ್ಲ, ನಾವಾಗ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ, ರಿಪ್ಯುಟೇಷನ್ ಆಗಿದೆ ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕಿದೆ ರಿಪ್ಲೈ 137. ನಾನು ಚರ್ಚೆ ಮಾಡಲ್ಲ. ಪ್ರಿನ್ಸಿಪಲ್ ಮೈ ಲಾರ್ಡ್, ಪ್ರಿನ್ಸಿಪಲ್ ಬಾರೋ ಅಲ್ಲಲ್ಲ, ತಮ್ಮ ಗಮನಕ್ಕೆ, ಬಿಕಾಸ್ ಸಿನ್ಸ್ ಆಲ್ ದಿಸ್ 12 years time is taken, principal borrower is none other than the appellant is none other than the managing director, and he was the employee of former employee of the Shimoga Steels. ಸೊ ಈಗ ನಾನು ಪ್ರಿನ್ಸಿಪಲ್ ಬಾರೋವರ್ ಕಂಪನಿ ಮೇಲೆ ನಾನು ಏನ್ ಮಾಡಿದ್ರು ಇವ್ರ ಮೇಲೆ ನಾನು ಪ್ರೊಸೀಡ್ ಆಗ್ಬೋದು. ಇಸ್ ಲಾ. ಫರ್ದರ್ ಇಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಏನಿದೆ ಅಂದ್ರೆ ಲೈಸೆನ್ಸ್ ಬಗ್ಗೆ. ಈಸ್ಮೆಂಟ್ ಆಕ್ಟ್ ನಲ್ಲಿ ಸೆಕ್ಷನ್ 52
Exhibit R2 is that same, right?
He,
It was
they were
R2.
the licensees. ನೀನೆಲ್ಲ licensed ಅಂತಂದು use ಮಾಡಿದ್ವಲ್ಲ. Under what capacity they were in the premises of Indian casting ಇದ್ದು ನಾವು ಸೀಸ್ ಮಾಡಿದ್ವಿ, ಸೇಲ್ ಮಾಡಿದ್ವಿ ಶಿವಮೊಗ್ಗ ಸ್ಟೀಲ್ಗೆ. ಶಿವಮೊಗ್ಗ ಸ್ಟೀಲ್ ಇಂದ ಇವರು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಆ ಜಾಗದಲ್ಲಿ ಆಸ್ ಅ ಲೈಸೆನ್ಸಿ ಅಂತ ಉಳಿದು ನಮ್ಮ ಹತ್ರ ಲೋನ್ ತಗೊಂಡ್ರು. The license comes under section 52 of the Easement Act. ಅಲ್ಲಿ ಟೈಟಲ್ ಇರಲ್ಲ. Indian Easement Act.
Yes, you are referring to?
Section 52 of the Indian Easement Act.
Yes.
ಬಹಳ ಜನ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೋತಾರೆ. ಲೈಸೆನ್ಸ್ ಗೂ ಲೀಸ್ಗೂ ಬಹಳ ಡಿಫ್ರೆನ್ಸ್ ಇದೆ. A lessee cannot be thrown out from premises without the due notice, without due process of law, whereas a licensee can be proceeded against. ಈಗ ಹೋಟೆಲ್ ದಿ ಕೋರ್ಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್ ಅಲ್ಲಿ ಹೋಟೆಲ್ ಇಟ್ಕೊಂಡಿದ್ದಾನೆ, ಕ್ಯಾಂಟೀನ್ ಇಟ್ಕೊಂಡಿದ್ದಾನೆ. ಹಿ ಇಸ್ ಅ ಲೈಸೆನ್ಸಿ, ಹಿ ಇಸ್ ನಾಟ್ ಎ ಲೆಸ್ಸಿ.
A distinction we have read a lot under
ಅಲ್ಲಲ್ಲ.
the Public Premises Eviction Act ಅಲ್ಲಿ
Actually,
ಅಲ್ಲೆಲ್ಲ ಬರುತ್ತೆ.
ತಾವು ಮಚ್ಚ.
What
But
is the
ಆದ್ರೂ
distinction between the lease and license?
I am getting some judgment from this son of a court in a different cases. Both are same.
Then you can enlighten in those courts.
ಅಲ್ಲಲ್ಲ, it is my duty to assist the court. It is my duty to assist the court. Licensee, ನೋಡಿ, where one person grant to another or to definite number of other person a right to do so, do or to continue to do in or upon the immovable property of the grantor something which would in the absence of such right be unlawful, and such right does not amount to an easement or an interest in the property, the right is called as license.
ಅಷ್ಟೇ ಡಿಫರೆನ್ಸ್.
ಅಷ್ಟೇ.
Lease creates an interest in the property, license does not create.
ಬೇರೆ ಏನು ಇಲ್ಲ. ಇವತ್ತು ಬಸ್ ಸ್ಟಾಂಡ್ ನಲ್ಲಿ ಕೊಟ್ಟಂತ ಎಲ್ಲಾ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇವು ಶಾಪ್ಸು ಲೈಸೆನ್ಸೀಸು, ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಕೊಡ್ತಕ್ಕಂಥ ಎಲ್ಲ ಲೈಸೆನ್ಸೀಸು, ಇವನ್ ನಾವು KSTDC ಕಡೆಯಿಂದ ನಾವು ಕೊಡ್ತೀವಿ, ಅವೆಲ್ಲ ಲೈಸೆನ್ಸೀಸ್. We don't give lease. Further. Now coming to the yesterday some document were shown before my lordship along with that order 41 rule 27. ಅದರ ಬಗ್ಗೆ ಒಂದು 2 ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ. Many of the documents were subsequent to filing of this appeal.
Yes.
My lords got it?
Yes, yes.
Volume 2.
We are seeing the application itself.
Application, and along with the application there are many documents right from R27 onwards.
Just 16 documents
Ah,
which they have marked as exhibit R27 to 42.
42 ಯಾರು ಮಾರ್ಕ್ ಮಾಡಿದ್ರು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ,
ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು ಹೆಂಗ್ ಬರ್ಕೊಂಡಿದ್ದಾರೆ?
ಇಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. So even and all these documents, majority of the documents are arisen after filing the appeal.
Yes.
Even they are divorce of order 41 to 27.
41-27 subsequent events, if they are relevant, they can bring on record.
ಅದು ಇದಕ್ಕೆ ರಿಲೆವೆಂಟ್ ಇದ್ರೆ ಇವೆಲ್ಲ ಶಿವಮೊಗ್ಗ ಸ್ಟೀಲ್ದು ಶಿವಮೊಗ್ಗ ಕ್ಯಾಸ್ಟಿಂಗ್ ನಮ್ಗೆ ಯಾವ್ದು ಸಂಬಂಧ ಇಲ್ಲ, ನಾವು ಅವ್ರ ವಿರುದ್ಧ ಹೋಗ್ತಾನೆ ಇಲ್ಲ, ಏನೇನ್ ಕ್ಯಾಸ್ಟಿಂಗು ಹೋಗ್ತಾ ಇಲ್ಲ. ಕಂಪ್ನಿ ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಿದ್ರು, ಏನ್ ಹೇಳಿದ್ರು ಎಲ್ಲವೂ ನೋಡಿ, ಡೇಟ್ಸ್ ನೋಡಿ. ಅಂಡ್ ಇನ್ನೊಂದು ಇಂಟ್ರೆಸ್ಟಿಂಗ್, all these, by keeping the appellant, allowing the appellant to be in America.
He has sworn to the affidavit. ಅವರೇ ಮಾಡಿರೋದು.
ಅಲ್ಲ, ಅವ್ರು ಅಲ್ಲಿದ್ದಾರೆ. ಅದ್ರ ಬದಲು
Affidavit is sworn by him only.
that is okay. But RTI application ಯಾರು ಹಾಕಿದ್ದಾರೆ? RTI application, RTI application 502 ನೋಡಿ.
Is filed by whom?
Filed by the learned advocate.
All right. See, whether the documents are relevant,
ಅಂದ್ರೆ they are not relevant.
41 rule.
ಅದು relevant ಅಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟೆ.
He had applied.
Who has obtained, XYZ has obtained.
Correct.
What for he has obtained? ಅಲ್ಲ ತಮ್ಗೆ.
He has sufficient experience at bar.
Yes.
Yesterday also we said no personal comments.
ಮತ್ತೆ ಮುಗಿದೋಯ್ತು. ಇದನ್ನೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ಈ ತರ ಹಾಕಿ 10 ವರ್ಷ, ಇದು ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಹಾಕಿದ್ದಾರೆ ಅದನ್ನು ನೋಡಿ, ನಾವು ಡೇಟ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿ.
2020.
Appeal is of 2012.
I have not taken one agenda. I have taken, of course, he was sick. I never objected. As if what he is trying to say is, I am prolonging the matter. The matter, and as a matter of fact, what is made, I will discuss. That when this matter was there, I requested not to keep it as a hearted. I made a.
All right, now we
As if he's throwing blame on the other person. If the courts are.
ಇಬ್ಬರಿಗೂ ಹೇಳಿದ್ವಿ ಅವ್ರು ಪರ್ಸನಲ್ ಕಮೆಂಟ್ಸ್ ಮಾಡ್ಕೊಳಕ್ ಹೋಗ್ಬೇಡಿ ಇಲ್ಲಿ ಅಂತ. ಯಾಕಂದ್ರೆ ನೀವು ಮಾಡಿದ್ರೆ ನಿಮ್ ಹಿಂದೆ ಕುತ್ಕೊಂಡಿರೋ ಜೂನಿಯರ್ಸ್ ಎಲ್ಲ ಆಯ್ತು ನೋಡಿ, we are not deciding the matter on that. We are deciding the correctness of the judgment.
ಆಮೇಲೆ
Hurts me.
See,
ಬಿಡಿ.
if there is something between you, speak that outside.
I will take him for coffee and we will discuss.
And the subject
I will
matter.
take him to a coffee and I will discuss.
ಇಲ್ಲಿ
Coffee.
so you
So date of IA, page number 439.
it is filed in January 2020 ಆಯ್ತು.
November 2020.
ಇಲ್ಲೇನು January 2020.
439, page number 439.
ಇಲ್ಲ in date ಅಲ್ಲಿ January 2020. 10/1/2000 application was ready on 10/1/2020 it seems. ಯಾಕಂದ್ರೆ ಅದ್ರ ಮೇಲೆ ಡೇಟ್ ಆದಿದೆ. ಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ಮ್ ಮೇಲೆ 26 November 2020.
ಅದನ್ನೇ ತಮ್ಮ ಗಮನಕ್ಕೆ ನಾನು ತರಬೇಕಲ್ಲ. You have to assist the court.
Can say it is belated application, all right. ಇಲ್ಲ even affidavit is sworn in on 10/1/2020.
ಅವರು ಇಂಡಿಯಾಕ್ ಬಂದಾಗ ಏರ್ಪೋರ್ಟ್ ನಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ಹೋಗ್ಬಿಟ್ರು. ಇವ್ರ ಮುಂದೆ, ಯಾರ ಮುಂದೆ? ನೋಟ್ರಿ ಮುಂದೆ. ಬಟ್ ಫೈಲಿಂಗ್ ಈಸ್ ಇಂಪಾರ್ಟೆಂಟ್.
ಕರೆಕ್ಟ್.
ಫೈಲಿಂಗ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಅಂದ್ರೆ ದಟ್ ಮೀನ್ಸ್ 2012 is a appeal. 2020 November is a application. So they are all related. They are nothing to do with this case. And enforcement of guarantee, whether any documents are going to cause any hindrance, answer is no. This is my submission. Now, yesterday in all these arguments, my learned friend could not narrate one particular paragraph of the trial court judgment. How it is wrong? ಈಗ ನೋಡಿ, ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಬಗ್ಗೆ ಕೇಳೋ ಅನ್ಸಿದ್ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ತಾವು ಓದ್ತೀರಿ, ನಮ್ಮ ಲರ್ನಡ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಎಲ್ಲ ಓದ್ತಾರೆ. ಅದೇ ರೀತಿ ಹೌ ಇಟ್ ಇಸ್ ರಾಂಗ್, ವಾಟ್ ವೇ ಇಟ್ ಇಸ್ ರಾಂಗ್ ಅದನ್ನು ಹೇಳ್ಬೇಕಲ್ಲ. ಅದನ್ನ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಓರಲ್ ಏನು ಹೇಳಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸಿಲ್ಲ, ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ತಪ್ಪಿದೆ, ಇದು ರಾಂಗ್ ಇದೆ, ಇದು ರಾಂಗ್ ಇದೆ, it has to be looked into, this has to be reappraised in the appellate jurisdiction ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಹಾಗಾಗಿ ಐ ವಿಲ್ ಕ್ಲೋಸ್ ಮೈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಿಕಾಸ್ ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ಸ್ ಅನ್ನ ಕವರ್ ಮಾಡಿದ್ದಾರೆ. ಪಾಯಿಂಟ್ ನಂಬರ್ ಪಾಯಿಂಟ್ಸ್ ಬಿಕಾಸ್ ಅಲ್ಲಿ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆಗಲ್ಲ ಅಲ್ಲಿ, ಬಿಕಾಸ್ ಸಿನ್ಸ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಸೂಟ್, ಮೈ ಲಾರ್ಡ್ ಇಸ್ much aware about this type of cases than me, having conducted these mispetitions.
Points for consideration.
Points for consideration.
Not issues. Yes.
Okay. Points for consideration. Internal page number 8, point number 9. Whether petition is established. ಅದನ್ನು ಅಫರ್ಮೇಟಿವ್ ಆಗಿದ್ದಾರೆ, ಬೇರೆವೆಲ್ಲ ನೆಗೆಟಿವ್ ಎಕ್ಸೆಪ್ಟ್ 9. ಎಂಟೈಟಲ್ಡ್ ಆರ್ಡರ್ 31(1)(a) ಬೇರೆ ಎಲ್ಲ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಎಲ್ಲ ರಾಂಗ್ ಅಂತ ಹೋಗಿದೆ. ಇದಕ್ಕೆ ರೀಸನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಲ್ ದೀಸ್ ರೀಸನ್ಸ್ ಅದು ಹೇಳಿದಲ್ಲ 127 ಆಫ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್, 137 ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್, ಗುಲಾಟಿ ಜಜ್ಮೆಂಟ್ ಪ್ಯಾರಾ ನಂಬರ್ 16 ಅಲ್ಲಿ ಕವರ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಆಗ್ಲೇ ಓದಿದ್ದೆ ಗುಲಾಟಿ ಜಜ್ಮೆಂಟ್. ಪಾಯಿಂಟ್ ನಂಬರ್ 4, 6 and 7. ಅದನ್ನ ಸೇಲ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿಯಿಂದ ತಗೋಬೋದಾಗಿತ್ತು, ನಾನು ಡಿಸ್ಚಾರ್ಜ್ ಆಗ್ತಿದ್ದೆ. ಪ್ಯಾರಾ ನಂಬರ್ 17 ಎಲ್ಲ ಕವರ್ ಮಾಡಿದ್. ಹಿ ಹಸ್ ಟುಕ್ ಪೇನ್, ದ ಲರ್ನೆಡ್ ಜಡ್ಜ್ ಹ್ಯಾಸ್ ಟುಕ್ ಪೇನ್ in describing all the elaborate discussion on all the points. ಅದು ನೋಡಿ ಪ್ಯಾರಾ ನಂಬರ್ 18 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, it is the contention of the respondent is that the petitioner corporation has failed to recover the amount due by the sale of the property hypothetically to it. It is also their contention is that security has gone waste without proper maintenance.
The judgment. We have read the judgment.
I will not read.
You want to
I will not read.
anything specifically in that?
Specifically, a reason ತಾವು specifically reason ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 15 ರಲ್ಲಿ
Company petition that is now closed.
Huh?
Company petition winding up proceedings they are
ಅವೆಲ್ಲ
closed.
ಕ್ಲೋಸ್ ಆಗಿದೆ.
ಒಂದು ಪಾಯಿಂಟ್ ಮೇಲೆ ಅವರು ಪ್ಯಾರಾ 20 ಅಲ್ಲಿ since the matter is pending before the High Court, it is not proper for me to express any opinion regarding that ಅಂತ ಹೇಳಿ.
Yes, ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ. Regarding Shivamogga Steel. Regarding Shivamogga Steel. ಅಲ್ಲಿ ವರ್ಡ್ ಇದೆ ನೋಡಿ.
ಇವ್ರು ಹಾಕಿದ್ರಲ್ಲ ಇವರು ಕಾರ್ಪೊರೇಷನ್.
On the ground that the para 20 li 7th line, on the ground that the said property is not the property of the first respondent, it is a property of the Shivamogga Steel.
ಸೇಲ್ ಮಾಡಕ್ಕೆ ಲ್ಯಾಂಡ್ ಇಟ್ ಸೀಮ್ಸ್ that plot number 279 ಅಂತ ಹೇಳಿ ಆಮೇಲೆ they filed application to withdraw that, modify that order.
Permission to sell, standing outside case.
It's filed seeking modification of an earlier order dated 5/4/2011. Thereby withdrawing the permission earlier granted to sell building on number 279 on the ground that said property does not belong to respondable owner of basis steel ಅಂತ. Sorry, Shivamogga Steel. Exhibit R9. Yes.
ಇನ್ನೊಂದು ಪಾಯಿಂಟು ಅವ್ರು ಹೇಳಿದ್ರು, ಅದನ್ನ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಓದಲ್ಲ, ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹೇಳ್ಬಿಡ್ತೀನಿ. ರಿಗಾರ್ಡಿಂಗ್ ಸೇಲ್ಟೆಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಕೊಟ್ಟರು, ಇದನ್ನೇ ಟೈಪ್ಡ್ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದ್ರ ಬಗ್ಗೆ ಒಂದು 10-15 ನಿಮಿಷ ಟೈಮ್ ಸ್ಪೆಂಡ್ ಆಯ್ತು. ಆಮೇಲೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಮಗೆ ಟೈಪ್ಡ್ ಕಾಪಿ, ಬಟ್ ದಟ್ ಇಸ್ ಇರ್ರೆಲೆವೆಂಟ್ ಟು ದಿಸ್ ಕೇಸ್. ಆ ಸೇಲ್ ಡೀಡ್ ಅವ್ರಿಗೆ ಮಾಡಿದ್ದು ಇವ್ರಿಗೆ ಪರವಾಗಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಲ್ಲ.
Num reference is there again.
ನಾನು ಈಗ ತಾನೇ ಹೇಳಿದೆ 137 ಸೆಕ್ಷನ್ 137 ಪ್ಯಾರ ನಂಬರ್ 27 ನಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ learned trial court judge has considered. Para 27. Before concluding the discussion on these points, I may refer to 137. I need not repeat it. Therefore, as per section 137, 28 nalli, if there is a provision in the guarantee deed that the surety would be discharged if the creditor omits to sue the principal debtor or to enforce any other remedy against him, then the surety would be discharged. ಆ ಥರ ಇದ್ರೆ ಅದನ್ನ ಅವ್ರು ತೋರಿಸ್ಬೇಕಾಗಿತ್ತು, ತೋರಿಸಿಲ್ಲ, ಗ್ಯಾರಂಟಿ ಇಲ್ಲ. In this case, on the contrary, there is a provision in the guarantee deeds that the surety would not be discharged if the creditor, that is the petitioner corporation, omits to enforce its remedy against the principal debtor. ನಾವು ಪ್ರಿನ್ಸಿಪಲ್ ಡೆಟರ್ನ ಬಿಟ್ಬಿಡ್ತೀವಿ. ನಿನ್ನೆ ಅದರ ಬಗ್ಗೆ 7-8 ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು.
Many times you repeat that.
ಅಲ್ಲಲ್ಲ, 7-8 ಸಲ ಅದನ್ನ ಇಲ್ಲಿ ಕವರ್ ಮಾಡಿದ್ದಾರೆ.
Judgment.
ಅಂದ್ರೆ ಎಲ್ಲದಕ್ಕೂ ಉತ್ತರ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಟ್ರಯಲ್ ಜಡ್ಜ್. ಐ ನೀಡ್ ನಾಟ್ ರಿಪೀಟ್. ಇದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸು, ಅಶೋಕ್ ಅಗರ್ವಾಲ್ ಎಲ್ಲ ಕವರ್ ಮಾಡಿದ್ದಾರೆ. ಕವರ್ ಮಾಡಿ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ಪಾಸ್ಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ಕಾರ್ಪೊರೇಷನ್. ಈ ಪ್ಯಾರ ನಂಬರ್ 31 ಅಲ್ಲಿ ಗುಲಾಟಿ ಕೇಸ್ನಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇದೆ, ಲಿಮಿಟೇಷನ್ ಬಗ್ಗೆ ಇದೆ. ಪ್ಯಾರ 36
Now, if you are going to take some.
ಮುಗೀತು, ನನ್ ಮುಗೀತು.
ಅವ್ರದ್ದು ರಿಪ್ಲೈ ಇದೆ. Afternoon.
ನನ್ ಮುಗೀತು. The loan is not disputed. Our cross examination ನಿನ್ನೆ ಓದ್ಬಿಟ್ಟೆ. Loan is not disputed by the guarantors. There is the appellant. ಲೋನ್ ತಗೊಂಡು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಶಿವಮೊಗ್ಗ ಸ್ಟೀಲ್ ನಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. 1.5 ಕೋಟಿ ತಗೊಂಡಿದೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಟೆಕ್ನೋಕ್ರಾಟ್ ಅಂಡ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಫ್ರಮ್ ಅಮೆರಿಕಾ ಎಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. Hence, this appeal may please be dismissed with a exemplary cost.
We'll hear you in the afternoon. Otherwise, it amounts to violation of our human rights. Yes. Yes, Gangadhar, for the anything. Yes. Serial number, 1 second. Serial number 36. Patrimony.
37 madam,
Only party person. Alla 36, yeah, advocate, nobody represents her. She served unrepresented, idralli. Gangadharappa avaru, respondent. Because yarnarappa amicus curiae marteve, henmaglu, she is entitled for trial court alli, whether she was represented through. We'll appoint some amicus curiae. Whatever it may be, ಯಾರನ್ನ ಒಬ್ಬರನ್ನ ಅಸೆಸ್ ಮಾಡ್ತಾರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ನೋಡಿ ಏನಿರುತ್ತೋ ಅಷ್ಟು ಹೇಳ್ತಾರೆ. 36. Respondent, though served is unrepresented, since she is a woman, she is entitled to free legal aid. Therefore, matter is referred to High Court Legal Services Committee. This is from which place? Ide Koratagere. Therefore, the matter is referred. And the High Court Legal Service Authority ಆದ್ರೆ ಮತ್ತೆ ಬೇಕಾಗುತ್ತೆ. ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್ ಇವ್ರು ಬೇಕು ಅವ್ರಿಗೆ ವಕಾಲತ್ತು ಬರಕೊಡೋದಕ್ಕೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು ಬೆಟರ್. ಸುಹಾನಿ ಹೊಳ್ಳವರನ್ನ. Therefore, Srimati Suhani Holla, Laurel Council is appointed as amicus curiae to assist the court on behalf of the respondent. One copy ಕೊಟ್ಬಿಡಿ ಅವರು. Registration show her name in the copies. Accordingly, appellant's counsel shall furnish one set of copies to her. List on, I thought 10 days ಬಿಟ್ಟು ಹಾಕೊಳ್ಳೋಣ.
12-6.
12-6.
That 37, madam.
37.
And higher, deposit.
ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ 2015 ಪೆಂಡಿಂಗ್ ಇದಾವಲ್ಲ ಇವ್ರೆ 37. Agenda at the request of the appellant. Yes. Pardon? Afternoon, it is inconvenient to you. Shauri. Agreeable. As requested, list in the next week. Yes.
See, we have
Data.
try out the possibility of settlement.
Like it was not referred to mediation.
ಇಲ್ಲ ಅವಾಗ ಹಾಗೆ ಇವತ್ತು ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ maybe 2 weeks time may be given. In the meanwhile we'll try. So ಒಂದೇ ಊರಿನಲ್ಲಿ ಮಾತಾಡ್ತೇವೆ ತೀರ್ಥಹಳ್ಳಿ ಕತೆ.
This is from which place?
ತೀರ್ಥಹಳ್ಳಿ.
Tirthahalli. See, both of you would be the best mediators.
ಅದಕ್ಕೆ we will try. That's what I don't want it to be referred to mediation. ಒಂದ್ 2 ವಾರ 3 ವಾರ ಟೈಮ್
ಹಂಗಂದ್ರೆ ಈಗ
ಮಾತಾಡ್ತೀವಿ
both
ಅಡ್ವೈಸ್ ಮಾಡಿ.
ಆದ್ರೆ ಇಷ್ಟು ದಿವಸ 2016 ಪೆಂಡಿಂಗ್ ಇದೆ. ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್.
ನಡೀತು ಅಂತಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಲ್ಮೋಸ್ಟ್ ಪಾರ್ಟ್ ಆಗಿತ್ತು.
ಏನು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇದು ಅಲ್ಲ ಡೈವರ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಡಿಗ್ರಿ ಆಫ್ ಡೈವರ್ಸ್ ಇಸ್ ಗಿವನ್. ದೇ ವಾಂಟ್ ಟು ನೌ ಪರ್ಸ್ಯೂ
wife's petition.
wife's petition. That's why
Both counsel seek time on the ground that they explore the possibility of settlement. List on ಒಂದು 2 ವಾರ ಅಂತ.
18-6.
18-6. ಅಲ್ಲ ಒಂದೊಂದ್ಸರಿ ಪಾರ್ಟೀಸ್ಗೆ ಇಂಥ ಟೆಂಡೆನ್ಸಿ ಇರುತ್ತೆ ಅಂದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಆದ ತಕ್ಷಣ ಕಾಂಪ್ರಮೈಸ್ ಅನ್ನಕ್ ಶುರು ಮಾಡ್ತಾರೆ.
this matter was heard. We are ready for argument. But ಇವತ್ತು
more particularly family court matters. Yes, ಕಾಮತ್ ಅವ್ರು ಎದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ದಾರೆ?
ಇಲ್ಲ 48.
48. Who is for the other side? ಶಂಕರ್
ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನೀವು ಯಾರು ನಿಮ್ಮನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದ್ದು?
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
ಓ ಕಾಮತ್ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಯ್ತು ಕಮ್ಮಿ ಮಾಡಿ.
42.
ಒಂದ್ ಅರ್ಧ ಗಂಟೆ ಬಿಟ್ಕೊಂಡ್ ಬನ್ನಿ, ಯಾಕಂದ್ರೆ ಅವ್ರು ಇನ್ನೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು. ನಾರಾಯಣ ಅವರು.
ಆಯ್ತು. 42 ಬಂದಿದ್ದಾರೆ ಸುಮಾರು.
42. ಏನು ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಪೀಲ? ಕಂಪ್ಲೇಂಟ್ಸ್ as requested, list tomorrow. ಆಯ್ತು. ನಾಳೆ you want it tomorrow? You need it as requested, list in the next week. All right. 50? ಏನಲ್ಲ?
54 ಅದು
ಬಾಡಿ 54 ಅಲ್ಲ? ಎಲ್ಲಿ ವಾರಂಟ್ ಏನು ಮೆನ್ಷನ್ ಇಲ್ಲಲ್ಲ ಇಲ್ಲಿ?
54.2 ನಲ್ಲಿ
54 parties are present. You mention it in the afternoon. ನಾವು ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 1 week ಅಂತ ಹೇಳಿದೀವಿ. ಅಲ್ಲ ರೀ, ನಾವು 1:50 ನಿಮ್ಗೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಡೋದಕ್ಕೆ ಕುತ್ಕೋಬೇಕಾ? ವುಡ್ ಹ್ಯಾವ್ ಹರ್ಡ್ ದ ಮ್ಯಾಟರ್ಸ್. ನೋಟ್ಸ್ ಇಲ್ಲ ಇರ್ಲಿಲ್ಲ, ನೀವು ತೆಗೆದಿಟ್ಕೊಂಡಿರಿ. ಮತ್ತೆ ಯಾವ್ದು ಬೇಕು? ಅಲ್ಲ ಇದು ಬೇರೆ ಕೇಸ್.
ಕಹಾನಿ ಹೊಳ್ಳ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಇದು ರೆಫರ್ ಮಾಡೋದು ಹೆಚ್ಚು
ಕೋರ್ಟ್ ಆಫೀಸರ್ 37 ಅರ್ಜೆಂಟ್ ಆಯ್ತಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ 37 ಅರ್ಜೆಂಟ್ ಆಯ್ತಾ?
ಸರ್ 37 ಅಡ್ಜನ್ ಆಗಿದೆ.
ಯಾವಾಗ ಹೋಗಿದೆ ಮೇಡಮ್?
ಸರ್ ಬರೀ ಅರ್ಜೆಂಟ್ ಅಟ್ ರಿಕ್ವೆಸ್ಟ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ.
ನಾವು ಮಾತಾಡೋದು ಅಲ್ಲಿ ಕೇಳಿಸುತ್ತೆ.
ಮೀಟ್ ಮಾಡಿದ್ರಲ್ಲ ಸರ್ ನಮ್ ಕಡೆಗೆ ಅವ್ರು ಊಟಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅವ್ರು ಇಲ್ಲಿ ಮೀಟ್
ಕೋಟಲ್ ಸರ್. ಕೋಟಲ್ ಸರ್.
ಮೀಟ್ ಮಾಡಿ ಸರ್ ಬಂದಾಗ ಕೇಳ್ತಾರೆ ಅವ್ರು.
My lord, in this case, I am appearing on behalf of respondent number 2. The mic is not on, my lord. I have not heard the voice.
Sir, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
Yes, my lord. Here I am undertaking to file wakalat on behalf of respondent number 2, my lord. Day before yesterday, he has given wakalat.
Respondent 736 ಸಿಗ್ನಲ್ ಅಪೀಲ್ ನಂಬರ್ 232 ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ನನ್ನ ಕೈಗೆ.
Same.
Yes.
ಮತ್ತೆ ಇದ್ಯಾವುದು ಇನ್ನೊಂದು 936 ಅಂತ ಒಂದಿದೆ. ಅದೆಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್?
Serial number 39, my lord.
39. ಇದರಲ್ಲಿ
Notice has been issued.
ಸರ್ಡ್ A to Javed served.
Yes, my lord. I am undertaking to
PM
file wakalat.
Jagdish has filed wakalat for R3.
R3 already filed.
Undertaking to appear for R2.
R2 also, my lord.
But warrant is issued against him.
No, my lord, in the last date of hearing on 15/4/2024.
Possible, ನಮ್ಮ ಕೋರ್ಟ್ ನವರು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರು. R4 ಅಲ್ಲ ಎರಡು R2 and R4 ಅಂತ ತೋರಿಸ್ತಾರೆ.
R4 reported to be dead.
There is a mistake in our list. The effect that respondent number 2 is in judicial custody.
Now he is released, my lord.
He is released.
Yes, my lord. He released and he has given to wakalat.
I am Jagdish, ನೀವು ಸ್ವಲ್ಪ ಈ ಕಡೆ ಬರಬೇಕು.
Yes, my lord. I am Prabhu Swami on behalf of CM Jagdish.
ಅಲ್ಲ ಅವಾಗ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ರು. ಪ್ರಭು ಸ್ವಾಮಿ ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
Yes, my lord. Along with CM Jagdish, I am also appearing.
CM Jagdish Leonard Council undertakes to appear for respond number 2. He is permitted to file the wakalat in the registry within ಎಷ್ಟು ದಿವಸ ವಕಾಲತ್ ಹಾಕ್ತೀರಿ?
Any next week or 2 weeks time may be granted.
ವಕಾಲತ್ ಹಾಕೋದಕ್ಕೆ 2 ವಾರ ಟೈಮ್ ಬೇಕೇನ್ರಿ?
In the office, I will file wakalat.
You file it in the registry only within 10 days.
Respondent number 3, your lordships. Respondent number 3.
ಅಲ್ಲ NBW issued. Respondent number 4 is dead.
Against R2, your lordships.
R2 is
PW against
concerned.
R2.
And he is undertaking to appear for R2. Correct. R3 ಗೆ already Jagdish has appeared.
Yes, my lord.
Who is R1?
R1 is also I am representing, my lord. R1 and R3.
ನಿಮ್ಮ ಹೆಸರು R3 ಗೆ ಮಾತ್ರ ತೋರಿಸಿದಾರಲ್ಲ.
CM Jagdish in last date
The
of
name
hearing.
is shown only for R3. R1 third unrepresented ಅಂತ ಇದೆ.
M Jagdish for R3.
In the last date of hearing also I have represented on behalf of respondent number 1 and 3, my lord.
Have you filed wakalat for R1?
Yes, my lord. I already filed on 15/4/2024 order sheet. My lord, kindly
You
peruse
have
the.
the acknowledgement? ನೋಡಿ ಹಾಕಿದಾರಂತ. ಇದು ಯಾಕೆ ಈ ರೀತಿ confusion? R1 ಗೂ ವಕಾಲತ್ ಹಾಕಿದಾರಾ? R3 ದಷ್ಟೇ ಕಾಣಿಸ್ತು. ಇಲ್ಲಿ ವಕಾಲತ್ ನಮ್ಮ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಹಾಕೋದಿದ್ರೆ ಹಾಕಿ, ಇಲ್ಲದೆ ಇದ್ರೆ ವಿಲ್ ಇಶ್ಯೂ ವಾರಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್ ಆಲ್ಸೋ. R3 ಮಾತ್ರ ಇದೆ.
I will also undertake next date of hearing. I will also clarify the record and file the wakalat. Because
Why they have mentioned council for respondent 1 and 3 are present at the work. ವಕಾಲತ್ 3 ಗೆ ಮಾತ್ರ ಹಾಕಿದೀರಾ? ರಿಪೋರ್ಟ್ ಆಯ್ತಲ್ಲ, undertakes to work. On verification of the records, it is found that Mr. CM Jagdish has filed wakalat only for respondent number 3. ನೀವು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತೀವಿ ಅವ್ರಿಗೂ.
Next date I will clarify, my lord.
ಅದನ್ನ ಮೊದಲು ಬರ್ಕೊಂಡ್ಮೇಲೆ ಹೀಗೆ ಬರ್ಬೇಕು. CM Jagdish Leonard Council undertakes to appear for respondent number 1 and 3. He is permitted to file the wakalat in the registry for the said respondents within 10 days. The registry shall maintain the NBW ಇವ್ರು ತಗೊಂಡು maintain the records of the appearance of the advocates properly. This from 10 days on the 36. ನೆನಪು ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಆಯ್ತಲ್ಲ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಎಸ್ ಎಸ್
Further hearing? Bill number 39?
Yes, Mr. Narayan, how much time you need?
4?
20 minutes ಯಾಕೆ ಬೇಕ್ರಿ ನೀವು ಮೊನ್ನೆ 4 hours argument ಮಾಡಿದಿರಿ. We will allot you 10 minutes. You have to complete this. Now it is 2:47.
One submission, my lord.
2:57 ಮುಗಿಸ್ಬೇಕು.
I am in a hurry to run to quota number 26 also. I am in a very hurry also. Of course, I'll finish. No. I will not even go through the case laws. I will simply say what is there in the case law. Your lordship may come, please. That which I'll do that. Okay.
Yes.
My lord, my learned friend's submission was the proceedings under section 31(1)(a) are totally different from the suit and it cannot be compared and there is no proceedings under that thing. Now, in this case, Maharashtra State Financial Corporation was Ashok A. Agarwal, second case laws which I have quoted, page number 19.
Yes. Page number 19 is
Put it here.
Gulati's case.
Maharashtra State Financial Corporation
Yes.
versus
ಅದು ಎರಡೇ ನಂಬರ್ 13 and 19 ಎರಡೇ ಇದೆ. Yes. 13 ಅಂತ ಇದೆ, 19 ಅಂತ ಇದೆ.
internal page number 2, reverse side. The argument, fourth paragraph.
Yes.
The argument that an application under section 31 is in the nature of the execution proceedings. Therefore, article 136 applies, which allows a period of 12 years from the execution of degree and orders. And the application was thus well within time. It is submitted that the courts have upheld the legal fiction that application under section 131 of the State Financial Corporation are treated in the nature of execution proceedings. In support of this submission, the learned counsel referred to Gujarat State Financial Corporation versus SCR and that thing. It was observed by this court in this case that the substantial relief in an application under section 3(1) is something akin to the application of attachment of property in the execution degree. Section 31 of the Act contains a special provision for enforcement of claim by the state financial corporations. It is by way of legal fiction that the procedure is akin to the execution degrees under the code of civil procedure has been permitted to be invoked. But one cannot lose sight of the fact that there is no difference, no degree, no order of civil court where we are dealing with an application under section 31 of the Act. The legal fiction at best refers to the procedure to be followed. It does not mean a degree order has been passed. It is only a procedure. It does not alter any other provisions of the Act. Therefore, whatever is applicable to suit, whatever the limitation is applicable to any transaction is applicable. There are no special provisions. Next, now, we refer to section 128 of the Indian Contract Act. It merely says the liability of the guarantor is coextensive as that of the principal. It only means as long as principals, the debt from the principal is recoverable, it can be recovered from surety also. But when it is recoverable, either it can be recovered from the principal borrower or from the guarantor. But what is important is that debt should be recoverable from the point of a law of limitation from the principal also. That is only it says. It's coextensive means if he is payable, you can either go to him or go to me. But if you cannot go to him, you cannot come to me also. Or even otherwise also, if you are treating me as a principal creditor, the law of limitation is applicable to me, the transaction. Next, Gulati case. In this, the loan was sanctioned on 28/9/93, communicated on 21/10/1983. Mortgage was mortgage the property was on 7/2/84. Guarantee deed was executed on 7/2/84. First notice was 18/1/89. Second notice on 14/9/93. That's the case invoked. Then application was filed on 29/93. In this case, two things are important.
Yes.
The mortgage, the time limit for foreclosing mortgage is 12 years. That means from 84, 12 years, 96. Till 96, the loan was recoverable against the principal creditor. But they have foreclosed, they have recovered it earlier, and 93, they have given the notice to the kid. Therefore, it said it is well within time. The principal point is, at that point of time, whether the loan against the principal creditor was recoverable or whether it is hit by limitation. Here in this case, it was mortgaged. Section 37 of the Contract Act, 137 of the Contract Act. It merely says forbearance on the part of the principal creditor to the borrower will not be considered as the laches. In this case, the illustration is given. As per the illustration, 1 year, the principal creditor tolerated it. But in this case, more than 12 years is over. Would it be called as a forbearance? And that too after the borrower specifically saying that I am not going to pay it, I am repudiating the contract. Therefore, this case is not applicable. In this case, in this regard, the trial court judge is relying on one Narayan Rao's case, where in that case, the loan was given to hypothetically the truck, lorry. Lorry runs all over India. To trace it, to take it back is very difficult. So that case cannot be compared to this case at all. Here, I'm not only the immovable properties are situated in Bangalore, Mysore, I have already handed over the key to them. Regarding the key to them and other thing only, I have produced the subsequent documents which are very relevant for the case. Then 139 and 140 of the Indian Contract Act. First I'll read it. Surety is right to benefit the creditor's securities. Whatever the security the creditor had, he has to be handed over to me. I can go against it if I am a surety. It is my specific case that the property which has been told to me as mortgaged was not mortgaged, they were not the owners. Then 139, discharge of surety by creditors acts of omission and commission imposing this. As early as 96, I handed over the assets. If they have sold the assets, this loss would not have been this much. They allowed the scrap, the security to become scrap.
As well as
And all this application, in all these applications which are given as a subsequent document, I will not elaborate on that. It will demonstrate they try to take possession of the same industrial property. And the court negatived it. On the one hand, in this proceeding, they say we are the owner, it has been mortgaged to us, we have got the hypothecation. The same right they try to establish in the company court. Company court negatived it. Company court upheld the right of the Simha Steel Limited. To that extent, I was misled. It is not I was misled at that point of time. They misled themselves.
How many times he will repeat?
No,
this?
that is what,
Already
that's all. That's all my argument.
We
That's all.
tell it
No.
on your face only.
No.
That you say that you are an engineer plus MBA. MBA means Master of Business
Only
Administration.
one submission. Out of the proceedings.
You say you
No, no.
are not conversant with commercial transactions. You are the Master of Business Administration.
One minute, madam.
Yes.
Out of the proceedings. Ambani, that is our Mukesh Ambani and Anil Ambani, in their partition deed, they agreed to sell electricity at a particular rate of a public limited company. They thought that public limited company was also there. Such a stupidity was done by the eminent advocate.
Ambanis were
No,
not. eligible.
anybody can do it. What I am trying to say is, I am subject to correction. Anybody can commit a mistake.
They were not MBA.
No, my lord, MBA is finance is there. MBA is marketing is there. So MBA for marketing will know only the marketing. And second thing is, my lord, my friend also
Settled
told you.
principle is ignorance of law is no excuse.
No, ignorance of law is not. I have never pleaded that I am ignorant.
You
Therefore, please.
You have mentioned in your statement of objection and affidavit both that you are
No,
MBA,
see.
you are not conversant with commercial transactions.
Only for the extent is whether willful default,
See,
mensiria or not. That's all. That
they're trying to tell you that
Therefore-
try to be brief, no repetition
There-
and
therefore
no
my
exaggeration.
therefore my humble submission is allow the appeal, dispute is set aside now.
Third reason. ಇವೆಲ್ಲ ಕೊಟ್ಟಿರೋದನ್ನ ಅದರ್ ಸೈಡ್ ತೆಗೆದು
Number 48, Shankar Narayan Bhatt, Ramat Juris.
He said he will come. ಅವ್ರು ಬರ್ತಾರೆ ಅಂತ.
ಬರ್ತಾರೆ, we will wait.
ಎಷ್ಟು?
ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಹೇಳಿ.
I have informed him.
ಯಾರು ಅವ್ರ ಕೊಲೀಗ್ಸ್ ಇಲ್ವಾ ಇಲ್ಲಿ?
He has no juniors. Could be one.
Because he has to commence.
We'll pass over, I'll again try to contact.
If possible, you contact him.
Please,
Next ಯಾರು ಇದ್ದಂಗೆ ಕಾಣ್ತಿಲ್ಲ, ಯಾರಿದ್ದಾರೆ?
please,
ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ we start hearing you, that's all.
please.
Number 40, MB Hiremat, ND Omkarappa.
AMC.
The appellant herein is the pipe, my lord.
Who is for the other side? ND
Other
Omkar.
side, today not present, but yesterday he was here.
He was here.
Yes, correct. Yesterday, because yesterday the matter was not reached.
ಅದೇನದು KMC report?
The earlier the matter was referred to mediation, it was not settled.
ಅದು ಬೆಂಗಳೂರು ಮೀಡಿಯೇಷನ್ ಕರ್ನಾಟಕ ಮೀಡಿಯೇಷನ್
ಅದೇ ನಾನು ಹಾಗೆ ಅನ್ಕೊಂಡೆ. That was a mistake.
KMC ಅಂದ ತಕ್ಷಣ ನಮ್ಮ ತಲೆಯಲ್ಲಿ
ಅದೇ.
ಮೆಡಿಕಲ್
Yes, yes. ಅದು Karnataka Medical College.
ಏನಾಯ್ತು ಸೆಟಲ್
Short,
ಆಗಿಲ್ವಾ?
ಒಪ್ಲಿಲ್ಲ, but short issue may not.
ನಾಟ್ ಸೆಟಲ್ಡ್.
Huh?
ನಾಟ್ ಸೆಟಲ್ಡ್. It is not settled.
Not settled. The respondent husband lord has filed the petition lord on the ground of desertion and cruelty, my lord. The petition is allowed, against which, my lord, this present appeal is filed by the wife, my lord. It is pending, my lord. I'm told that he has taken second marriage also. Therefore, on the last date of hearing, at least for some amount, it can be referred. The matter was referred, but was not settled. And another thing is, my lord, there is a maintenance petition is, there is an order by the magistrate court to pay maintenance also. So as yesterday he told me that instruction I don't know. So, but only thing, my lord, since he has taken marriage, one issue, but maintenance or alimony has not been awarded. To that extent, this court at least, because in that way because I'm not saying on merit, I may argue that here, my lord, the wife had filed a petition, I mean, the large complaint for the offense punishment section 498. So the court has taken the view that there is a cruelty, private person.
Charge sheet was filed?
Please, my lord.
Charge sheet was filed.
Yes, matter is going on, but the final conclusion I am not aware.
Charge sheet ಹಾಕಿದ್ದಾರೆ ತಾನೇ?
Charge sheet ಆಗಿದ್ದು ನನಗೆ ಆ ಮಾಹಿತಿ ನನಗೂ ಇಲ್ಲ. That is why, my lord.
It is filed. It cannot be said that it is a frivolous complaint.
That is why, my lord. ಅದು ಯಾಕಂದ್ರೆ ಆ ಸ್ಟೇಜ್ ಬಗ್ಗೆ ಬಂದಿರಲಿಲ್ಲ ಅವಾಗ. ಈಗ ಯಾವ ಸ್ಟೇಜ್?
ಈಗ ಇದ್ರಲ್ಲೇ ಅವ್ರು ಒಂದೇ ಮ್ಯಾರೇಜ್ ಇನ್ವಿಟೇಷನ್ ಕಾರ್ಡ್ ಒಂದೇ ಹಾಕಿದ್ದಾರೆ. ಈ ಕಡೆ ಏನು ರೆಕಾರ್ಡ್
ಇಲ್ಲ, ಬಟ್
how he established
that is the reason because ಇಲ್ಲೊಂದು the finding
ಅಂತ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ಅವರೇ
24 ಅದು ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ I am of the opinion that ಅಲ್ಲ CC number 442 ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್
ಆಗಿದೆ CC number 442/2012 which was filed under 498A of IPC.
Mere filing of criminal case does not amount to cruelty unless it is shown that either there was an acquittal or she has turned hostile in that case.
Yes.
It cannot be said that it amounts to cruelty.
At this stage, that is the reason. That's why the court has taken the view that ಅಲ್ಲೇ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಪ್ಯಾರಾಗ್ರಾಫ್ 24 ಅಲ್ಲಿ ಮೇ ಪರ್ಸ್ಯೂ ದಿ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 17 ದಲ್ಲಿ
ಮತ್ತೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ ಶಂಕರನಾರಾಯಣ್ ಭಟ್ ಅವ್ರು ಕರ್ಕೊಳ್ಳಿ ಬಂದು ಹೋದ್ರು.
ಇಲ್ಲಿ that's why ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ I am of the opinion ಇಲ್ಲಿ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 17 of the judgment finding ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ I am of the opinion that allegation is responding that a petitioner having a illicit relationship with another lady filing of criminal cases against the petitioner and his family members under section 498A are also a ground to hold that respondent treated the petitioner with cruelty and accordingly answering the issue number 1. The reason ಅದು subsequent ಆಗಿದ್ದು but 3 months ಇದ್ರು ಅಂತ I examined 2 witnesses RW1 and 2. ಅವರು only to the extent of this criminal case ಮಾತ್ರ witness ಉಳಿದಕ್ಕೆಲ್ಲ accept ಆಗಲ್ಲ ಅಂತ ಅವರು
ಕರೆಕ್ಟ್. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಇನ್ನು ಫೈನಲ್ ಅಡ್ಜುಡಿಕೇಶನ್
ಆಗಿಲ್ಲ. That is the reason.
So now what is the position now?
Position ಅಂದ್ರೆ ಈಗ
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್
that ಮಲಡ್
ನಿಮ್ಗೆ
ಎಲ್ಲ I will
ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಚೆಕ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಪೆಂಡಿಂಗ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅಂತ. That was one ground. ಡೆಸರ್ಷನ್ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ ಅನ್ನೋದು
ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ.
But according to she was subjected to cruelty.
ಅದು 2 years ಆಗಿದೆ ಅಂತ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Merely because 2 years they are living
ಆಗಲ್ಲ.
separately does not amount to desertion.
That's the
Desertion should be without any excuse.
without any justifiable cause there.
There.
ಅದು
Filed a criminal case. ಅದೇನಾಗಿದೆ ರಿಸಲ್ಟ್ ಗೊತ್ತಿಲ್ಲ.
ಗೊತ್ತಾಗಿಲ್ಲ. Yesterday actually he also wanted to know the present status. ಅದು ರೀಚ್ ಆಗಲಿಲ್ಲ.
ಅದು ಯಾವ ಕೋರ್ಟ್ ಏನೋ ವೆಬ್ಸೈಟ್ ಹೋಗಿ ಹಾಕಿದ್ರೆ ಸಿಗುತ್ತೆ ಅದ ರಿಸಲ್ಟ್.
ಅದು I will find out next week ಅಥವಾ 10 days ಬಿಟ್ಟು ಹಾಕಿದ್ರೆ I will get it.
2012 ಇಲ್ಲಿವರೆಗೂ ಇರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ ಅದು.
CC number 442/2012.
It may not be pending. You had not filed any application under section 25.
Yes, ma'am.
ಹಾಕಿರ್ಲಿಲ್ಲ ನೀವು ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಅಂದ್ರೆ ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಕೊಡಿ. ಇಲ್ಲ ಅದು ಇಂಡಿಯನ್ ಡೈವರ್ಸ್ ಆಕ್ಟ್ ಒಳಗಡೆ ಕೇಳಿದೆನೂ ಕೊಡಬಹುದು. ಹಿಂದೂ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಒಳಗಡೆ ಹಾಕಿರೋದು ಆನ್ ಎನ್ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ ಅದರ್ವೈಸ್ ಅಂತ ಇದೆ. ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಬೇಕಲ್ಲ ವೆದರ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಫಿಡವಿಟ್ ಆಫ್ ಯಾವುದು ರಜನೀಶ್
ಹೌದು ಅದು ಆಗಿಲ್ಲ. ಅದು ಕೂಡ ಆಗಿಲ್ಲ. ಅಲ್ಲ ಇದು ಏನಾಗಿದೆ ಎಸ್ It was on 24th August 2016. The judgment has been given, my lord. Perhaps that is subsequent to.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಈಗ ನಾವು ದ ಮ್ಯಾಟ್ರಿಕ್ಸ್
ಇಲ್ಲಾರ ಹಾಕ್ಬೋದ?
ಇಲ್ಲಾದ್ರೆ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು ಎನಿ ಆನ್ ಆನ್ ಅಪ್ಲಿಕೇಶನ್ ನಾನು ಯಾವಾಗ ಓದುವಾಗ ಮಾತಾಡ್ತಿದ್ದೀನಿ. We can exercise power under section 25 only if you make an application.
Here.
Section says that on an application made to it for the purpose of ಅಂತ ಇದೆ.
That
ಈಗ
is
ಇಂಡಿಯನ್ ಡೈವರ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಈ ರೀತಿ ಇಲ್ಲ.
ಇಲ್ಲ.
It's mandatory for the court to decide. At the time of the passing of the decree or at any time subsequent thereto, on an application made to it for the purpose has to grant permanent alimony ಅಂತ ಇದೆ. ಮತ್ತೆ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ ನಾವು ಅದನ್ನೇ ಕನ್ಸಿಡರ್
ಅಲ್ಲ
ಮಾಡಿ.
with
Now you do one thing, you argue only on the merits. Or you have to
apart from that, my lord, with the permission to make an application with a trial court.
file ಮಾಡಿ
Even ಅಲ್ಲೂ ಕೂಡ they can ಯಾಕಂದ್ರೆ ನನಗೂ ಅದು ಮಾಹಿತಿ ಸಿಗ್ತಾ ಇಲ್ಲ. That's why.
Other parties in contact with you.
They came for mediation.
Correct.
ಅಲ್ಲಿ ಬಂದಿದ್ರು, ಈಗ ಇದ್ದಾರೆ. I will seek that instruction.
ಹಂಗಂದ್ರೆ why were you hearing you?
That's ಒಂದು 10 days ಬಿಟ್ಟು ಹಾಕಿ.
As requested by the appellant's counsel, list and no representation for respondent and our call. As representation for the appellant's counsel, list 10 days. List after 10 days, right?
Yes.
Database. ನೀವು 48 ಬಂದ್ರಾ? ಇಲ್ಲೇ ಬಂದಿದ್ದಾರೆ ನೋಡಿ, ಎಲ್ಲಿದ್ದಾರಲ್ಲ. Number 48.
I appear for the respond number 1 and 2.
Yes, Mr. Bhatt.
Your lordship, kindly
This is
see the
the-
order. Serial number 49, my lord.
Serial number 48.
Sorry.
For the appellant, my lord. Here in this regard, on the last day of hearing,
How many application? 4 of 20 is for
not on last
permanent
date of
alimony.
hearing, Lord, at the instance of my learned friend,
1 of
This one-
2021 is for direction. And there are so many memos. 2
My
of
lord,
2021 is for direct-
I'm confining today's proceedings to only memo dated 3rd April 2024. The lordship
Now
may
it is listed for final hearing.
Now, final hearing, my lord, what has happened on 27/9/2021, this honorable court directed respondent, directed appellant to pay 1 lakh.
Cover sheet is 10 kg.
files are also this big, but my lord, let's read it.
27/9, because of very, very,
Order you are referring?
order dated 27/9/2021,
27/9/20.
2021, my lord. It was almost a consent order, my lord.
When?
After hearing, after arguing the matter at length by the learned counsel for both parties, Sri Shankar Narayan Bhatt, learned counsel for the appellant husband, fairly submits that appellant is ready to pay monthly maintenance of rupees 1 lakh to the wife and children, and appellant agrees to pay all the educational expense and medical expense of the children directly to the respective institutions. Submission is placed on record. Sri N. Ravindranath Kamath, learned counsel for the respondent wife, is directed to furnish the particulars where the institutions, namely the institute where the children are studying, the fees to be paid, etc., to enable the appellant to pay all the education expenses of the children and medical expenses, if any. List of dates and synopsis filed by the learned counsel for the respondent's wife is placed on record. List the matter next week. Thereafterwards, my lord, your lordship may kindly see the order dated 7/3/22. Shankaran Bhatt, learned counsel for appellant, Ravindranath Kamath, so for the respondent, learned counsel for respondent vehemently submitted that the direction contained in the order dated 27/9/21 has not been complied with by the appellant, notwithstanding his readiness and willingness to pay the monthly maintenance of the amount to the wife and children, as well as to pay educational expenses and medical expenses directly to the respective institution. In view of aforesaid submission, an extra copy of memo dated 4/10/21 has been served on learned counsel for the appellant today. Learned counsel for the appellant prays for short accommodation to enable him to make a statement with regard to the amount paid to the respondent. In addition, learned counsel for the appellant shall file an affidavit stating the amount given by the appellant to the respondent on account of maintenance as well as educational and medical expenses of the children. Next, my lord, the next order 21/3/22. So and so, additional document so and so. Learned counsel for the respondent submit that in compliance of the order dated 27/9/21, the appellant has not paid the educational expenses incurred by the respondent, and the appellant be directed to reimburse the amount of educational expenses incurred by the respondent. However, from perusal of the order dated 27/9/21, we find that the learned counsel for the respondent was directed to produce particulars of the institutions and where the children are studying and the fees to be paid. In the absence of any application seeking modification of the order, it is not possible for us to modify the same made on the basis of the submission. Thereafterwards, my lord, again on the order dated 1/7/22, learned counsel for the respondent.
Correct, no. Why are you arguing?
ಈಗ ಈ 4 ಆರ್ಡರ್ ಪ್ರಕಾರ ಅವರು ಈ 27/9 ಆರ್ಡರ್ ನ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. ನನಗೆ ನಾನು ಐ ಆಮ್ ಜಸ್ಟ್ ಲಿವಿಂಗ್ aside whatever that has happened in between. As per my memo dated 3/4/2024, which is listed in the list, page 24, I have produced all the bills, receipt, everything, memo of calculations, page 24 of the.
Correct, you execute that order.
No, my lord, I cannot execute that order. This order, he has to pay me the money. I have filed an application for initiating.
There is an order.
No.
Order of this court.
Yes, my lord.
If he fails to pay that, you can execute that order.
No, my lord, now.
This order.
No, my lord, I can file a contempt proceedings. In a contempt proceedings, again, what happens is that I have to seek the permission of this honorable. I have filed an application to initiate contempt action against him. That IA is pending. That IA is, I have filed before this honorable court, 14,32,000.
7/9, it was. 7/9/2021. Otherwise, the proceedings go in this only.
No, my lord, I'm just cut shorting.
First order, 27/9.
27/9/2021.
Consent order, no, consent order, contempt, they can execute it. All right, you file the contempt petition only, we'll refer it to the, goes before.
No, my submission is this, my lord.
Counsel for both parties. Fairly submit that appellant is ready to pay monthly maintenance of ₹1 lakh to the wife and children. Appellant is pay all education expenses and medical. Now, there was a consent order.
It is a consent order, ma'am.
Consent
No,
order.
I'll submit,
You
just
say
wait for
that
it.
they have not paid, they say that they have paid, right?
They have not paid. They have not paid. Your lordship.
Now again, that has to be adjudicated.
No, my submission is only this. The further order says he has to file an affidavit. In the affidavit, he must say how much he has paid. He has not filed that affidavit. Now, my lord, your lordship may kindly take the order dated 15/11/23, when the matter was posted before your lordship. There was a necessity for the respondent's daughter to join a veterinary course, and the veterinary course college was approached. Capitation fee seat was available for her, and from the month of October 2023, the daughter was contacting the father to pay the capitation fee. He delayed. Requirement was 15 lakhs rupees. Finally, this honorable court ordered for 7 lakhs rupees as per order dated 15/7/23. Then that 7 lakhs rupees, if the seat is not available to her, should be deducted from the monthly maintenance was the order. Because there was a delay in approaching to the college with 7 lakhs rupees, we lost that seat. Therefore, that 7 lakhs rupees is adjusted towards monthly maintenance. For the month of June, that 7 lakhs will be exhausted. Now, she is joining again CET for engineering. She will require at least 5 lakhs rupees to join the college. Now, keeping this, deferring this matter so far as the maintenance is concerned, and the main matter, let him pay 5 lakhs rupees to me towards the educational expenses of 2 children. Let the matter be posted next week. Final hearing, let him take 1 hour, I will take 1 hour, my lord. This is matter from 2009. Let the matter be disposed of. They don't have money even to buy rice today.
We said that maintenance amount goes up to June.
Up to June.
We are in May, so 1
No,
month.
the daughter has got lungs infection. Every day she has to buy medicine. And the doctor has to come to the house and treat the daughter. She cannot be taken. Sudden stroke hoditadu avalige. Because of that illness of the daughter, husband left the house. ನೀನ್ ಏನಾದ್ರು ಮಾಡ್ಕೋ ಆ ಮಗು ಸತ್ತೋಗ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇವಳನ್ನ ಬಿಟ್ಟಿದವನು. That is the reason. It has come in the evidence also, and he has admitted it. Yes, ಅಂತ ಅವ್ರು ಒಪ್ಪಿದ್ದಾರೆ. ಅವ್ರದ್ದು cross exam, which I will take.
We will decide the matter on merits.
No,
All these applications memos.
No, my submission is only this. No, my submission is.
We are here to adjudicate the matter.
No.
Not to run their family every day.
No, my lord, my submission is only this. There is an order by this honorable court now.
Correct, learned.
There-
See, if you argue the matter all together, main matter, we'll hear you.
No.
If you are not ready to argue, we'll record that and hear him and post.
I am ready to argue the matter, my lord. Now, your lordship may kindly
Now we
see.
recollect.
That is why. No, I'll come to the.
Wait, Mr. Counsel, he has. to
No,
argue.
my lord, may I submit, my lord. On 1/4/2024,
He
after.
can argue on referring to all those.
No,
orders.
that is my last argument now. Then let the matter go for final hearing. I'm convincing your lordship because from 2012, the initiation of the proceedings by the appellant, he went on concealing the fact regarding his income. This honorable court on 1/4/23 directed him to produce all the records.
Okay.
Now let him produce that record.
See, those applications, permanent element application is pending since 2020.
Yes,
We
sir.
have to decide it. I will consider
ಆಯ್ತು,
that.
ನಾನ್ ರೆಡಿ ಇದ್ದೀನಿ ಈಗ. ನನಗೀಗ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು
ನೀವ್ ಹೇಳ್ದಾಗೆ
ಅಲ್ಲ ಅವರು ಆ ರೆಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು. He has to comply the order dated 1/4/24. He has got that record with him.
affidavit consequences will follow.
ಅಲ್ಲ
You
ಅಲ್ಲ
have
It's ready, Miller.
You
It's
have
ready.
not filed the affidavit. Why have you not filed the affidavit?
Miller, I could not the objection, Miller. Last occasion, he wanted me to produce my salary certificate right from the year 2012. And to collect all that things, it took considerable
No,
time.
was
And it's
there any
ready.
order, direction to you produce all
On
the
the last date of hearing, the court is directed me.
last date of hearing?
Just before
1/4/24, my lord.
before vacation. there's
The
an order.
salary statements and all connected records shall be made available by the appellant. Office
Once.
1/4/2024, my lord.
Yes. Salary statements of the appellant from 2012 onwards will be made available before this court.
ಅವ್ರು ಈಗ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ
Office is directed to name the show the name of respond, delete the names of so and so. All right. Produce ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Yes, Miller, I'm having it. I'm
So this
producing.
order was passed on 1/4/2024.
1/4/24, my lord. The matter was posted again on 18/4/24. On that day, it was not ready. I submitted to this honorable.
ಆಯ್ತು, ಅವ್ರ ಫೈಲ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲ, ಇವಾಗ ಅವರು ಫೈಲ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ. I am also ready for argument. Let the matter not be urgent.
No, we will list it tomorrow. You file it in the registry. I'll verify ಆಗಿ ಬರ್ಬೇಕು. We
Yeah.
can't do it. You file it in the registry.
Yes, Miller.
Tomorrow or day after tomorrow, whenever you want, we will.
My only submission is this, my lord. Your lordship can orally direct him also. Let him out of 18 lakhs rupees that is due.
ಆರ್ಡರ್ ಮಾಡೋದಿಲ್ಲ.
ಅಲ್ಲ.
ಅವ್ರ ಫೈಲ್ ಮಾಡ್ಲಿ, ನಾಳೆನೆ ತಗೊಳ್ತೀವಿ ಬೇಕಂದ್ರೆ ಫೈನಲ್ ಇಯರಿಂಗ್. All these applications, memos, everything will consider.
Let him give the application. Otherwise, I cannot.
Let me-
I'll send you a copy. No,
ಅಲ್ಲ ಕಾಪಿ ಸಾರು
ಅದೇ
ಮಾಡ್ತೀನಿ.
copy ಇಲ್ಲೇ ಇದೆ. It's ready.
ತಗೊಳ್ಳಿ madam.
Learned counsel for the appellant submits that
ಇತ್ತೀಚೆಗೆ ಸೈನ್ ಮಾಡಿ.
another secured 1/4/2022. ಅಲ್ಲ ಫೈಲೇ ಇಷ್ಟು ದೊಡ್ಡದಾಗಿದೆ. He has collected the records for production in compliance with order dated 1/4/2024 and he
Copy
submits. He seek to submit the same in the court. He shall submit the same in the registry. ಆಯ್ತು, ನಾಳೆನೇ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀವಿ ಬೇಕಂದ್ರೆ. ಲಿಸ್ಟ್
ನಾಳೆ ಇದು ಬರೋದಿಲ್ಲ, ಇದಾಗ ನಾಡಿದ್ದು ಬರ್ಲಿ.
ನಿಮಗೆ ಇಬ್ಬರಿಗೂ ಹೇಳ್ತೀವಿ.
ಅಲ್ಲ ನಾಳೆ.
Both of you are not interested.
No, I am ready. Now only I am ready. ನನಗೆ ಇದು ಬೇಕಿತ್ತು, ಇದು ಬಂದ್ಬಿಡ್ತು.
ಅಲ್ಲ ಬರೀ ದಿನ see, courts are not here to run your family every day.
My lord,
We are here to adjudicate the-
there is a order by this honorable court.
Or comply with it.
There is a violation of the order of this honorable.
Sir, common.
Unless I approach your lordship, where can I go?
Correct, ನೀವು ಮಾಡಿ ಎಲ್ಲಾನು ಸೇರಿ.
ನಾಡಿದ್ದು
Day after tomorrow Thursday ಆಗುತ್ತಾ?
Thursday.
ಆಫ್ಟರ್ನೂನ್ ಇದೇನೋ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇದೆ ಅಂತೆ. ಅವತ್ತು ಹಾಗಾದ್ರೆ soon after the final hearing ಬರುತ್ತಲ್ಲ, ಫಸ್ಟ್ ಮ್ಯಾಟ್ ಹಾಕ್ಸಿ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಮತ್ತೆ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಅಂದ್ರೆ
ಬೇಡ.
ಆಫ್ಟರ್ನೂನ್ ದೇರ್ ಇಸ್ ಅ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಅಂತೆ, ಬೇಗ ಬಂದು 2:30 ಅಂತ ಮಾಡ್ತೀವಿ. ಹಾಗೆ
2:30.
ಫರ್ದರ್ ಹೇಳಿ ಯಾವುದು? ಥರ್ಸ್ಡೇ ಲಿಸ್ಟ್ ಮಾಡಂತ ಹೇಳಿದ್ರಲ್ಲ, ಥರ್ಸ್ಡೇ ಆಫ್ಟರ್ನೂನ್ ನಮಗೆ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಯಾವ್ದೋ ಪಾರ್ಟರ್ಡ್ ಮ್ಯಾಟ್ರ್. ಆಯ್ತು, ಮಾರ್ನಿಂಗ್ ಯಾವ್ದು
ಮಾರ್ನಿಂಗ್
ರೀಚ್ ಆದಾಗ ತಗೋತೀವಿ.
ಪ್ಲೀಸ್
Day after tomorrow.
Day after tomorrow. Thursday.
You file it immediately.
Yes.
ಅದಕ್ಕೊಂದು ಇದು ಮಾಡೋದು ಬೇಡ.
ಇಲ್ಲ, court number 4, 6.
ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿ ಪುಟ್ ಅಪ್
I'll put up, I'll file it. I have another matter before court number 4, next matter there, therefore I came.
Public.
Number 43, 53,
ನಾಗರಾಜ್ ಯಾವ್ದು ರೆಡಿ ಇದಾರೆ? ನಾಗರಾಜ್ ರೆಡ್ಡಿ. ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ?
44 ready there.
51, my lords.
Which is your matter?
Serial number 51.
51, 44 ನಾವು ರೆಡಿ ಇದಾರಂತಲ್ಲ ಅವತ್ತು.
ಅಲ್ಲ, ನಂದಲ್ಲಿ client has taken back the file, my lords. I have
50?
issued notice 51.
I am for the respondent.
You have to issue notice and retire.
ಹೌದು, notice issue ಆಗ್ಬೇಕಾದ್ರೆ. He
ನೀವು
has taken back the file. I have issued notice. Once I get the acknowledgement, I will file memo for it.
ಆಯ್ತು, ಇದು ಅರ್ಜೆಂಟ್ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಮಾಡ್ತೀವಿ. You are for the
I am for
respondent.
respondent.
You are opposing. ಅಲ್ಲ, your petition was dismissed.
Petitioner.
ಹೋಗ್ಲಿ ಬಿಡಿ.
ನನ್ನ
ಏನಂತ
ಫೈಲೇ ಇಲ್ಲ, my lords. He has taken back the file.
You file the acknowledgement and
I'll file the acknowledgement.
at least then we can dismiss it. 51, urgent at the request of the appellant's counsel. Yes. 44. Ready ಇದ್ದಾರೆ.
Number 44,
Apply recovery petition execution case. ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
Case of acquittal, my lords. Offense under section 447,
ಇದು 44.
44.
ಓ, HCLC ಇದೆ ನಿಮಗೆ.
ಹೌದು.
Response 1 to 4, AC ಮಂಜುನಾಥ. Proceedings of 44. Complainants appeal.
Complainants appeal.
Whether they were appearing earlier.
Last, ಗೊತ್ತಿಲ್ಲ ಸುಮ್ಮನೆ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ನಾನು ಬಂದಿದ್ರೆ
ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಅಲ್ಲ, ಈಗ ಇರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಮತ್ತೆ we can't proceed in their absence.
ಹೌದು.
Again we have to issue warrant and ಏನ್ ಮಾಡೋದು ಈಗ?
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಸ್ವಾಮಿ, ನನ್ನ ಹೆಸರು ಕೂಡ ತೋರಿಸಿರ್ಲಿಲ್ಲ, ನಾನು ಬೆಳಗ್ಗೆನೆ ಮೂವ್ ಮಾಡಿ ಟೈಮ್ ತಗೊಂಡೆ, ಹಾಗಾಗಿ ಅವ್ರು ಬಂದಿದಾರಲ್ಲ
ಅಲ್ಲ, ಅವ್ರು ಬಂದಿರೋದು ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
ಗೊತ್ತಿಲ್ಲ ಅದು.
Whether he appears here regularly.
ಇದಾರೆ.
ಯಾರು? AC ಮಂಜುನಾಥ್ ಅಪಿಯರ್ ಆಗ್ತಿರ್ತಾರ?
ಗೊತ್ತಿಲ್ಲ ಸುಮ್ಮನೆ.
ಅಲ್ಲಿ ಫೋನ್ ನಂಬರ್ ಏನಾರು ಇದೆಯಾ? ಅದರ್ವೈಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಇಶ್ಯೂ ನೋಟಿಸ್, ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಇದೆ, ಫೋನ್ ಮಾಡಿ ನೋಡ್ತೀರಾ? What are the offenses?
447, 506, 307 and 324.
307 ಇದೆಯಾ?
307.
She is the victim.
ಹೌದು, ಅವ್ರ ಮಗ ಮತ್ತೆ ಈಕೆ ಇಬ್ರು. ಇಬ್ರು. PW1 and PW2 both.
Her evidence was disbelieved.
Yes, my lords, due to some discrepancies, my lords, and minor.
Busy ಬರ್ತಾ ಇದೆ ಅಂತ. ಏನ್ ಮಾಡೋದು? No representation. We'll record his absence. We'll also make a note that if he fails to appear, warrants will be issued.
Yes, ma'am.
Then. Counsel for respond number 1 to 4 absent. Appellant's counsel is ready for argument. Since this is an appeal against order of acquittal, the matter cannot be proceeded in the absence of response 1 to 4. If the counsel for response 1 to 4 fails to appear on the next hearing date, their presence has to be secured by issue of non-bailable warrants. List on. ಅಲ್ಲೆಲ್ಲ ಫೋನ್ ನಂಬರ್ ಇದೆ ಅಂತ ನೋಡಿ ತಗೊಂಡು ನೀವು ಬೇಕಾದ್ರೆ ಹೇಳಿ.
ನಾನು ಮಾಡ್ತೀನಿ ಸರ್.
6 next week. 6.
6. Please.
ಭಂಡಾರಿ ಅವರು ಯಾವ ಕೇಸಲ್ಲಿ ಇದ್ದಾರೆ? Any of you are waiting? Which matter?
Your lordship, serial number 49, madam.
40, I am waiting for 46, your lordship.
46.
46.
Who is your opponent?
Lalita A.
Lalita A. Your opponent is not here.
Adali, your lordship, I have filed one IA, that has to be first allowed, your lordship. That is IA for amendment of the prayer, additional prayer by way of the insertion of additional prayer for permanent alimony.
You have not filed any application before the trial court?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಡೈವರ್ಸ್ಗೆ ಅವರು ಹಸ್ಬೆಂಡ್ ಹಾಕಿದ ಪಿಟಿಷನ್.
Correct.
Desertion and cruelty. Desertion is proved, cruelty is not proved.
No, appeal is by wife.
Appeal is filed by wife now. I made an application for alternatively to grant the permanent alimony.
Only desertion ground is allowed.
Yes. Cruelty is not proved.
Your application is?
Desertion for 9 months ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 9 ತಿಂಗಳಿಂದ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡೆಸರ್ಷನ್ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ.
ಬಟ್ ಇದ್ರಲ್ಲಿ ಬರೋದಿಲ್ವಲ್ರಿ? ಅಮೆಂಡ್ಮೆಂಟ್ ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲೂ ಅಮೆಂಡ್ ಮಾಡೋದಕ್ಕೆ ಕೇಳಿದೀರಾ? ಇಲ್ಲ.
ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲ, ಪ್ರೇಯರ್.
Now just now we are reading section 25. You have to file an application supported by an affidavit in terms of that Rajneesh versus Neha. Not this application. You got the point.
You please, your lordship.
Then you file separate application under section 25.
The affidavit I had filed, your lordship. Then
that affidavit in that format you have to file affidavit.
please.
That application is mandatory.
So there should not be any delay.
No representation for the respondent. Learned counsel for the appellant seeks adjournment on the ground that he on the ground for filing an application under section 25 of the
25.
List on ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
2 weeks, your lordship. Party has come from 10 days.
List after 10 days.
Before that I can file, your lordship.
2012 MC ಕೇಸ್ ಆಯ್ತು.
ಹೌದು. ಅಲ್ಲಿ ಒಂದು ಮೇಂಟೆನೆನ್ಸ್ ಹಾಕಿದ್ರೆ ಮೇಂಟೆನೆನ್ಸ್ ಅಲ್ಲೂ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಬರ್ದವರೆಲ್ಲ ರಿಟೈರ್ ಆಗ್ತೀವಿ ಆಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದವರು. ಅಷ್ಟು ದೂರ
ಇಲ್ಲ ನಮಗೇನಿಲ್ಲ, ನಮಗೆ ಅಟ್ ಲೀಸ್ಟ್ ಪರ್ಮನೆಂಟ್ ಎಲಿಮೆಂಟ್ ಸಿಕ್ಕಿದ್ರೆ ಏನು ಇಲ್ಲ.
If you want permanent alimony, file an application under section 25 in terms of the judgment of the Supreme Court.
Please, Your Lordship.
ಇದ್ರೊಳಗೆ ಮತ್ತೆ
ಆಯ್ತು ಸರ್. within a week or 10 days, Your Lordship, I'll file.
10 days ಬಿಟ್ಟು this was 6. Call 6.
6. Oblige, Your Lordship.
44 ಆಯ್ತಲ್ಲ
43 ಒಂದು
43 ಯಾರಿದ್ದಾರೆ? ಕರ್ಸಿ
43 ಸೆಲ್ ನಂಬರ್ 43 SPP
ಫ್ರಂಟ್ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ. ಯಾಕೆ SPP ಅವರು ರಿಟೈರ್ ಆಗ್ಬಿಟ್ರ? ನೋಡಿ ಅದರಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಅಪೀಲ್ ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ಚೇಂಬರಿಗೆ ಬಂದಿದ್ರು ಅವರು. No representation for the exam madam. 307 IPC. Oh, 307 ಅಂದ್ರೆ 324 ಗೆ ಕನ್ವಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. 307 ಗೆ ಮಾಡಿಲ್ಲ. ಇದು what discuss ಮಾಡಿ. ಅವ್ರಿಗೆ ಹೇಳಿ SPP repeat paid warrant this is an appeal against order of acquittal. He is convicted for 324 instead of 4. PO Act apply ಮಾಡಿದ್ದಾರೆ. Sheet was filed 307. This is an appeal and acquittal. This is an appeal or acquittal ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ. This is an appeal against conviction of the accused for the lesser offense than the one charge sheeted in the absence of the accused. I'm sorry, the respondent accused though served is unrepresented. In his absence, the matter cannot be proceeded. Therefore, issue non-bailable warrant against respondent accused. If he is arrested in execution of the warrant, he shall be produced before the trial court. And the trial court shall remand him to the judicial custody till further order of this court. Please on 4 weeks with
27/6.
ಹೀಗೆ ಹೆಚ್ಚು 27/6.
Cell number 44, 45 adjourned. Cell number 46 adjourned. Cell number 47.
ಬಟ್ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅವರು ವೇಟ್ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ ಯಾರು ವಿಚ್ ಮ್ಯಾಟರ್
Serial number 49, madam.
49.
Please, I appeal for respondent number 1 and 2.
49. G&W.
House. Really, Your Lordship, kindly see the order dated 4/3/2024, my lord. Now ward become attend, major, my lord. Now it become infructuous, my lord. In the last occasion.
Infructuous.
Please, my lord. In the order it has mentioned, my lord. 4/3/2024 order. May kindly see.
4/3/2024.
Please, my lord.
Respond number 2 and minor. Earlier case. Respond 2 and minor not measure present execution of the rule in the presence of the secretary. That is information to be applicant and to do with the matters of technically the ward is warrant 23.6. And in another 19 days, she is going to do majority along with the main matters. ಇದು ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ಕೇಸ್ ಇದು
ಇಲ್ಲ parents, his father has filed the petition.
No, respondents are the grandparents.
Respondents are the grandparents and mother, my lord.
Grandmother and mother.
How mother and
Abdul, Like petitioner is Muhammad Arif Khan. How he was related to the girl?
He is the father of the girl.
This respond number one.
He is the mother of the child.
Child.
Wife and
Oh, second marriage, ado.
our
Daughter of the girl.
he had second marriage, my lord. She is not.
She has not undergone second marriage.
She is also gone under second marriage, but child was residing with grandmother, my lord.
And this Nasira Khanum is a grandmother.
Please, my lord.
Now the child is with a grandmother.
No, mother also is came back, my lord. She is with mother, my lord.
Last time ಇಲ್ಲಿ ಕರ್ಸಿದ್ರು.
ಹೌದು ಅವ್ರು ಬಂದಿರಲಿಲ್ಲ, ಮದರ್ ಬಂದಿರಲಿಲ್ಲ, ಅವ್ರು ಸೂದಿನಲ್ಲಿ ಇದ್ರು, ಹೀಗಾಗಿ
ಅಲ್ಲ ಯಾರೋ ಸೋದರ ಮಾವ ಬಂದಿದ್ರು.
ಸೋದರ ಮಾವ, ಹೌದು
ಹೊರಗೆ ಕಳಿಸಿದ್ವಿ ನಾವು.
ಹೌದು ಹೌದು ಸೇಮ್ ಮ್ಯಾಟರ್.
You represent respondent number 1 and 2.
1 and 2, madam.
Sorry. Adin birth certificate hakidra on what basis we say?
It is admitted, my lord. In the petition itself said, my lord, it is it's admitted back.
One petition was filed by him.
One petition filed by the mother, my lord. That has been not challenged, my lord. My mother petition was allowed and husband petition was dismissed, my lord. Without challenging the petition filed by the mother, they have challenged the dismissal petition.
This petition is filed by, this appeal is filed by the father, challenging the order granting custody of the daughter. No? Appointing.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. ಹೀಸ್ ಚಾಲೆಂಜ್ ಓನ್ಲಿ ಹೌದು 2 GMWC 2 of 2011 is filed by husband, my lord. GMWC 4 of 2014
for his appointment alva 2 of 2011.
ಹೌದು ಅದನ್ನ ನಂದು 4 of 14 ಅಲೌಡ್ ಆಗಿದೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಡಿಸ್ಮಿಸಲ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಕಾಮನ್ ಆರ್ಡರ್ ಅಲ್ವಾ?
ಕಾಮನ್ ಆರ್ಡರ್ ಆದ್ರೂ ಪ್ರೇಯರ್ ಇಸ್ ಇಟ್ ಸೆಲ್ಫ್, my lord.
ಒಂದು ಸೆಕೆಂಡ್ ಏನಂತ ಒಂದು ಅಂದ್ರೆ ಈ ಅಪೀಲ್ ಪ್ರೇಯರ್ ನಲ್ಲಿ ಬರೀ ಒಂದನ್ನ ಮಾತ್ರ ಕೇಳಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾನು ಇದು ಮೇಂಟೆನೆನ್ಸ್ ಆಗಲ್ಲ ಅಂತ.
Custodian challenging the order appointing the mother, that is respondent number 2, respondent number 1 as a guardian, and rejecting his application for his appointment as a guardian. Okay. As per the both parties admitted that the ward is born on 24/3/2006. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಈಗ?
18 years ಆಯ್ತು. 18 years and
28/5/2024 2006. So she attained majority on
26/3. ಹೌದು
24/3 and 23/3.
23/3/2024
2024 ಗೆ ಆಗಿದ್ದಾರೆ.
ಹೌದು.
ಏನಂತ ಬಂದ್ರೆ okay, admittedly 24/3/2006. Therefore now she has attained majority. Therefore now she has attained majority. Therefore this appeal does not survive and disposed of accordingly. ಆಯ್ತು, ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ವಿ. Does not survive in fact does not survive for further consideration. ಅದನ್ನು ಒಂದು ಬರೆದು ಬಿಡಿ ಅಷ್ಟೇನೆ. ಅದಕ್ಕಿಂತ ಮೊದಲು does not survive. In the previous session, child declined to meet the appellant in view of the child attaining majority. This appeal does not survive for further consideration and disposed of accordingly. Okay, yes, ನಿಮ್ದು ಯಾವುದು? Serial number 55. You are for respondent. ಎಲ್ಲಿ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಅನ್ನ? ಅವ್ರು ಯಾಕ್ರಿ ಇಬ್ಬಿಬ್ರು ಇದ್ದಾರೆ, ಒಬ್ರು ಬಂದಿಲ್ಲ ಮಧ್ಯಾಹ್ನ. ಹೇಗೆ ಬರಕೋದು ಅಲ್ಲ ಇವಾಗ ಯು ಆರ್ ರೆಡಿ
R2 madam.
Huh?
R2 madam.
ವೆರಿ ರೆಡಿ ಲಕ್ಷ್ಮೀ ದೇವಿ ಆರ್ ಫಾರ್ ಹೈಕೋರ್ಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ R1 ಇಲ್ಲ learned SCP and counsel correspondent number 1 are absent and Sedgen it ಪಾಪ ವೇಟ್ ಮಾಡ್ತೀವಿ ನೀವು ರೆಡಿ ಆಗಿದ್ರಾ
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸ್ವಲ್ಪ ಇದೆ ಮೇಡಮ್ ಇನ್ನ ಕೊಟ್ಟಿಲ್ಲ
ಇನ್ನ ಸಿಕ್ಕಿಲ್ವಾ ಆಯ್ತು ಉಳಿದಿದ್ವೆಲ್ಲ ಕರ್ಸಿ ಇಲ್ಲಾಂದ್ರೆ ರಿಪೀಟ್ ಮಾಡಿ
Repeat ಮಾಡಿ.
ಅದರ್ ಮ್ಯಾಟರ್ಸ್
47 ಉಳಿದಿದ್ದೆಲ್ಲ ಮಾಡ್ತೀನಿ 50, 52, 53, 56, 56 to 61.
ಈಗ ಎಷ್ಟಿದೆಯೋ ಅಷ್ಟೇ ಹಾಕ್ಸಿ ಯಾಕಂದ್ರೆ ಫೈನಲ್ ಇದೆ ನಾಳೆ ಇವ್ರಿಗೆ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇದೆ ನಾಡ್ದನು ಮತ್ತೆ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಹಾಕ್ಸಿ